When I first moved here, before I became a...
You're all set?
I was a librarian. And I was a librarian in this program. And I was police cat.
Okay.
So I used to go to the house.
Members of the board, are you ready?
Oh, yeah, sorry.
Okay. Good morning. My name is Kerry Horvath. I'm the attorney for the Blue Island Municipal Officers Electoral Board. This morning we are reconvening the evidentiary hearing before this board with respect to the objections to the nomination papers of Domingo F. Vargas, candidate for mayor of the city of Blue Island, in case number 2020 BIMOEB-02. If I may, if we could have a roll call of the board members. Mr. Kelly?
Here.
Judy, I keep drawing a computer. Here, and he is operating the facility, the instruments with respect to the Zoom and YouTube. And there are two members of the public present as well. Before we move,
Your colleague's name again is Franco?
John Franco.
John Franco.
Correct.
And the last, what is it?
JOYC.
Thank you.
That's my hair.
Looks like it's right out of law.
Sure.
It looks like, did you just
That's
graduate?
right in around here.
Italian and Irish.
would you mind spelling that for me, please?
First name John Franco, JOHNFRANCO. Last name JOYCE.
JOYTE?
JOYCE.
See, that is an interesting first name. I've never heard it before. It's unique. Okay, before we begin the proceedings, I will read into the record the COVID-19 pandemic statement. Please be advised that on, I believe it's February 6th of 2021, the governor of the state of Illinois issued his latest statewide disaster proclamation related to continuing public health emergency posed by the COVID-19 pandemic, and has further issued executive orders implementing further enhanced mitigation measures and restrictions. As such, pursuant to Section 7E of the Illinois Open Meetings Act, the rules of procedure for this board, and as attorney for the board, it's been determined that holding a meeting entirely in person that is otherwise conducted in full compliance with the Open Meetings Act is neither practical nor prudent because of the ongoing disaster. To the extent necessary, this meeting will be conducted with the option to participate via internet teleconference and without requiring the physical presence of a quorum. Although we do have a physical presence of the quorum of the board today, they're all three present. It's further found that due to the disaster, the physical presence of more than 10 people at the meeting location in an accessible, hygienic, and legally compliant manner is not feasible. Alternative arrangements have been made to allow the public to contemporaneously hear all discussion, testimony, and roll call votes via Zoom teleconference. All votes shall be conducted by roll call vote and a verbatim. On
In that regard, I have a question. I mean, it seems that this matter's been remanded. The sole issue of what was raised at the last hearing, the request to call an expert on a different date rather than the date the hearing was set for. But in reading Judge Karkula's order, it mentions reversal.
yes,
So
Now
I
I'm-
hopefully it's not too broad. I'd ask the attorneys what their view of that is.
but
You were there.
yes, he did. He basically reversed the decision of the board and remanded it for this proceeding to hear evidence with respect to the objectors' objection concerning the various challenges they made with respect to the nomination conditions of the legal process.
Okay, I didn't get did you send copies of the order?
Yes, I thought I did send it.
I received a copy of it in email.
Yeah, I emailed all three of you yesterday.
Okay, I didn't get it. I copied everything that you sent.
But I don't have a copy of it with me, but on February 9th, Judge Karkula did issue that order. And if you want to make a motion to accept that order into the record at this point in time, someone would make that motion.
Also move.
Motion by Mr. Kelly, second.
Second,
Second by Ms. Coleman. Roll call, Mr. Kelly?
Aye.
Ms. Coleman?
aye.
Mr. Petrucci? Aye. Let the record show that the Judge Karkula's order of February 9th, 2021 has been entered into the record, and I will resend a copy of it to all three members of the board. Any other preliminary matters from the board?
Yeah, do we have a copy of our decision? I just want to,
Yes.
thank you.
You need a copy of the decision?
Thanks.
Anything else? Attorneys for the parties, any preliminary matters?
None. I do have one witness that may be a rebuttal witness. Bond is here. Mike, it's okay, she stays here. Or do you want to recuse her? Oh, no. You're going to use her for purposes of just in case. Yeah.
You,
No, she can.
Mr. Lazinski, you had presented a motion yesterday. You had filed a motion, which I submitted to the board.
I filed an objection to the candidate testifying. Mr. Casper sent me a text message indicating that the objector will not be calling Mayor Marcus as a witness.
Is that correct, Mr. Casper?
That's good.
Okay, then there's no need then for this board to rule on that particular objection.
Okay, so just for procedural, do you want to withdraw that objection?
I just would put it in the record.
Just put it in the record? Okay, and then we're not gonna rule on it. Okay, just to make that plain, because it's going back up on appeal.
If you let the record show that yesterday, Mr. Lazinski filed on behalf of the candidate an objection to the objectors calling candidate Vargas as a witness. The parties have apparently agreed that the objectors will not call Mr. Vargas as a witness. And Mr. Lazinski has just asked that this particular motion be filed as part of the record in this proceeding. Is it acceptable that that just be filed as part of the record?
Yeah.
Somebody make a motion to that effect.
I'll make a motion that be filed as part of the record and the board will make no ruling on the objection.
Is there a second? Motion by member Coleman, second by member Bertucci. Roll call. Mr. Kelly?
Aye.
Ms. Coleman?
Aye.
Judge Bertucci? Show that the motion filed or the objection to the objectors calling candidate as a witness has been placed up as into the record, and there will be no ruling on it as. Any other preliminary matters? Yes, sure, maybe. Give me a second here. Oh, sure. Just got to wait, get the glasses. No, we don't get a bottle of water, do we? I 13. I 13.
I didn't come.
I think I have 13 of those. And my expert is
It just says,
okay. I need a
No, I saw it yesterday.
it doesn't say just to be late.
Yeah,
An email, I can't.
yeah. I have it.
I don't know if we should do this on the record or not, but just as an understanding, Judge Corpula's order said that our decision was reversed. Does that mean the whole decision is reversed? Or just the rule part as to
Rule
relate?
eight.
If anybody can explain that, maybe we should go on the record.
Well, my understanding, and again, I wasn't here for the first proceeding, but my understanding is the result of whatever rulings you made was that the objector's petition was overruled. And the judge reversed that decision
Okay,
and remanded to conduct this evidentiary hearing.
okay, so,
So that's, so I don't think,
what he essentially did was just to overrule
everything,
or reverse our decision to overrule the objection.
okay,
Allow for evidence to be presented.
okay.
I think we're at a position where you have to have the record exam results read back into the
I
record.
think that was where I
Yeah.
was going to start. I don't know if that's, if you have accepted the records exam results. If not, we need to do that. That's probably where we should start.
Thank you.
So did they take the records exam results?
I believe
We
they
did.
did.
You did.
We did.
It's in our order.
Yeah, do you have an extra copy of our order? No, I need one.
Oh, what?
A copy of our order, our original decision. Our original decision that was.
Oh, sure.
Thank you.
Still on page 2, paragraph 8. And about the middle,
I just had the decision in my hand.
the records examination was completed and the electoral board adopted and incorporated by reference to results of the record examination conducted by the office of the town clerk and accepted set results. We did.
Yes, we did. We did accept into the record the report from the county clerk. The results were read into the record. They are listed in paragraph 8 of the decision.
Thank you.
They were also included in the record of proceedings without the signature clips, which is the way it's supposed to be presented. And so if you want to readapt them, we certainly can, but they are part of the record already.
I'm not sure that we have to readopt them. I think we just need to take them into consideration and then hear the evidence as to whether we're gonna accept them as
Yes,
or not, so,
whether you're going to accept the determination of the clerk or
right,
overrule the
overrule it.
determination on a case, signature by signature
Sure.
basis. That's how we're going to proceed.
Right.
Is
They
the,
are already part of the record. So if you want to reintroduce them, sir.
and are the ones with the signature clips in the record? Because you're gonna need those to make the determination.
No, they're not.
Well, we should do that.
If
I believe that's the problem.
If you're gonna look at the signatures, it should be in evidence.
you have copies of the signature clips and you have counsel, you both have copies of the clerk's record with the signature clips, correct?
Correct.
Because they both signed confidentiality agreements. Members of the board, you should have copies as well.
Okay, so we can either,
They're,
Tab-
they're, in the documents I gave you, they're number 5, the petition summary report. Signature clips.
so we can either admit them into evidence as the board exhibit, or if one of the, if the objector.
I believe the traditional path is the board
Why
adopts
don't
them.
we make it a board exhibit?
Okay.
Would one of you make a motion to accept into the record as board evidence the petition summary report, petition page report, and petition detail report, board copy with the signature clips as presented by the Cook County Clerk?
I so move.
And that,
Motion by member Kelly,
a second, just because
second by member Coleman.
the notation that it would be exhibit 9 according to.
Yes,
Thank you.
roll call.
Aye.
Mr. Kelly, aye.
Aye.
Aye. Let the record show that petition summary report, petition page report, and petition detail report board copy with the signature clips has been moved and admitted into evidence as board exhibit number 9.
The reference to 5 is simply that it was in tab 5 of what you gave.
Yes, yes.
Okay, very good.
Yes, a copy of that specific exhibit is in tab 5 of the documents that I gave to you in the binder. Anything else from the board at this point in time? Council, any other preliminary matters?
None
No.
for me.
And just to verify, that your expert witness will be available at 1 o'clock?
His
Correct.
expert will be available at 1 and will be testifying by Zoom.
Okay.
Thank you for accommodating.
Pardon?
Thank you for accommodating him. By the way, his wife is very ill.
Do you have
Ready?
anything to present at this time before you present your expert?
Yeah, I have, before we begin with the expert, I have 13 affidavits that I intend to introduce into evidence. They've been shared with Mr. Ladizinski pursuant to paragraph 13 of the objector's petition. Paragraph 13 of the objector's petition alleges that certain signers of Mr. Vargas's nomination papers, that their signatures should be invalid because they had previously signed the nomination papers of a different candidate for the same office. That rule is contained in section 10-3 of the election code and has been specifically adopted by the Illinois Appellate Court a number of times, beginning with a case called Watkins versus Burke back in the 1980s. And so that those signatures are identified specifically in the appendix recapitulation that is attached to the objector's petition. And that's Exhibit A to the objector's petition. The first such line is where that objection appears is on page 2 of the appendix recapitulation, line 5, in column F. So those are, that's where you'll be able to identify that.
Mr. Casper, are you referring to the original objection or to the Rule 8?
The objector's petition, the original objector's petition.
So it's in tab 3.
That's in tab 3 of the documents that
With any luck, the pages I've been given are numeric order. That would make my life a lot easier, so we'll see. The first one of those is on page 8, line 10.
Say page 8.
Page
Sheet 8 as well or not?
Yeah, okay, petition sheet 8, line number 10. So you'll see corresponding on the appendix recapitulation for sheet 8, line 10, there's an X in the box, column F, signer previously signed.
And it says so for 9 as well. But
Yeah, but right, and I'm only gonna talk about the ones where I have evidence to support that.
Gotcha.
So the first one I mentioned on page 2, there is an allegation that that person previously signed on page 2, line 5, but I don't have any evidence. You know, I assume that what happened was they identified the cross pollination running to substantiate, which came from the store, couldn't find the person to sign an affidavit, or they wanted to sign it. So the first one is sheet 8, line 10, and Mr. Joseph Leja, L-E-J-A. Sheet 8, line 10 of Mr. Vargas' petition. And in the affidavit, easier. Steve, you have a copy?
I have a copy, as long as you just tell me what the exhibit number is going to be,
Okay, yeah.
because it's listed as a group exhibit 1.
Yeah, I'm happy to label them individually, or I can put them in as a group, whatever.
I'm going to, just for clarity, because I'm going to have objections to each one of these individually.
And why don't we'll do each one separately so that we have a clean record.
Okay.
For what might be a review, okay? Is that okay with the board?
Yes.
Okay. So for the.
I'm smiling because, yes, I object to a review of anything we do. But otherwise, yes.
Okay, I just,
What is that?
These are the affidavits.
Yes, those affidavits were served by Mr. Erdman.
Yes, correct.
2 days ago, I believe it was.
I have more photocopies.
If you have a set that I can look at, I'd appreciate it. I do have it. Thank you very much. Thank you.
I'll mark this petition or this affidavit as objector number 1. This is, like, as I said, it's an affidavit from Mr. On line 10 of the nominating of the United Blue Party, under the case of Watkins versus the court has adopted the person voter signed 2 different.
Could you please sit at your mic instead of standing?
Oh, sorry. In Watkins versus Burke, the appellate court applied a rule that says when a petition signer signs the petition of more than one candidate for the same office, the first signature in time is valid and any subsequent signatures are invalid. That decision in Watkins has been affirmed on 2 other occasions by the appellate court in a case called Rosenzweig, Rosensweig, I think. And so objectors, 1, would support that theory.
just so I don't get confused. You didn't go back to 2, but there's, are you saying you don't have any evidence for, line 9 on sheet 8?
Correct.
And where would you like to you give it to me?
Well, could we
I'll
see it?
circulate it to the board.
Okay.
And these are all substantial.
So
That's you. Objectors exhibit number 1, which consists of 3 pages. David, a copy of the Island United Party, and a copy of Mr. Barnes.
okay, on behalf of the candidate, I'd like to object to the admission of this exhibit.
I'm sorry. Can't hear you.
I'm talking right up to it.
Then it's me.
In the packet I gave.
Hello.
Exhibit number 1.
Yes.
Each of the affidavits and copies of the respective petitions that.
Carrie, we're gonna need you to sit at your mic as well.
Recording, send it. Members of the board, just so you're aware, the respective exhibit is under the tab 7 in the documents I presented to you. These were filed by the objector 2 days ago in accordance with our rules. And I'm going to presume that Mr. Casper is going to present them in the order listed. That's hopefully, so hopefully, so you'll be able to review these in that packet as well.
Thank you. Very well organized. I'm going to tender this back to you. But there was an objection.
Yes, I have an objection. First of all, the section 10-3 applies to independent candidates, and this affidavit is provided for a independent signing and a party signing. So I do not believe that the rule under the Watkins case or Rosenzweig case would prohibit someone signing the petition. Likewise, I have an objection to the affidavit because the affidavits are clearly not attached. The exhibits are not attached to the affidavit under Supreme Court Rule 191. When you do have something that's an exhibit, it must be properly attached with incorporation language. But more importantly, the Rule 8 motion of the objectors, this objection was not preserved for appeal. And I'm looking at the chart that was provided, and item number 29 is 8-9, and then item 30 is 9-1. 8-10 is not listed at all on that. So the objectors did not preserve their right to bring this to the board.
Members of the board, with respect to that last comment, Mr. Matuszynski made, that is correct. It was this particular objection for this person was not reserved in the Rule 8 motion. The Rule 8 motion is in tab 6 of the documents that presented. And in the Rule 8 motion, there is an exhibit to that motion. I'll wait for you if you want to get to it. And there are 5 particular objections where this type of objection was preserved. And those were at sheet 4, line 7, sheet 6, line 1, sheet 8, line 9, sheet 16, line 6, and sheet 20, line 1. But this particular objection for this individual was not preserved in the Rule 8. I'm just pointing that out to you.
Okay, so my question is though, most of the Rule 8 goes to what the Cook County Clerk
Can I respond?
decided.
I'm sorry.
Do you want to respond?
I do.
Okay.
Yeah.
Then I'll-
Yeah, the objection is not well taken. The reason for that is these are set forth in the objector's petition, these factual allegations. There are other factual allegations contained in the objector's petition. The person's not a registered voter. The signatures doesn't match the one on file. The address is not in the district, etc. Right? Those are traditional records exam issues. The county clerk knows those things. They know whether or not you're registered to vote. They know whether or not your address is in the district. They can compare the signatures. They have no idea whether or not this person signed another candidate's petition. How can they possibly enter a ruling on that I need to preserve? There is no.
What I'm
Wait,
pointing out,
can I finish?
Sure,
Would
yeah.
you extend me the courtesy of letting me
I
finish?
understand you were correct. I thought you were finished.
Okay. But the notion that you have to preserve a ruling that is not made at the records examination is preposterous. And therefore, the objection should not be granted. It should be.
So that was going to be my comment, that a Rule 8 goes to,
Well-
my experience, Rule 8 goes to what the Cook County Clerk has determined is a good signature, not a good signature, residents, not residents, et cetera. They don't take into consideration signing 2 different
And
petitions.
all I was pointing out was what Mr. Ladizinski said was correct. In the rule, I read the Rule 8 motion, and in the Rule 8 motion, it said further, although not subject to Rule 8, objectors requested an evidentiary hearing on those objections appearing in column F of the appendix recapitulation of the objector's petition, as those objections were not subject to records examination because the pertinent material for said objections are not part of the county clerk's records. And then they said specifically, those signatures are identified in Exhibit A with an F in the applicable column. Exhibit A referring to Exhibit A to the Rule 8 motion. So what I was pointing out to this board, so you're aware, is that what Mr. Ladizinski said in his last comment, or last part of his objection, was in fact true concerning the fact that this particular affidavit with respect to this individual was not listed as an individual in the attachment to the Rule 8 motion as having signed 2 petitions.
So.
I'm just
we're
pointing that out
following-
as your attorney. Yeah.
Right, so we're following Mr. Casper's argument that, hey, we couldn't have preserved it in terms of what the board did at the election.
The clerk.
Right, the clerk did, because that's not, in their parameters or jurisdictions on. But Mr. Ladizinski's indicating, or confirmed, that it wasn't otherwise raised or preserved in the Rule 8, even though, there's a catch-all phrase in there. So what about that?
Yeah, the references to those having an X in column F in Appendix A. That's to the objector's petition.
And in the actual objector's petition, yes, but I'm talking about in the Rule 8, which is what Mr. Ladizinski said. All I'm saying is,
I'm saying we don't need to preserve them in the Rule 8 motion because the purpose of Rule 8 is to preserve rulings that are made by the county clerk.
All right, in that regard, in their Rule 8, did they name other individuals besides Mr. Leah?
Did they name others besides?
Yeah. That on the same basis, that they signed other,
Yes, they named 5 people,
okay, so
but not Mr. Leah.
you follow that? Mr.
Yeah.
Casper?
Okay.
All right.
Let me see.
They
My,
named-
my feeling is, I'm not gonna wanna have to come running back here because we didn't. Yeah, my feeling is I don't wanna be having to come back here after it's appealed one way or the other because we didn't accept one affidavit because it wasn't, it's not, doesn't pertain to the Rule 8.
Okay, I just wanted,
That's a
but I
good
wanted to
point.
point out to you what,
Sure. And I appreciate that. I just wanted to know though, how many were specifically put into your Rule 8, even though, the clerk doesn't look at it, and I appreciate
I
it.
believe the confusion is that what's in the Rule 8 are signatures where we allege that the signer signed this other party first. Okay. But we also allege that the address is not in Blue Island or they're not registered. So we preserved them in Rule 8 for that purpose. Right. And then so there's an overlap of both. But I certainly am taking the position that I don't need to preserve these dual signature ones in my Rule 8 motion because they're not ruled on in the records.
I think the more relevant argument here is the 10-3, according to signing an independent and signing a slate. I mean, that's the more
Two parties.
Right.
and
What about that?
versus whether it's in the Rule 8 or not.
Oh, there's
It's
certainly
not
a corresponding. See, this Article 10 of the election relates to nonpartisan new parties and independent candidates. And Article 10 relates to political party candidates. And this notion that you can't sign for more than one candidate appears in the political party article as well. So it applies to parties and independents. The theory is that you shouldn't be permitted, you can only sign for one candidate. You can only endorse one candidate when it comes to parties and per election. That's what it stands for. So whether or not it's 2 independents or an independent and a new party makes no substantive difference under either Watkins or Rosenzweig or any of these other cases.
Under the theory of those cases?
Yeah, the theory of those cases, sure,
Right.
is that
But we
you
don't
get
have a case.
you get to play on one side.
Right.
And the theory behind that is it's to stop the nomination of a third candidate to weaken your opponent. That's what it's designed to do. And Citizens for John W. Moore, the federal 7th Circuit said, it's what is in the vernacular called party rigging. The Republicans should be able to nominate a weak candidate in the Democratic Party, in the Democratic Party. And so that's what the theory of the law is. Same thing that goes here, that this United Blue Island Party, whoever they are, shouldn't be able to nominate a weak candidate to try and dilute the vote of Mr. Barker. That's why you can oversign. And it applies in equal force. I mean, why that matters, other than it's a clever way for Mr. Pazinski to distinguish them, but it has no practical difference.
I will also point out under rule, with regard to the issue regarding Rule 191, none of these exhibits are attached to these affidavits.
Yeah, I'm sorry, I meant to say, Mr. Ladizinski doesn't have the benefit of the originals. They were clearly, there's indentations in the originals where they were attached and they were separated so that they could be equal. So you can certainly examine them. They're clear, obvious paperclip marks.
Well, that doesn't mean attached. Okay,
How am I supposed to send paperclips through the computer?
I anticipated that. That's why I have a witness here to testify about my affidavits that are stapled. In addition, these affidavits don't provide specific facts. It says, I signed this one first, I signed this one. It doesn't give you a date. It doesn't give you a range. It doesn't give you any background on the signing. Mr. Casper and I are going to disagree about 10-3. But if you take a look at the affidavit, there's nothing from the affiant giving you a point in time.
Well, it does say it was signed on the same date in the affidavit.
Same date?
It says, I signed the United Blue Island nomination petition. Oh, I'm sorry, I misread it.
No, it refers to the
Yes,
April
yes,
6th
yes,
election.
Well, that gets to the weight of the affidavit, not to its essence. Number one.
But he does say in paragraph 4
Oh,
what
it
he
gets
signed
to-
first.
It gets to the weight of the affidavit rather than its admissibility. And from our perspective, there's only one operative fact. Which one came first? Doesn't matter whether it was a day before, 10 days before, or I guess the most it could be is 90.
Any other argument? Okay, members of the board, with respect to this particular affidavit and the documents that Mr. Casper indicates were part of the affidavit, or somehow attached to the affidavit, it is up to you to make a motion either to accept the affidavit as evidence or reject it as evidence. If you accept it as evidence, then you have to determine if you are going to accept the objection or overrule it. So first, will someone make a motion whether to accept or reject the affidavit as evidence?
I'll make a motion to accept the affidavit as evidence.
Second. Motion by Ms. Coleman, second by Judge Bertucci. Roll call, please. Ms. Coleman,
Yes.
Mr. Bertucci.
Aye.
So the affidavit with the two petitions attached or part of the exhibit are accepted into evidence. Is there a motion to accept the objection or grant the objection?
Yeah.
or- I'm sorry.
May I interrupt?
Sure.
And if I'll just make this suggestion, if you don't want to make a ruling on these now and you prefer some briefing on the law, I'm happy to provide.
Well, I
Well,
would,
go on. So,
I would like to look at 10 dash before I make
Okay.
a determination whether as to the weight of the evidence, I would like to look at the.
so we have two issues. One, you're saying there isn't a case that has someone signing an independent and a party. The only cases out there are party. And Mr. Kessler's saying, hey, by analogy, I mean, it's the same thing.
I think there's cases independent and independent. You see that in
Watkins
this-
versus Burke
is
is two
in-
independent.
Sure.
And the other two
Are party cases.
Watkins
Right.
versus Burke is a Democratic Board committeeman. That's under 7.
Oh, I thought it was an Alderman.
It's Alderman Burke was running for committeeman in the 14th Ward.
Okay, well then it's two party. Then it's a party. I thought it was two independent, but it certainly applies in aldermanic.
But we just don't have a case where it's independent and party. It's
So-
independent or party.
I'm not aware of an appellate case that says.
This will be the, correct me if I'm wrong, will this be the argument, counsel, with respect not just to this particular affidavit and the attachments, but you said you had 13, Mr. Kessler?
Correct.
With respect to all 13?
Yeah, they're all substantial.
So if the board would like some briefing on it, certainly it'd be very beneficial to everybody before you make a ruling.
So maybe we should just take all the affidavits and determine whether we're gonna accept them or not, and then maybe we could, since we do have a break, to look at the.
I think that's probably, that would allow us to at least streamline this portion of it, although we have some time.
Yeah.
Right.
Certainly, if councils, I'm not going to tell you how to put your case on, but if you want to do it that way, we can. You can introduce each one of these as objectors 1, objectors 2.
That's what I intend.
Right down the line. We'll circulate it to the board so they can review. And then if you want to add any arguments, you're certainly free to do so. But we will ask you both to provide us with a written.
And then the second thing raised, aside from the law, is the weight to give it.
Yes.
And it's going to be the same on all of them. They're all going to say, I signed the other one first.
Correct.
And Mr. Lazinski saying, well, if there's no other meeting there, they're not telling us when or anything like that, and they're not here to talk about it. Okay,
If that's acceptable to the board, then certainly. So why don't we let them present? Sure. And then we'll do an appropriate motion after Mr. Casper makes his presentation. That way it'll go smoother. Is that okay with you, sir? Mr. Ladizinski?
Yeah, it's fine. There are a couple other.
Yeah, as well. Thank you.
The next is objectors 2, which relate to sheet 9, line 5, a Mark Tellis, Telles. Try to stay here. Who indicates that he previously signed the Moving Blue Island Forward Party, which is a different party than the last one. Petition prior to signing.
Board, I'll tender the original objectors to.
With regard to the process, I'll have the same objection to this affidavit.
So that would be a objection.
Just want to make sure they're allowed here.
Only
And just for the record, when Mr. Casper is referring to the sheet line, you're referring to the sheet line on the petitions, or excuse me, the specific petition for Mr. Vargas.
Correct.
Yes.
Correct. I figure that's the easiest way for everybody.
Yeah, okay, that's,
To keep track. And then I'll just adopt the same response that I made, Mr. Ledizinski's objection. The third one is objectors 3, relates to sheet 11, line 10 of Mr. Vargas' petition.
wait, 1 minute. Do we want to, instead of accept them individually, if we or not accept it?
I think I'll present them and I'll make a motion that you adopt objectors exhibits 1 through 13.
that's fine.
Okay. I'm just,
Unless you have.
There's gonna be a couple specific ones where they were sustained for other reasons.
Oh,
okay.
Is an affidavit from Darlene Washington Metcalf, sheet 11, line 10 of Mr. Vargas' petition, indicating that she had previously signed the nominating petition for the United Blue Island Party. Sheet 15.
thank you. Sheet 11, line 10, right? Members of the board, tendering objective number 3, which is the affidavit and the 2 petition sheets.
Line 10, Mike.
Yeah, see, they're out of order. Now
Yeah.
I'm gonna go. Sheet 11, 8, and 9 are now.
Now you change my order. Okay. I would also interject one other objection for all these affidavits. If you take a look at column F, I don't believe that the objection has specific reference to what other candidate was signed for. It just says signed another candidate. It doesn't say for an office or anything.
I think when Mr. Casper makes his motion again to introduce these into evidence, you can then summarize your arguments one time for all of the objections. If you have specific objections as we move along, you certainly can raise them, but that way we'll cover everything.
That's fine. All right. Okay. So this is number 4.
You're on number 4, yes.
Objectors 4, I'm going to go back a little bit. Sheet 11, line 8 is an affidavit of Deborah Burks indicating that prior to signing Mr. Vargas' petition, she signed the United Blue Island Party petition, sheet 19, line 7.
Mike, did you misread that? Is it sheet 11, line 8?
Yes.
Sheet 11, line 8.
Okay.
I'm sorry if I misspoke.
Objector Exhibit 4.
Everyone ready?
You know, you're presenting these, to us. We also have a copy that you provided.
You have copies of these.
Yeah.
But these are, you know, exhibits that'll be on this. Thank you.
Right, Objectors 5 is sheet 11, line 9, Margaret Wright, WRIGHT, who indicates that she signed for the United Blue Island Party, sheet 7, line 10, prior to signing Mr. Vargas' petition. Is Objector 6, Barry E. Ward Jr., sheet 20, line 1. Indicates that he had previously signed the petition to the United Blue Island Party, sheet 2, line 9. Objector 7, and I don't apologize for this, is sheet 4, line 4. Peggy Jorgensen, Jorgensen, sheet 4, line 4, who indicates she signed the Moving Blue Island Forward Party,
sheet 37, line 1, before she signed Mr. Vargas.
Number 6, members of the
37, line 1. Objectors 8, objectors 8 is Kathy Gardner, Gardner, sheet 18, line 6, who indicates that she signed for the United Blue Island Party, sheet 109, line 7, prior to signing Mr. Vargas.
Thank you.
It's coming up right now.
This one,
310. It was sustained on registration,
310.
and no objection was made based on column F.
I'm sorry, what was that?
Exhibit, this would be exhibit number 9 that he's about to mark.
You're on 9 now, right? Yes.
Yeah, the next one I submit will be 9.
Signature. You're going to skip it.
Yeah, I didn't object.
Wait. Sheet 3, line 10?
Yeah, I submitted in the disclosure an affidavit for sheet 3, line 10.
Javier Leal?
I'm sorry, yes, correct. Javier Leal, Leal. But Mr. Ladazinski's objection that it was not, that signature was not objected to on this basis is well taken. Therefore, I will not.
So that you're withdrawing them?
Yes.
Wait, pardon, could you say that again?
Mr. Ladazinski's objection that we did not object to the signature on the basis that the signer had previously signed.
Oh, in the original objection.
Yes.
Okay, so you're withdrawing.
Well, I'm just not going to
You're
submit
gonna not
that.
submit it
No.
as number 9?
No,
Right, correct.
okay, no,
So the
no.
next one will be number 9.
Okay, yeah, all right.
Okay, thank you.
Sheet 17, line 6.
Sierra, right?
Yes. Sheet 17, line 6 is Rosalia, Rosalia, Sierra, Sierra, who indicates that she signed the United Blue Island Party petition, sheet 123, line 4, prior to signing Mr. Vargas' petition at sheet 17, line 6. Objectors number 9.
Thank you.
Objectors 10. 10 is sheet 17, line 7. Porfirio Sierra, Porfirria. Last name Sierra. Sheet 17, line 7, who indicates that he signed the United Blue Island Party's nomination papers, sheet 123, line 5, prior to signing Mr. Vargas. Objectors 12. Sheet 10, line 4. Salvador Castillo, Castillo, sheet 10, line 4, indicating that he signed the nominating petition of the United Blue Island Party, sheet 60, line 6, prior to signing the nomination paper of Mr. Vargas, sheet 10, line.
Mike, what was that exhibit number? Exhibit number.
Mr. Ward, you probably have your 11 and 6, 11 and
You can just call me Mitch. I don't object to you.
That concludes the affidavits on that.
you've submitted 12 altogether.
Correct.
And you withdrew 1.
Correct.
Okay.
I don't believe I have anything further to present until 1 o'clock.
Members of the board, do you have any questions of Mr. Casper at this point?
Demonstrative 1 o'clock that I just shared with Mr. Lizinski. I'm sorry, it just got put together yesterday. That may be helpful to the board if there's any objections. I just took the signature clip from the petition summary report and I overlaid it with the petition so that you can look at one piece of paper for the signatures when the expert testifies. It's certainly not evidence, it's just a demonstrative that the expert used in making his calculations. It's helpful to look at it that way, or you can flip back and forth between a bunch of pages, whatever.
If it's helpful to the board and it's not being introduced, I think that, Mr. Anderson will show us, and then I'll turn it over to the board.
This is something, everything that you're looking at is in the record already. It's just a more convenient way.
The only inquiry I have of this is, did the expert put this together or did you put this together? Okay, and are these all the signatures he's going after?
No, this is the entire universe from the Rule 8 motion.
Okay, so I would ask, so we could streamline this and I could figure out what I need to do. Which signatures have you identified that you seek to challenge this afternoon with the handwriting expert?
Okay,
I think that.
If that makes sense?
sure. And this may change somewhat.
Okay.
I don't want to limit myself to what he can testify to.
No, it would help me
Yeah.
to get ready.
Sure. All right. The signatures that the expert has identified so far, the last time I talked to him, which was last night, that he will testify regarding are as follows.
Are you going to go off of the Rule 8 now?
Yes.
Okay.
Sheet 2, line 9. Sorry, is everybody ready? And what you need is the attachment to the Rule 8, this document.
The Rule 8 should be under tab 6.
You're asking us to look at this document right here.
Right, correct. So the expert, again, I'm not limiting myself to what he might testify to. So far, is identified sheet 2, line 9.
Number 7. Can you just say?
Oh, the item number?
Yeah. that's
7.
easier.
Thank you.
20, 23, 26, 28, 46,
46.
46,
Wait,
48, 54, 55, 60.
Do you have I only, my rule is at 64.
Yeah, it says
Yeah.
60.
That's it. That's what ours.
Yeah.
60. Oh, 54. 60.
54,
54.
I
55,
thought he said 64.
No,
No.
54, 55,
60.
60, and 62.
I thought you said 65.
Oh, no.
A total of 11 so far.
I think it's 12.
Okay.
Maybe not. Yeah, 11, right. And potentially 53. He was still conducting.
63 as well.
53. 5.
53.
So that's for the expert.
Correct.
So just to repeat that, it would be right now, 7, these are item numbers, 7, 20, 23, 26, 27, excuse me, 28, 46, 48, 53, 54, 55, 60, and 62. Right.
No, may I ask? I know the parties didn't make opening remarks, but you have an expert that's challenging 11, maybe 12, and possibly more. That's as of last night. You have these affidavits. I mean, ultimately, where do the numbers lie? You know, if you're successful on the points you raise.
That's a good question. Very good. Question I'm not sure I'm quite ready to answer yet. because the reason for that,
And I asked both sides. but
yeah,
go on.
the reason for that is Mr. Ladizinski has rebuttal evidence.
Right.
I don't know what.
Right.
That is. I believe that if the evidence is accepted, the objector's evidence, and I haven't figured out this affidavit here that was omitted, puts the candidate below somewhere in the neighborhood of 12 signatures.
Well, I think before we hold him to it,
Absolutely.
it should just be verified and counted. Yeah. I don't think we should hold him to that number. When we get all the evidence, then we can add it up.
Yeah, no, I just wondered if we have a break, it makes it easier for me to identify which ones I have to address.
Well, unless you want to talk for an hour and a half. we gotta break.
Yeah, what,
Mr. Casper,
He's been known to do that.
No, Mike, I have not. I've gotten better with brevity.
the evidence that you presented, we have one copy here. Do you have any copies, or I can probably get some copies made pretty quickly?
Yeah, if we could get another copy. I brought 2 copies.
Yeah, we'll need each
I'll
one of
have
us.
some made for the board and myself, and I'll have. Do you,
Yeah, so
do you
get-
have a copy, Mr.
Mr.
Ladizinski?
Ladizinski,
I have a copy.
All right, so
So
we'll make.
we probably need 4 more copies.
Randy, can we get copies, please?
Mike,
Here we go.
Actually, you know who did it was Diane Mark. She did it.
Oh.
So I said, "Our guys, just do this."
Yeah.
How they do it,
They can
yeah, I was gonna say, I couldn't see you doing
No
this.
way.
just write them.
That's
so,
why I give him the-
Get out of
Get out of science class. Come here.
Yeah.
Yes.
We now have the 12 objectors and exhibits
We have to
to introduce. I think you just make a summary. The board members, but I think you can summarize his objectives.
Sure. I would.
Make a motion to accept it into evidence,
Right.
subject to.
You grab your microphone, Carrie.
So, Mr. Casper, if you'd be kind enough.
I would move the admission of objectors exhibits 1 through 12 into evidence. In regards to Mr. Ladizinski's comment that they were not sufficiently identified in the column where it said signer previously signed for another candidate in the appendix recapitulation, I would point the board's attention to the text of the objector's petition, paragraph 13, which specifically says the nomination papers contain the names of persons who signed another candidate's nomination papers prior to signing candidate Vargas's nomination papers for the same office. And so I believe that covers it. And then it goes on to specifically adopt the column section. So, I think that the lack of words on the appendix sheet is just a convenience. There's only so much space. So I think we've adequately pledged the objection.
Mr. Casper, do you have anything else?
No.
Mr. Ladizinski?
Yeah, I'll start off with that. It doesn't identify which other candidate they signed. So it does not provide enough detail for the candidate to identify which other petitions you should be looking at. Once again, I'll go to 10.3. I do not believe it applies. This is the recap of the arguments. And that would be with regard to objectors exhibits 1 through 12. I disagree with Mr. Casper, and we're going to submit written submissions for the board to look at. I believe the affidavits are vague with regard to time. They also indicate that, the affidavits do not state that they reviewed exhibits A and B. Once again, that may go to wait for your consideration, that they actually reviewed each of these and affirmatively are offering their testimony as required under Illinois Supreme Court Rule 191.
Anything else? Mr. Ladizinski?
I have nothing else.
At this point in time, if the board would consider a motion to accept into evidence for your review to determine whether you are going to either overrule or sustain the specific objections with respect to each document that's been submitted. Would you make that motion?
Well, I guess I would just comment that question that they didn't identify what candidate they were voting for. I think all of the other petitions, other than the one for Vargas, was late. So it's really hard to identify which candidate they were signing for because it was a slate. Is that correct?
Correct.
All the other petitions that they said they signed first were slate. Am I correct?
That's correct.
All right, so
Yes, there were two other, I think, all the other petitions were either the Moving Blue Island Forward Party slate or the United.
right, so you don't individualize what candidate you're signing.
Well, I would move to accept the 12 exhibits in evidence. And we'll at some point discuss the weight of them. For their attention.
Second, we have a roll call. Mr. Kelly?
Aye.
Aye.
Mr. Bertucci?
Aye.
Let the record show that the exhibits 1 through 12 inclusive have been accepted into the evidence by the board, subject to its review to determine the weight and whether they will accept or reject the specific objections with respect to each affidavit. Very accurately stated?
Yes, and Jerry, we are going to be on break for some time, so the parties may want to present us case law as they kind of have an argument. I'm not telling you what to do, but think about discussing the weight we should give these. But I just want to pull this out there that what I noted, just for the parties to think about rather than me raise it later. And it's just a factor. It doesn't mean which one was signed first or anything like that. Each of the 12, the individuals say, I signed the other one first. I just wanted to know for the parties to think about during this break we have. Number 1, Joseph Leah, it was notarized. Doesn't mean it was signed any one day or the other, but each were notarized on November 30th. The other party's petition and Vargas's petition. You take the next 5, the other parties was notarized on 12/9, Vargas's 11/17, about 3 weeks earlier. The next one, 12/7 for the other party, notarized 11/16 for Vargas. Next one, 12/7, Vargas, 11/16. Finally, 12/7 for the other party, 11/16. When you take the next 7, the other parties were notarized in various dates in November, except the last one was December 7th, and Vargas's were notarized, later than that in December. Again, it doesn't mean one signed earlier or not, but it's a factor that I'm going to consider, I think, in part, and I just want to put it out there for others to consider or not, and maybe to think about in terms of your arguments. That's the only reason I mentioned that. And finally, I just want to say, we accept these exhibits, and I trust in discussing it openly and hearing from the parties, we'll give them the appropriate weight. I once had a matter where exhibits were admitted, and the attorney submitting them wanted them accepted since there were no counter affidavits. They just had to be accepted. I said, well, certainly they're going to be admitted. But if they say it hasn't snowed in Chicago in a month, and you're telling me that today, I'll accept that affidavit and it'll be in evidence, but I absolutely won't accept the facts in there. And I only pulled it out there because in that case, a lot of affidavits were given to the court, no live testimony. And the person all said, that was my signature on the petition 2 weeks ago. And I swear to you, every single one, and I know our signatures change during our lifetime, every single one, the signature on the affidavit saying I signed that petition was different than their signature on the petition. Significantly, every single one. It was amazing. So yeah, I accepted them, but doesn't mean I gave them the weight that, or the credibility that the opponent wanted me to. This is a totally different scenario, and the case is different. I just rolled it out there. We are going to have to assess, decide to give these. And there isn't a glaring problem like the one I just mentioned at all. But I wanted the parties to note that they're 2 to 3 weeks apart in notarization. That doesn't mean they were signed at any different time than the app being said, or any different order, but it's a factor to consider.
Thank you, Randy.
Do we want to hear, if there's nothing else right now, do we want to hear a motion to recess until 1 o'clock?
Yes.
Is there anything else that we
That's, before you recess, I'm going to distribute to you all a copy of the illustrative exhibit that Jasper was here.
Thank you. Thank you.
Some crap.
Okay, there's nothing we can accomplish. The witness will be here at 1. Is there anything we can accomplish before 1 in terms of these arguments or not?
You don't want to put on it.
I don't want to put anything onto your handwriting. That's what it's a stand.
We talked earlier, I'm sorry, we spoke earlier about you presenting some law for both sides with respect to the argument concerning the Watkins case, the Rosenzweig case, whereas independent to independent, party to party, and whether there's any significance to that. I know what Mr. Gasper's position is and what Mr. Blazinski's position is, but the board would probably like some case law to support that would be helpful to the board. If you have it now, fine. I think that's what you're driving at.
Sure, now or at 1, for example.
Yeah,
I don't know.
we could do
Whatever
something.
the
We could each throw something together before we want to talk.
If you, that would be very helpful, and that would allow us to move along too.
That's what I'm thinking.
Sure.
I don't know if we want to come back another day to hear.
You don't want to come back.
Well, we're going to have to come back another day, but another day to hear arguments on that issue. That's my mean. If we come back, we probably should come back for the decision,
Sure.
not any other arguments.
We can recess, and why don't we recess and come back at maybe 1:45, and maybe you can present us with something at that point.
So we need a motion to recess until 12:45. Second.
Roll call, please.
Aye.
Mr. Kelly. Ms. Coleman. Mr. Petrucci. Okay, let the record show we're recessed until 1:45. Thank you. Thank you.
Where does one go in Blue Island, or do I have to drive back into the city? Take lunch.
Randy, where's a good place for lunch?
I have a question for you. Are you going to appeal the main township?
Don't know. Depends on how you rule it.
Well, I was on that board.
I know.
I was
Yeah.
Sorry, usually it kick back at me.
Students never make up stories or alibis about not getting their homework in either. They always tell the truth.
Thank you very much, Ben.
Always like it after the final exam. Is there opportunity for extra credit? A little late for it.
It's after they get their grade or before they get their grade?
Yeah, the day you're about to submit your grades and call it a semester.
Oh, he is only 9.
What are you teaching then?
I got business law. I've also got a business survey class.
Is this the community college?
Wilbur Wright.
Oh, that's nice. That's in my district.
Yeah, sure.
He got
He was a guest speaker there all those years ago when we were young and healthy.
Yeah.
Actually-
Do you remember when that was?
I don't know. I got some photographs. I'll have to look them up for
A
you.
friend of mine teaches a film class there.
See myself with long hair.
Let's see. You came. Ed Jordan, who's now past, came.
Early high
and
school.
Lynch came, but Lynch was only a pitching wedge away. He didn't have far to travel. He's he's still on. He's still sitting.
Yeah. His son, Dan, is buddies with my kid. They went to State.
Yeah, he switched that around because he was a Loyola Academy student himself, but same order.
I used to go over there on Wednesday nights. Business class.
That's assuming that they.
Yeah, there's a film discussion class I would go to with Owen Field. And
Yes, that's
yeah.
my good friend. Yes.
Yeah, maybe we've been in a couple together, but he's trying to do it online and I never really got into it.
Yeah, it's a little, I haven't done it. I'll wait until he can do it. He's always been, you should see his music. I mean, his films, you should see his music collection.
I ran into him a couple times at the theater just by chance. We went in to see the same movie and they had that Orson Welles picture that had been in litigation for like 30 years and they had it one day at the Music Box. So we sat through it and went afterwards, oh, wow. It just blew my mind.
I went to law school with him. He was a few years ahead of me.
He grew up in Indiana or something?
Yes, on a farm.
Yeah. He still sends me an email every week. He reviews everything that's on cable.
Yeah, he does that. He, music,
His
I'm like,
1-year-old.
and also, and we're
sister,
both going to see
a
the
little bit.
Dracula picture.
I know,
Not the
I've been
center
to
of
the
attention
patio.
anymore.
Yeah.
You know.
I went to law, actually Myra was in my, I introduced them.
Oh, honestly, yeah.
Yes, I introduced them. It was a fix-up.
wonder, did we ever go out for drinks at the end of the semester? We went up to
Yes.
Galvin's Public
I
House.
always say,
Yeah,
wow, you're a
okay.
big brother now, or you're a big sister now, because.
Yeah, I really miss that, actually.
Are you gonna do it again once he sorts out?
Provided it doesn't interfere with the teaching schedule. There were a couple semesters I couldn't do it because I was in class with my students at the same hour, or, you know.
He also does, I think, Monday nights at Truman.
Truman,
which is
yeah.
closer to you, actually, where you live, right? Truman's not that far from you, is it?
Not too far, but I only did the courses at Wright because when I started, he wasn't doing Truman at that point. And actually, he started where he was a part of the class, and the
Yeah.
guy who was teaching the class gave it up, and Owen took it over.
Well, I mean, he started doing it when
Just
Wright
ask my
was still in
firstborn
the
Italian
old
male
Wright
brother.
building on,
Oh, yeah, it's a high school now on
I don't talk to
Austin.
him, so I won't be asking him. Yeah.
I come from a family of 7, and I'm a middle child, so that's why everybody says it.
Gotcha.
Try and get,
Uh,
I'm like, nah, they're 7, everybody.
just it's fine.
When he was in practice, did he work for the state of Illinois, or was he in the AG's office?
Yes, he was
or
head,
appellate
actually for a
defender?
while, he was head of the public health.
Oh,
He was general counsel. He started, well, actually started interning there when he was in law school.
yeah.
And he worked his way up to general counsel.
Who's that? Your
Owen Field is a, yeah.
We were in some adult ed classes where he would show movies, and then we'd have like 45 minutes of discussion after the picture was over, or something like that. And
Just wait for Mike. Steve, are you guys ready?
Yeah.
Scott, are you, when Mike gets back, will you guys be ready?
so as you see this playing out, we're going to have to return again for a decision date or something.
Or we could do that by Zoom too, if it's just. If it's
Oh,
just
yeah,
something
like we
that
did the
is-
last time, we held the pages up. Yeah,
Yeah.
yeah, okay.
Depends on how far we get to it.
Right, right.
How long do we want to go to? Yeah, but how long do we want to, when do we,
It's up to you. Whatever you all feel like, because you're the ones that
Would somebody please?
live for as long as you are.
been lunch and dinner at this point. So, no hurry. Because my eating alone.
I just don't say
I mean,
one thing, I would be older again
Yeah.
unless I like driving.
didn't
at
have
night.
anything.
Yeah.
I did it for so many years.
Here, let's see. I'm gonna send it to you.
It's
Oh,
not signed
so you
yet.
try to sign in?
Yeah.
I'm gonna send it to you one more time. You should have it now. At the bottom, there should be an attachment.
Okay, now you did spill it, see?
You have napkins there?
I got my hanky.
Here, I'll grab some.
That's par for the course for me. I mean, at least I spilled it on my
Actually,
stuff.
I didn't get the weekend. Owen should be sending it out, so. Doesn't he usually
Usually
send it
my
out?
coffee waits till there's a keyboard around.
Yeah, I was just thinking about that.
Yeah, that's good. No harm, no foul.
at the agenda. Open Meetings Act public notice. Agenda. There's only one. Yeah, the attachment, right.
Six and Cal, I used to zipper this, so I didn't bring it anything home. I have to leave it here, just reminded me. Shake your stuff out before you get in the car. I remember I had a jury in a box.
Smudge you.
Had a jury in a box in a murder case.
Okay.
And I, you know, it was always tell them, don't worry about interrupting if you have to use the bathroom or something, you know, but I'll take regular breaks. Well, at some point, there's a mouse that goes in front of the jury box. They can't see it, but I'm on the bench, I can see it. So I said, ladies and gentlemen, you know, I said you could take the bathroom if you need to. Well, I need to take, listen, we're gonna take a break. The sheriff will escort you. They go home, the sheriff catches up and kills the rat or mouse. Bring him back on. After the verdict, they always have him in chambers, thank them privately and give them certificates.
It's just a Zoom. On the attachment.
There's a mouse in front of the bench, I don't want to tell you.
There's a Zoom link. You can
We'll
click.
make sure you guys came back the next
It'll
day.
take you right there.
Yeah, that place is a dead.
Copy it and just send it in an email.
Here's what I'm gonna just copy it and send it to you. That's a good idea. No. All right, now I'm going to send it to you right now, and it's just a link to the Zoom. All you got to do is click on it, okay? There you go. Should have
I am ready for it. I am ready for that.
Oh, yeah.
I've never done that before. That's funny, but I did it once again after, you know.
You know, once it gets in, it's tough.
Yeah, yeah.
Like you said, we need a good appellate court decision. Who's codes, so we can use.
Ted Cruz and Heidi Cruz.
There's no bottled water here or something, is there?
What's that?
How stupid can you be?
I know.
You know,
I'm not a fan of Ted.
so.
I've texted some friends. I normally don't quote Trump, but I put, Ted, parentheses, ugly wife,
Oh,
father killed
Really?
Kennedy.
Thank you so much.
Parentheses,
I only have
Cruz.
one, sorry.
I appreciate it.
I mean, it's the Trump calls your wife ugly, says your dad's involved in. It's balls.
They have some enemies. They've got something hanging over them, just like.
Oh my God, here's another guy. Yeah, Lindsey Graham.
There is no.
You should be dialing in. Okay, great.
Super.
You got it? Everybody ready?
Ready? Ready?
Okay. Let the My name is Kerry Horvath. I'm the attorney for the Blue Island Municipal Officers Electoral Board. We are now reconvening the evidentiary hearing that we began this morning in BI 2020 BIMOEB-02. Solomon Esparza and Octavio Carbajal, petitioners, objectors, versus Domingo F. Vargas, respondent candidate. If we could get a motion to reopen the hearing.
I so move.
Motion
Second.
by Mr. Kelly, second by Mrs. Coleman, or Miss Coleman, excuse me. Roll call, please.
Aye.
Kelly, aye. Coleman,
Aye.
Bertucci.
Aye.
Record show by roll call vote, we are now reopening the hearing. When we reset, just prior to recessing, the board asked the parties if they could prepare some legal argument for them with respect to their positions that they had taken earlier this morning. Are we prepared to do that, Mr. Casper?
Yes, I filed a memorandum via email to you about 20 minutes,
Okay.
and I served a copy to Mr. Lazinski.
I'm going to forward, if it's okay, I'm going to forward it to the board. If I can, let's see. Record show I just forwarded by email to the members of the board. What I can read on my screen is a dual signing memo
Correct.
and a notice of filing that
Correct.
was presented by Mr. Casper by email to me at about 12:30 this afternoon.
I have it.
I got it.
Did you all receive it?
Well, I can't receive it here.
Do you have email up here?
No, I don't. That's at my desk.
Okay. Let me see if I can pull that up. All you gotta do is scroll. Up of it. The board wants to take a few minutes to do that. Mr. Lazinski, do you have a submission to make, or are you gonna just make?
I'm going to make an argument on it because I think we've talked about the cases already.
You need to enlarge it.
Yeah.
Enlarge it, you said that-
Yeah, I got you.
Able to do it,
Yeah.
okay.
Okay, thank you.
I just finished reading because Dan had my,
No, I was just gonna make a suggestion because we have the expert witness waiting. Should we have the expert witness testify first and then get back to the arguments? I mean, just as a courtesy. I mean, I don't know how anybody else feels about that.
That's fine with us. I agree. I don't think we should
Board,
keep,
how would you like to proceed? Because we can do it either way.
Do you have a preference?
No, I don't care. I don't know how long this will take, but we're gonna be here anyway. We might as well do the witness.
Right, to get him,
Yeah.
so he can leave
You okay with just proceeding with the expert and
Yeah.
and then going
come
back
back to
and,
this?
yeah. Because we're gonna have to hear.
Andy,
Scott, I found my
mics are
memo.
not working. It's like 1 o'clock. Okay. Okay, Steve. Mr. Casper, if you want to proceed with your witness,
Sure.
it's fine to go that way.
Sure. Just give us
Oh,
1
no,
minute.
take your time. Go ahead.
All right, thank you, Mr. Horvath, members of the board. We're prepared to proceed with our witness. But before we do that, I just wanted to make everyone aware, the time is now approximately 1:20, and around 2:15, I'm going to have to excuse myself, and Mr. Erdman will take over for us.
Okay.
One of the losses COVID has imposed on us is the lack of the after-school program. So I have to pick up my 12-year-old from school.
That's way more important.
Much to the consternation of the parents. The
And don't be late. Don't be late.
after-school program has been a fatality.
And you don't want to Zoom from your car?
I've done that.
I know,
I've done that. And no,
I may or may not have done that.
My days of doing that are long gone.
Right?
I may though. I may dial in. That's a good idea. Okay, Mr. Spencer, are you there?
I am.
Okay. All right. We'd like to call Warren Spencer as a witness. And even though you're there, could you give us your word? You're raising your hand to be sworn in by the court reporter.
Maureen, would you
Still
swear?
doing. Where's,
Where is
we're not
he?
gonna see him?
I don't know.
Does he have the video on?
Do you have the video on?
Thought I
Mr.
did.
Spencer?
What do I need to hit here? Start the video? That it?
Yeah, there you go. There he is. There's
There I am. Okay.
It's like Wolford Brimley.
Good afternoon.
All right.
You all see.
Can you see?
Please, would you mind swearing the witness? Oh,
You have your hand up, sir. Can
I do.
you-
I do.
She just asked you if you would swear to tell the truth, the whole
Sure.
truth, and nothing but the truth.
I do.
thank you, Mr. Spencer. Could you please state your name and spell your last name for the court reporter?
Warren Spencer. Last name is Spencer.
Mr. Spencer, what do you do for a living?
A forensic document examiner for LS Spencer and Associates, St. Charles, Illinois.
Okay, and how long have you been a forensic document examiner?
Started our practice in Illinois in 2006. Actually hung up the shingle in 2007.
Okay, and did you undergo any specific training to become a forensic document examiner?
Yes, I have.
And could you explain briefly what your educational and training background is?
Well, I did get a bachelor's of science at Iowa State University a number of years ago. Really has nothing to do with my being here, but I do have a degree. I did take training from Andrew Bradley, located in Denver, Colorado at that time. That was when we actually had a practice in Iowa, in my home state of Iowa. And Andrew Bradley provided a correspondence course in question document examination. There's a number of examiners across the country that started from Andrew Bradley's course.
Okay, and you said at the beginning that you were a certified document examiner. Who are you certified by?
Scientific Association of Forensic Examiners, currently located out of Boca Raton, Florida.
Okay, and I notice on your curriculum vitae, which everyone has a copy of, that you have given testimony in a number of court proceedings throughout your career. Is that correct?
Yes, it is.
Okay, and in each of those cases that's listed on your CV, were you giving expert testimony regarding handwriting analysis?
That's correct.
Okay, and have you done, and there's also a number of hearings, have you done any election matters similar to this one in your career?
Yes, I have.
And have you done any in the Chicago area?
Yes, I have.
Okay, and how, explain some of the cases that you've done regarding elections.
A number of years ago, I did one for Crystal Lake, where there had been concern about the names on the petitions, much like this one. And in that particular case, of course, that's Kane County, where I live. They had me go into the Kane County voter's office in the conference room, and I was asked to basically assist both sides. And if they couldn't agree whether the signature was appropriate, was genuine based on the voter registration card, then I broke the tie. And then I decided, if you will, whether it was a appropriate signature or not.
Okay, and have you testified in cases before the Chicago Board of Election Commissioners?
I believe that would be correct. In 2018, I testified a number of times in hearings dealing with various petitions that had been challenged.
Okay, and your CV also indicates that you testified in front of the Cook County Electoral Board a number of times. Is that true? Okay.
His answer.
Would you repeat your answer to that last question, please? The court reporter did not hear you.
I'm sorry, I was going to ask you if you could hear me okay.
Have you testified before the Cook County Electoral Board?
Yes, I did.
Okay, and did you do that in 2018?
That would be correct, yes.
Have you, when you testify in these election cases, are you usually retained by an attorney such as myself?
Yes.
Yeah. Have you been retained to testify in election cases by the law firm Odelson and Stirk?
The name sounds familiar, but I'm not certain of it.
All right. Are you familiar with the attorney named Ross Seckler?
I've been asked that earlier. I'm not sure. Let's see.
So can I direct your attention to page 2 of your CV?
Yes, I have. I just reviewing the CV, and you're correct. I have.
You have what?
I have testified on behalf of hearing officer Ross Seckler.
He's an attorney.
Correct. Yeah, you're right. Ross Seckler, attorney. That was in January of 2018.
So Ross Seckler would have been the lawyer who retained you?
That is true.
Okay. And are you aware that he's a lawyer at a law firm named Odelson and Sturp?
And not specifically, but I'm sure that is true.
Okay, all right, that's fine. And are you a member of any associations or groups regarding your profession?
Yes, I belong to the Scientific Association of Forensic Examiners, also the International Association of Document Examiners, and the National Association of Document Examiners.
All right, thank you, sir. I would move the witness.
I would like to conduct voir dire, if I may. I would like to question the witness with regard to his expertise. Mr. Spencer, from 1968 to 1987, what did you do?
1968 is when I graduated from Iowa State University in Ames. Was involved with a number of companies, mostly in material handling, mostly connected to Clark Equipment Company as an industrial equipment salesman.
So it has nothing to do with the examination of signatures, is that correct?
Absolutely true.
Now, your resume says you're a certified fraud examiner by the Association of Certified Fraud Examiners, correct?
Correct.
CFE is not in the area of handwriting analysis, correct?
It's true.
And it's not in the area of document examination, correct? Can you speak up, sir?
That is also true.
And the CFE is not in the area of forensic document examination, correct?
A certified fraud examiner is what you're referring to, yes.
That's correct, sir?
Yes, yes.
And with regard to document examiners and forensic document examiners, they're certified by the American Board of Forensic Document Examiners, correct?
Some are.
Okay. You are not, correct?
That's true.
And they're also certified by the American Society of Questioned Document Examiners, correct?
Some are.
And you are not, correct?
Correct.
And with regard to your certification that's listed, you simply went to a correspondence course and then paid for membership, correct?
Andrew Bradley that I mentioned to you before was done through correspondence through the mail,
Yes.
if that's your question.
Could you speak up, sir? With regard to your certification that appears on your CV, and one is from the Scientific Association of Forensic Examiners. That's a membership that you simply pay a membership fee to, correct?
You have to be invited. You have to be included in various things. We do seminars throughout the year, not every month, but most months. We do a 2-day conference every fall. I believe we're up to the 5th or 6th year of that now. I have attended all of them.
Okay, and it's not sitting for an examination, is that correct? For certification?
I did set examination in the
She's
past.
having trouble hearing them, and we are, is there something wrong with?
What do you suggest on the volume? Because you're breaking up at times.
Can you hear me?
Yes, I can.
Okay. You didn't sit in a controlled exam environment, correct?
Yes, yes.
And with regard to the memberships, you mentioned the National and International Association of Document Examiners. That's simply a membership that you pay a fee to, correct?
In case of National Association of Document Examiners, I belong to them since 2007. However, I've not been able to attend any of their conferences. It's just been bad timing. Haven't been able to leave the Chicago area to go to those. It's necessary to attend their conferences before you can be considered other than just a general member. However, I am active with them. I just have not been moved up to professional status with the National Association of Document Examiners.
With regard to all of the associations and groups listed on your curriculum vitae, it's fair to say that's the same, correct? You pay a membership fee to, and that's it, correct?
In the case of the other two groups, you are expected to be active in their various seminars, their conferences, that sort of thing. But they have also recognized me as a certified forensic document examiner, where National Association of Document Examiner has some different requirements, and that's why I'm just a general document examiner.
His voice is trailing off. You want to let him know, or I can. Mr. Spencer, your voice trails off a bit. Make sure you speak loudly in your computer.
Okay.
Thank you.
What I'm asking is, what do you want me to do different? Because usually I have no problem with volume.
What you're doing right now is perfect. So keep your voice up.
Okay.
With regard to the organizations that you have listed, have you ever been an officer in any of those organizations?
I have not.
Okay. And sir, with regard to your testimony, is it fair to say that you have been found unqualified to provide handwriting analysis in several cases?
Not to my knowledge, no.
You've never been found unqualified in the state of Wisconsin?
You're talking about Shanklin versus Shanklin. I was not sworn in, so that really doesn't count. Go ahead.
We need that answer again.
She does.
Can you repeat that answer, sir?
Yes. He's referring to Shanklin versus Shanklin. It was a number of years ago. It was a pro se. Two Shanklin brothers involved me. Just one of them was in the arbitration. However, I was not sworn in at the arbitration. I was allowed to give my opinion, my findings, and that sort of thing. And so if you want to refer to the one where I was not sworn in as being unqualified, that would be true.
Well, sir, you testified in a matter called Vahey versus Lisa Copeland, where I was an attorney and I questioned you on this, and you admitted that, in fact, you had not been qualified as a handwriting expert, correct?
I'm sure that was what I said, yes.
And sir, with regard to the election matters that you have done, what is your protocols to examine signature specimens versus the specimen that you're opining upon?
Your question referring specifically to election petition names, as in this case?
Correct.
Yes.
Well, sir, what's your protocol? What is the protocol for a certified handwriting expert with regard to examining signatures on an election petition when you're going to offer testimony that a signature is not genuine?
Again, you're talking specifically about the names on a petition for an election as we're dealing with in this case, correct?
That is correct.
Okay. So the protocol is to be able to study the handwriting pattern of the name that is being challenged and compare it to the voter registration card, which is on file. In this case, I believe it would be Cook County, and compare the handwriting pattern, any of the uniqueness that might be present in the various strokes and combination strokes to determine the genuine or not genuine nature.
Is it fair to say that all you're comparing is two exemplars, one on the petition and one on the signature clip, correct?
In most cases that I worked in 2018, that is true.
And with regard to this case, that's all you did. Look at a signature clip, and a petition sheet, correct?
Looking at the voter registration card signature that's on file, comparing it to the challenge name that's on the petition sheet.
Sir, you didn't physically look at the records maintained by the Cook County Clerk to examine the signature clips, correct?
I was not given the opportunity to look at the originals. That is correct.
And likewise, you did not look at the original petition sheets of the candidate in this manner, correct? And with regard in the field of document examiners and certified handwriting experts, you're required to look at the originals before offering an opinion, correct?
That is not true.
What?
That is not true.
Is it your testimony to this board that as an expert witness, when you're going to opine that a signature is not genuine, that you do not have to look at the original signature?
That is true.
Okay. Sir, have you testified in a case involving a mortgage fraud where you were found unqualified because you did not look at the original signature on the mortgage?
Not that I recall.
You don't recall testifying in a case in Shelby, Illinois, where you failed to follow the protocols related to examination of original signatures that were available before offering your testimony?
I don't recall that, but if you say so.
Well, sir, with regard to examining originals, would you not agree that the best practice is to look at the original signature rather than a photocopy, correct?
The original signature exists, and we have the opportunity to study it. That is my protocol, yes.
And with regard to the cases that you have testified before in election matters, have you not looked at the original signatures?
The ones in 2018 that I believe you're referring to, yes, I had the opportunity to look at the original.
And with regard to the other cases you testified that appear on your CV, you reviewed the original documents such as mortgages and promissory notes, correct?
In some cases, I had the opportunity to study and examine originals. In other cases, it was a copy.
And you agree, sir, with regard to copies, they get blurry through copying, through scanning, and other factors, correct?
Not necessarily.
Well, now, sir, with regard to the documents you reviewed in this matter, did you review any affidavits that are marked as candidates exhibits 1 through, I believe it's 37?
No,
I object to the question. What's the steps to do with his qualifications?
What's your question?
I object to the question. What's the relevance to his qualifications?
That last question?
Yeah.
Can you read it back?
Now, sir, with regard to the documents you were given to this matter, did you review any affidavits that are marked as candidates exhibit 1 through, I believe it's 37?
I'm prepared to rule on the objection, but defer to the chair.
I don't see, right now, I don't see the relevance. I would think that he would do it in cross-examination.
Would the board like to rule on that objection?
I would,
The objection to the question, I mean.
I would sustain that moment.
I'd take the opposite view, because you're talking about affidavits of the people whose signatures he's examined elsewhere.
Correct.
So I would overrule the objection, and unless I'm missing something, Mr. Casper.
I think we're just getting to the whether or not he's qualified to testify to an expert.
I see
As
your
an
point. I see your point.
I withdraw the question.
That's fine.
I withdraw the question. Okay.
Drawing the question, that's fine.
Mr. Spencer, would you agree that as a proposed expert witness, that you should look at available exemplars of the signatures that you will be testifying about?
Court, as I understand it, expects me to look at best evidence available. And that's what I was able to do.
Well, I'm asking you about the protocol, the best practices for the field that you claim you're certified in, is it not fair to say that if exemplars of the signatures you are reviewing are available, you should obtain all the exemplars that are available, correct?
Whenever possible, we certainly want to look at the best evidence available, which in some cases would be originals. In this case, it was not.
Well, I'm talking about if there's, right now you testified, you only reviewed 2 signatures, the ones that appear on the petition sheet and the one that appear in the signature clip in the records of the Cook County Clerk. Did you review any affidavits containing signatures of the signatures you're going to testify about today?
Objection. He just asked the question that he just withdrew. It's the same question. So I raise the same objection. Let's just get to the evidence.
Okay, so there's a question and an objection pending. I'll ask the board to rule on the objection. Judge Bertucci,
What was the question again?
would you repeat the question for the board, please, Madam Court Reporter?
Question, I'm talking about, right now, you testified you only reviewed 2 signatures. The ones that appear on the petition sheet and the ones that appear in the signature book and the records of the Cook County Clerk. Did you review any affidavits containing signatures of the signatures you are going to testify about?
I'll say 2 things. One, yes, it appears that's more of something, if he's, once he testifies, it goes to maybe the weight to give his testimony. On the other hand, perhaps it does go to his qualifications because, if there's certain practices to be followed and someone who's an expert is not doing that, are they an expert? So I'd allow the question on balance.
Okay, so,
I'd vote to overrule it. I'm one of 3, though.
okay.
I again say that that type of question could be dealt with on cross-examination.
Mr. Kelly?
I'm going to go along with Public Member Bertucci.
So the objection is overruled, but I think at some point you're getting into cross-examination on the fact issues as opposed to qualifications. And so if you can move along, we can allow the answer to the question, and then we're going to have to move to qualification questions, or let the board then determine whether they will accept the offer from council to accept this gentleman as an expert. Okay?
Okay.
Go ahead, Mr. Yes. Would you repeat the question for the witness so that he can then answer that last question? Do you understand where we're at, Mr. Spencer? The court reporter is going to repeat the last question that counsel asked you so you can answer it, okay?
Thank you.
Thank you.
I'm talking about, right now, you testified you only reviewed 2 signatures, the ones that appear on the petition sheets and the ones that appear in the signature clip in the records of the Cook County Clerk. Did you review any affidavits containing signatures of the signatures you are going to testify about today?
I did review the affidavits at the 11th hour, but I had already formed my opinion before the affidavits were made available to me.
Sir, with regard to the affidavits, would you acknowledge that a more current signature of a voter would be a more accurate depiction of that person's signature?
In some cases, in other cases not.
Pardon me, sir? I didn't hear you.
Said in some cases that would be true, in other cases it would not be.
In the field of test and handwriting analysis, have you ever heard of a sworn exemplar?
Yes.
And a sworn exemplar is a document in which a voter or a person signs something in front of someone under oath.
That's my understanding.
And in your field of study, you would agree that the sworn statement, the sworn document is the best evidence of the person's signature.
Not necessarily, but in some cases, yes.
Would you,
But in some cases it would.
I have nothing further. I do not believe that Mr. Spencer has established his qualifications as someone that's certified to provide handwriting analysis in this case.
Well, I assume that Mr. Horvath, your lawyer, would disagree because his firm has used him within the last 2 years for this very purpose.
I would,
I don't have to agree to anything at this point in time.
I would have the opinion that we would let him testify, and then I think the three of us are capable to determine the weight to be given to his testimony.
And members of the board, just so you are aware, I have no knowledge of whatever Mr. Spencer did with respect to Mr. Seckler, but if you want to make that, because there's an objection pending to the allowing Mr.
I'd make a motion to overrule the objection.
Okay. Is there a second to that? Well, I should say, you made it, you're moving to overrule, Mr.
I just want to ask the attorneys this, you're waiting for us to rule. I don't hear either side arguing. Your objection to him testify as an expert. Neither side's arguing. You just want us to rule?
Well, I mean, I'll make an argument if you want, a brief one.
I kind of do. I mean, I don't know, for example, if there are certain boards that make someone, I don't want to say truly an expert, or not. I've heard about these certifications. So.
Well, then I'll ask some redirect.
You certainly have the freedom to ask on redirect.
Mr. Spencer, you have testified before the Chicago Board of Election Commissioners in petition-related cases as an expert. Is that correct?
Yes, I have.
And the Cook County Electoral Board as an expert, correct?
Yeah.
And in Joliet, Illinois, as a expert for the Will County Electoral Board, right?
Yes.
Okay. Any electoral boards found you unqualified as an expert?
I know it.
All right, I have no more questions.
Okay. Any argument either way?
I've made my argument.
No, I think you understand.
Okay, well, we're trying to keep this is on qualifications of the expert.
Right.
The members of the board can now make their determination whether to sustain
Sure.
or overrule the objection.
And you, was there a motion to overrule the objection?
Yes.
And find him qualified as an
Made him
expert?
qualified, and we can, on our own, determine the way we want to give his analysis.
I'll second that motion.
Roll call, please. Mr. Kelly.
Aye,
And I would be to accept
the expert witness.
Overruling the
opinion
objection,
and-
accepting the
Overruling the
objection.
And I will vote in favor of that. Aye.
Aye.
Mrs.
Aye.
Coleman? All right, so the objection is overruled. Mr. Casper, you may now proceed.
Okay, thank you. Thank you, Mr. Horvath, members of the board. Probably the easiest thing for you to have here is the Rule 8 motion objection, the attachment to the Rule 8 motion, and that identifies the signatures that we're going to talk about. Mr. Spencer, we have provided the board with that demonstrative exhibit with the two signatures lined up side by side. Okay.
Sir, you have to speak into your microphone. I think you may be muted, or you have to speak louder, please.
Is it okay?
That's fine.
Okay, Mr. Spencer, have you had an opportunity to review the signature that appears on sheet 2, line 9 of the candidate's nominating petition? This is item number 7 on the Rule 8 motion attachment. Item number 7.
Sheet number 2.
Sheet number 2, line 9.
Mike, is he working, excuse me, Mr. Kent, is he working off of this demonstrative exhibit?
I don't know. I
Can
believe so.
you, Mr. Spencer, can you, for us, let us know, show us the document that you are looking at, that you have in front of you, that you're going to be asked questions about, so we know that we're all looking at the same document you are looking at.
Okay. How would you like me to do that?
You'll
Just
have-
hold it up.
Hold it up, sir.
Yeah, that's it.
Okay, okay.
Okay, we all have the same document.
I think
Well,
we
that's
have-
pretty
yes.
weird.
Says sheet 2 on the bottom.
Correct.
And for the record, just so we're all clear, the board received from Mr. Casper prior to our break an exhibit, a demonstrative exhibit, which has on it a copy of the petition page for candidate Vargas, the respective petition page for candidate Vargas, and then superimposed is a copy of the signature clip for the various signatures that are being objected to it in issue. Is that a fair
Yes.
summary, sir? Okay.
Yes.
I didn't mean to interrupt you.
No problem. No problem. Mr. Spencer, if you had an opportunity to review the signature that appears on sheet 2, line 9 of the candidate's petitions.
Yes, I have.
If you had an opportunity to compare that to the signature that appears on that individual's voter registration record,
Yes, I have.
have you formed an opinion as to whether or not the person who signed sheet 2, line 9 of the candidate's nominating petitions is the same person who signed the voter registration record?
Objection. That is, he does not have personal knowledge, and that's outside of his area of specialty. He's got to testify here today as to whether or not it's genuine, not that it's a forgery. The objection in the objector's petition is the signature is not genuine, not that someone else signed it.
That is correct. The objection is that the signature is not genuine, not that it was inserted by someone else.
Yeah, not the genuine signature of the voter
He's
who's.
just saying what he said is correct.
No, I understand that, but if it's two different signatures, then it's not. One is genuine and
So
one's
I
not.
understand, but I'm just, so.
I think we're getting, you know.
It says in the objector's petition, paragraph 8, and said signatures are not genuine and are forgeries.
How can this with
I was looking at the Rule 8.
Yeah, and I'm looking at the objector's petition where we allege that these signatures are not genuine and are forgeries.
I'm looking at the Rule 8. I'm not looking at the objector's petition at this point in time. We're here on the
Okay, well,
Rule
you can
8.
look at whatever you want. I'm just telling you what's included in the objector's petition.
the Rule 8 is what's preserved for this hearing.
Proving these allegations.
No, it says A means the signer's signature is not genuine, and or the signer's signature was printed and not written, and or the signer signed petition more than once.
That is correct. That's what's in the Rule 8, and that's what's preserved with respect to.
Well, what's the? I mean, this is getting into the realm of the absurd. What's the difference? If it's not genuine, that means it wasn't signed by the person who's the registered voter at that address. It's not their genuine signature.
Stated the objection, and
Yeah, and I'm arguing that the objection should be overruled because it's absurd.
then the board.
Well,
I'm gonna make a motion that it's overruled. Let's just get through the signature.
Yeah,
but
I don't want
there's
this kicked back.
I don't want to keep going around and round either, but I'm just saying that's.
I know the objection.
I want to make this is a very important legal point.
I understand.
When you're going to allege that it's a forgery, it's clear and convincing evidence versus not genuine, which means the signature doesn't match what the signature clip is, which is a preponderance of the evidence. So if Mr. Casper is going to go forward and say that, hey, this is clear and convincing evidence that these are forgeries, that's not what's alleged in the Rule 8.
So then it becomes as a matter of how they weigh the evidence that's presented. If I'm not mistaken, is what your argument is, Mr. Ledezinski, as opposed to whether it's admissible or not.
They didn't preserve the allegation of forgery.
I don't think.
Okay, I'll restate the question. Why don't you do
that?
All right.
Might be helpful.
Mr. Spencer, this is going back to sheet 2, line 9.
Correct.
Have you formed an opinion as to whether or not the signature that appears on sheet 2, line 9 is the genuine signature of the person whose registration record you compared it to?
What I'm prepared to say is that the handwriting pattern on the voter registration card, which you're calling a clip, is a different handwriting pattern than line 9 on sheet number 2 of Donald Marchanta. So if there's not the same handwriting pattern, we have two different writers, two different authors.
Okay, and what specifically did you look at in coming to that determination?
The voter registration card that was provided for me of this gentleman's name, the writing pattern that was presented, compared to the petition name that's being challenged on line 9 on sheet number 2.
Okay, and do you hold this opinion that they were two different writers, as you said, to a reasonable degree of professional certainty?
Yes.
Okay. The next one is item number 20, sheet 6, line 7. Have you had an opportunity to review the signature that appears on sheet 6, line 7?
Yes, I have.
And have you had an opportunity to review the corresponding voter registration signature to that signature?
Yes, I have.
Have you formed an opinion as to whether the signature on sheet 6, line 7 of the candidate's nominating petitions is the genuine signature of the person who signed the voter registration record?
Again, I refer to handwriting pattern on the voter registration card compared to line item 7 on sheet number 6 is a different handwriting pattern. Therefore, two different writers.
Okay, and have you formed the opinion that they were different writers to a reasonable degree of professional certainty?
Yes, I have.
Okay, next is item number 23, sheet 7, line 1. Have you had an opportunity to review the signature that appears on sheet 7, line 1?
Yes, I have.
Have you had an opportunity to review the corresponding voter registration record signature for that voter?
I have.
Have you formed an opinion as to whether the signature on sheet 7, line 1 of the candidate's nominating petitions is the genuine signature of the person who signed the voter registration record?
Handwriting pattern of Michelle Gonzalez from the voter registration card is a different pattern than line number 1 on sheet number 7 of the name Michelle Gonzalez.
Have you formed an opinion that the two signatures were signed by two different writers?
Yes, I have.
And do you hold that opinion to a reasonable degree of professional certainty?
Yes, I do.
Okay. And the next one is sheet 7, line 9. Have you had an opportunity to review the signature that appears on sheet 7, line 9?
Yes, I have.
Have you had an opportunity to compare that to the voter registration record that corresponds with the signature for sheet 7, line 9?
I have.
Have you formed an opinion as to whether the signature that appears on sheet 7, line 9 is the genuine signature of the person who signed the voter registration record?
Handwriting pattern of Gaston Ramos from the voter registration card is a different pattern than line number 9 on sheet number 7. Therefore, we have two different writers.
And do you hold the opinion that the two signatures were signed by two different writers, to use your word, to a reasonable degree of professional certainty? I'm sorry, could you repeat that answer?
Yes, I do.
Thank you. Next is item number 28, sheet 8, line 8. Have you had an opportunity to review the signature that appears on sheet 8, line 8?
Yes, I have.
And have you had an opportunity to review the corresponding voter registration record for sheet 8, line 8?
Yes, I have.
Have you formed an opinion as to whether or not the signature on sheet 8, line 8 is the genuine signature of the person who signed the voter registration record corresponding with that signature?
I have.
And what is that opinion?
Opinion is that the writing pattern of Jose Hernandez on the voter registration card is a different writing pattern than the challenged signature on line 8 on sheet number 8 of the petition.
Could you repeat what you said after sheet 8, line 8? That it's. Here, I'll ask it.
Go ahead, please.
You remember what you said after sheet 8, line 8?
As I said, that the handwriting pattern of the voter registration card is different than that of the name Jose Hernandez found on sheet 8, line 8.
Have you formed an opinion as to whether or not the signature on sheet 8, line 8 was signed by a different writer than the person who signed the voter registration record?
I have.
And what is that opinion?
We have two different writers.
Do you hold that opinion to a reasonable degree of professional certainty?
Yes, I do.
Next is item number 46, sheet 13, line 6. Have you had an opportunity to review the signature that appears on sheet 13, line 6?
Yes, I have.
Have you had an opportunity to review the corresponding voter registration record for that signature?
I have.
Have you formed an opinion as to whether the signature on sheet 13, line 6 is the genuine signature of the person who signed that corresponding voter registration record?
Yes, I have.
What is that opinion?
Opinion is that the voter registration card writing pattern of Kenneth Morsalis is a different writing pattern than that of sheet number 13, line number 6.
Have you formed an opinion as to whether the person who signed sheet 13, line 6 is a different writer than the person who signed the voter registration record?
Yes, I have.
What is that opinion?
We have two different writers.
Do you hold that opinion to a reasonable degree of professional certainty?
I do.
Okay, next is item number 48, sheet 16, line 2.
Okay.
Have you had an opportunity to review the signature that appears on sheet 16, line 2?
Yes, I have.
Have you had an opportunity to review the corresponding voter registration record for that signature?
Yes, I have.
Have you formed an opinion as to whether or not the person who, the signature that appears on sheet 16, line 2 is the genuine signature of the person who signed that voter registration record?
This is my opinion that the handwriting pattern that was found on the voter registration card for Andrew Robinson is a different writing pattern than the name that appears on sheet number 16, line 2.
Do you have an opinion as to whether the person who signed sheet 16, line 2 is a different person than the person who signed the voter registration record?
I do.
What is that opinion?
We have two different writers.
Do you hold that opinion to a reasonable degree of professional certainty?
I do.
Next is item number 54, sheet 18, line 4. Have you had an opportunity to review the signature appearing on sheet 18, line 4?
Yes, I have.
Have you had an opportunity to review the corresponding voter registration record?
Yes, I have.
Have you formed an opinion as to whether or not the signature that appears on sheet 18, line 4 is the genuine signature of the person who signed that voter registration record?
Based on the voter registration card signature that's on file, is a different writing pattern than that of sheet number 18, line number 4 of Mr. Verduzzo.
And I'm sorry, I missed part of that. Did you form an opinion that the person who signed sheet 18, line 4 is a different person than the person who signed the corresponding voter registration record?
They're different writers. Yes.
Okay, do you hold that opinion to a reasonable degree of professional certainty?
Yes.
Okay, next is item number 55, sheet 18, line 7. Have you had an opportunity to review the signature on sheet 18, line 7?
Yes, I have.
Have you had an opportunity to review the corresponding voter registration record? Have you had an opportunity to review the corresponding voter registration record?
Yes, I have.
Have you formed an opinion as to whether or not the signature that appears on sheet 18, line 7 is the genuine signature of the person who signed that voter registration record?
The writing pattern of Scott Gardner found on the voter registration card is a different writing pattern than that of sheet number 18, line number 7 or 8. There's two different lines with Scott Gardner's name.
Have you formed an opinion as to whether or not the person who signed sheet 18, line 7 is a different person than the person who signed the corresponding voter registration record?
Yes, I have.
What is that opinion?
And we have two different writers.
Okay, and do you hold that opinion to a reasonable degree of professional certainty?
Yes, I do.
Okay, the next is item number 60, sheet 20, line 1. Have you had an opportunity to review the signature that appears on sheet 20, line 1?
I have.
And have you had an opportunity to review the corresponding voter registration record?
Yes, I have.
And have you formed an opinion as to whether or not the signature that appears on sheet 20, line 1 is the genuine signature of the person who signed the corresponding voter registration record?
Yes, I have.
What is that opinion?
Opinion is that the voter registration card signature for Barry Ward is a different writing pattern than that of sheet number 20, line number 1.
Have you formed an opinion about whether or not the person who signed sheet 20, line 1 of the nominating petition is a different person than the person who signed the registration record?
Yes, I have.
What is that opinion?
Opinion is we have two different writers.
Do you hold that opinion to a reasonable degree of professional certainty? Next is item number 62, sheet 20, line 4. Have you had an opportunity to review the signature on sheet 20, line 4?
Yes, I have.
Have you had an opportunity to review the corresponding signature for the voter registration record?
I have.
If you formed an opinion as to whether the signature on sheet 20, line 4 is the genuine signature of the person who signed the corresponding voter registration record?
Yes, I have.
What is that opinion?
The writing pattern found on the voter registration card for Anna Ward is a different writing pattern than that of sheet number 20, line number 4.
And have you formed an opinion as to whether or not the person who signed sheet 20, line 4 is a different person than the person who signed the corresponding voter registration record?
Yes, I have.
What is that opinion?
2 different writers.
Do you hold that opinion to a reasonable degree of professional certainty?
Yes, I do.
Okay, Mr. Spencer, are there any other signatures on this list besides the ones that we've talked about where you formed a similar opinion?
Pretty much covers my findings.
Okay, all right. We have no further questions at this time.
Mr. Spencer, can you tell the board what a controlled exemplar environment is?
Question deals with a controlled environment.
Of obtaining exemplars of signatures?
Well, there's many variables that we deal with in handwriting, particularly in signatures. One of the things that are certainly of interest is what kind of conditions we had in the environment, whether it was a clipboard, whether it was signed in the open area, whether it was signed on a table, whether it was signed as somebody was moving into a vehicle such as a bus, train, that sort of thing. But we don't know any of those. All we can do is look at the writing pattern and compare it to the known writing pattern compared to the challenge writing pattern.
So you would acknowledge with regard to the signatures on the petition sheets, they were probably gathered in the outdoors on a clipboard, correct? And in the field of hand.
Can we get some foundation for that? We object to that question. Calls for speculation as to how they were gathered. There's nothing in the record as to how they were gathered.
This is cross-examination.
We'll keep that in mind, but we understand.
With regard to the petition sheets for elections, their petitions are normally presented to voters to sign on a clipboard, correct? Okay, when you're going to have to speak up, sir. What was your answer?
I assume so.
Well, I don't want you to assume so, sir, because in the area of handwriting analysis, you usually get exemplars from a person by having them sit in a room while you observe them, correct?
Not necessarily.
Well, you get other samples of their signatures, correct?
The only thing we have some certainty with is that when they did their voter registration card, they probably were comfortable when they did that. That's
And with regard to the petition sheets, you would acknowledge that it's not a controlled environment when the signers are signing those, correct?
define what you mean by a controlled environment.
Well, sitting at a table in a room with a jacket on or in a nice warm place having a cup of coffee.
Because of what usually happens with the petition sheets, as I understand it, it would be affected by the environment, yes.
And sir, with regard to the signatures that you looked at, and I'm talking about the signatures, the signature clips that you're comparing the signatures to from the petition sheet, it's fair to say that you do not know the date other than one signature that appears on this demonstrative evidence as to when the individuals signed their signature clip, correct? The registration card.
I didn't pay any attention to the date, what type of the year it was, nothing like that.
You acknowledge and agree that people's signature and handwriting style change over time, correct?
Okay.
Their handwriting,
Sir, would you repeat your answer to the question? I believe it was,
You have now agreed that people's signature and handwriting style change over time, correct?
I said in some cases.
well, is it your testimony that if I sign a signature card for voter registration in 1999 and in 2021, my signature is going to be the same?
The writing pattern in all likelihood is the same, yes.
So is it your testimony that there is no variation in the signer's signature over time based on age?
Necessarily.
what was the answer?
Not necessarily.
Are you aware, have you determined by taking an analysis of the date the registration cards were signed versus the date, the range that the petitions were signed on any of these signatures that you're opined on?
I did not have the benefit of that, no.
But that was available, correct?
Not the information I had, no.
Okay, well, it's something that you would want to know of how old those specimens were, correct?
It's a factor.
Right, but in this case, you didn't consider that factor, correct?
I didn't have that information, no.
Sir, you didn't consider that factor, correct?
I did not have that information available.
It's non-responsive to my question.
I think we get the gist
Thus,
of the
you
answer.
couldn't consider it? I mean, is that what you're saying?
If what I was provided, there were no dates with the voter registration card for the most part. I think there was probably a piece of a date here and there, but I did not know the actual date of the voter registration card.
Sir, when were you retained?
About 2 weeks ago.
About 2 weeks ago? Can you give me a date?
You need a specific date?
Yes, I do.
Just a moment.
Objection, relevance.
It's a fair question. If you're reviewing a document, sir, would you please let us know what you are reviewing to determine the answer to that question?
I'm looking at my iPhone for emails, that's all.
What was that?
Emails on his phone.
I'm looking on my iPhone for emails, that's all I'm doing. It was probably Tuesday of last week. That's a guess, but I believe that's when it was.
And sir, did you receive a payment to provide your testimony?
I'm paid for my time, and there is a fee agreement, a retainer agreement, if you will.
And where did the check come from? Who is the payor of your fee?
Objection to relevance.
It goes to bias.
Paid for my time.
I would overrule.
Overruled.
You may answer.
What was the answer?
I am paid for my time, not my testimony.
And the question is, who was the payer?
Who paid the payer? There was a check. Did you receive it by check?
I have not received that at this point.
Okay, so you've not received payment yet.
Yeah.
Okay. And what is your hourly fee?
$2.50 an hour.
And sir, what was your retainer to be paid?
The work that I would
Objection,
do
relevance.
in preparation.
How much he's making is irrelevant.
Overruled. You can answer. You can answer the question.
I was paid for my preparation time to go through each of the signatures that had been challenged compared to the signatures at the voter registration cards. And I'm paid for my sworn testimony today based on 4 hours minimum. It's going to be approximately $1,800.
With regard to the affidavits, you weren't paid to review the affidavits, correct? And what I'm talking about are objectors, candidates exhibits 1 through 37, correct?
I'm not sure that I'm following you, sir.
Have you seen objectors exhibits 1 through 37?
Not objectors.
Sorry, candidates exhibits 1 through 37.
I don't believe they were numbered that way for me, but I could be wrong.
Well, they are numbered. I nicely placed exhibit numbers on them, and it says candidates exhibit number 1, and then it says objector rule 8 number, and the number relates to the item number. Did you see those?
I see what you're referring to. Go ahead.
And you didn't review those, correct?
After I had completed my findings,
You didn't review them, correct?
I looked at them after I had done my work, yes.
And with regard to these affidavits, it's fair to say that you're not going to consider these affidavits in your opinions because you've already made up your mind.
Objection. He's asking him, this is conjecture. Are you going to or are you not?
Let him
Let him
answer.
answer.
He can answer the question. It's overruled.
What I have been asked to do is compare the challenge name on the various petition sheets to the known and authentic signature writing pattern on the voter registration card. That was my assignment.
And so your assignment did not include reviewing candidates exhibits 1 through 37, which contain affidavits of voters that signed the petition sheet and the signatures that you're reviewing, correct?
Yes.
And sir, with regard to these sworn affidavits, you've previously acknowledged that this is a way of a handwriting expert to obtain an exemplar, correct?
If I had had the exemplars when I was doing my initial work, that would be different, but I did not.
Okay, so with regard to these affidavits, the reason why they provide you with verification is one, they're normally done in a controlled environment, like a one-on-one, correct?
I would assume so.
They're done before someone that's verifying the identification of the signer, correct?
Again, I would assume so.
I don't want you to assume, sir. Are you familiar with this process in handwriting analysis?
Yes, I am.
Objection. He doesn't have personal knowledge of how these affidavits were gathered.
I don't think he's asking him about personal knowledge of specific affidavits. He's asking him in general about,
Steve, do you want to defend this?
see what you do to obtain an exemplar, a sworn exemplar. And I'm going to overrule the objection unless the board wants to consider otherwise.
I would overrule, but did you have more to say, Mr. Urban?
So to be clear, he can ask for common processes, but he's asking him specifically if that's what the case with these were. And he can't answer that.
This is cross-examination,
We should
counsel.
answer.
I would overrule the objection.
I would have an answer.
Mr. Keller?
I would have him answer.
Would you re-ask the last question so that the witness understands what it is, and then he can answer? Please, Mrs. Clerk. Here, you can, maybe you can use mine.
Want Mr. Lozinski just to repeat this question?
I don't want you to assume, are you familiar with this process in handwriting analysis?
Where there is an affidavit and someone has witnessed the person signing their name is sometimes part of the exemplars in a case. Oftentimes it is not included.
You would agree, in this case, there's affidavits that were provided to you regarding the signatures that you've already formed opinions on, and you have made the decision not to review those, which violates the protocols for handwriting analysis, correct?
No, that would not be the case here, no.
So is it your testimony that if you are provided with evidence that the people that actually did sign the petition sheets have now sworn to that under oath, you disregard that?
I said is that the handwriting pattern comparison based on the voter registration card compared to the challenge name on the various petition sheets is what I based my opinion.
Sir, you didn't answer my question. My question is very simple, is that you were provided with exemplars under oath in a controlled environment related to the signatures you were going to review, and you are testifying that those don't matter.
Didn't say, said the best evidence available is what I based my findings on.
But you would agree the best evidence available showing a current signature would be an affidavit that would have a date on it, which is within 4 months of the time these petitions were signed.
Best evidence available when I was doing my initial work, my comparison. This is based on.
Sir, with regard to the best.
Repeat his answer. He broke off for a minute.
Can you repeat his answer, Madam Court Reporter?
The best evidence available when I was doing my the best evidence when I was doing my initial work, my comparison was based on.
You would agree that the affidavits, candidates exhibit number 1 through 37, would be considered best evidence in the field of handwriting analysis, correct?
Had that been available to me when I was doing my initial work, it certainly would have been considered. They were not available.
Sir, my question is more basic. It's fair to say that affidavits that are within a time range of the date that the signatures were made on the petition sheets that are on the affidavit would be considered best evidence in the field of handwriting analysis.
There's two things that are most important as I understand it. One is format. So when you have a name that has first name, full middle name, and last name, and you compare that to that same format, that would be considered best evidence available. The second area would be the time period. And your 4 months is right. You know, that's a good exemplar and certainly be considered appropriate to best evidence available definition.
And the reason why is because people's signatures change over time, correct?
Not necessarily.
Well, sir, with regard to, let's talk about your analysis here, is handwriting pattern. Can you tell the board what your definition of handwriting pattern is?
Yes, We're talking about the pattern of the handwriting. We're looking at the strokes, combination strokes. We're determining where it starts to the left of the signature line or above the signature line, below it, and where it ends up in the terminal stroke on the far right. Also, where it goes above the signature line, where it goes below the signature line, this sort of thing. And what we find is that some writers have a very consistent writing pattern over many years. And other writers have a significant difference, especially if they add a stylized signature during that time. So we can't say that everyone's handwriting pattern or the signature changes over time. Some do, some don't.
Sir, do you have an opinion as to what percentage of people's handwriting stays the same over time?
It varies, you know, it's probably 60-40 kind of a thing. It may be different than that depending on a given group. Might be 70-30, you know, I don't know.
And you would agree that age is a factor in change of signature?
It can be.
And with regard to any of the signers that you have opined on, I believe there's 12, do you know the age of the individuals when they signed the signature card for the voter registration that you reviewed?
I don't know.
Do you know the age of any of these 12 signers at the time they signed the petition sheet?
I don't know.
With regard to medical conditions, do they play a role?
In some cases, other cases not.
And with regard to the registration cards, do you know if any of those signers, these 12 signatures that you pointed out, whether or not someone had a medical condition at the time they signed?
I don't know.
And with regard,
Repeat your answer.
I don't know that.
and at the time these 12 individuals signed the petition sheets, you don't know if they had a medical condition, correct?
I don't know that.
Sir, is it fair to say that other than your purported expert opinion, you have no other evidence that someone else signed these petition sheets other than the person's name and address that appears on it? Do you understand my question?
You repeat that, please?
Sure. Other than your testimony, your purported expert testimony on this writing pattern, it's fair to say that you have no other evidence to support your opinion that someone other than the voter that appears on the petition sheet signed the petition sheet.
That would be true. However, I seldom know that in any of the cases that I testify.
And you're not offering any testimony that all 12 signatures were signed by one person, correct?
Saying one person signed all 12 different writing patterns?
Right. You're not offering that testimony, correct?
No.
And with regard to these 12 individuals, other than what was provided to you that you chose to look at, you looked at nothing else, correct?
True. My assignment was to look at the voter registration card compared to the challenge name on the various petition sheets.
Now, sir, let's get to number 1, which is sheet 2, line 9. I want to call your attention to the last. It starts with the D is the first name, and then you see some L's. Do you see that?
I believe it's Donald Marchin. I'm not sure what the last spelling is.
Is it your testimony that the 2 upward stroke ovals are not similar to the signature clip?
based on what I do, and as I look at the strokes, combination strokes, as I had mentioned earlier, we're looking at what the strokes are doing in combination next to one another and that sort of thing. And there's differences between the challenge name as well as the known voter registration card signature.
Now, sir, would you agree if someone was standing and writing very fast, that would impact their writing pattern?
Good. I don't know that. Your environment is not known when you're dealing with petition sheets in the Chicago area.
But it's a relevant factor that a handwriting analysis or expert that you purport to be would take into account.
Look at the various factors that you might know. The problem is that, as has been pointed out, you shouldn't assume anything.
Well, with regard to those factors in your field of specialty, you would acknowledge that whether someone was writing fast would impact their handwriting pattern.
Good.
And it would also, if they're writing upright on a clipboard, up like this, and writing upward versus on a flat surface of a table, correct?
And I don't know what that environment was like.
Okay, but that would be something that would impact their handwriting pattern, correct?
Possible.
It's possible. You're aware that that has occurred, correct?
Say it again.
You're aware that that's something that is to be taken into account in your field of study.
The environment is a factor, yes.
Now, sir, calling your attention to number 2, which is petition sheet 6, line 7.
Okay.
You're aware there's an affidavit for this signature, correct? Of Timothy Barnes, correct?
I believe that's true.
And it's fair to say that you did not compare the signatures on the affidavit to the signatures. And in Mr. Barnes' case, there's actually 2 signatures, one for the signature and one for the printed name, correct?
On sheet number 6, he provided his signature in the left column, and he provided what appears to be a printed name in the column to the right of that.
And so you did not compare the affidavit for Mr. Barnes. And that affidavit is, let me see here. That is Canada's exhibit number 20.
Did you say candidates exhibit number 20?
Yes.
No, it's
It's,
not.
it's a mismatch.
It's not.
Oh, I apologize.
It's candidate exhibit 9, which makes reference to objectors rule 8, number 20.
My fault. I apologize.
Oh, okay.
Yeah, but he said
I've got it.
exhibit 20, so.
Which tab are we in?
It's Canada's exhibit number 9.
Members of the board, you're in tab 8.
Right, okay.
No, I have it, but he did say exhibit
All right.
No,
And then,
20, so.
I found it.
Say exhibit 20, it's candidate exhibit 9, reference to objector rule 8, number 20.
I've got it now.
Got it now?
Yeah.
I apologize. I tried it. I thought I was making it easier.
there it is. Okay, thank you.
Sir, with regard to all the signatures, the 12 signatures that you reviewed, how much time did you spend on each one?
Talking about the initial assignment of, I think it was 64 different signatures.
Now, the 64, did you review all 64?
I did.
Okay. And how long did you spend on each of the 64?
The total you're talking about?
Total time. And then I'll get down to specifics.
Okay. In the neighborhood of 3 hours looking over the 64.
And in the field of handwriting analysis, before you form an opinion, what is the recommended time to do the analysis of a single signature against a specimen?
On how many exemplars you have to work with, they're the known and the authentic signature. But the idea is to determine the writing pattern of the one in question compared to the writing pattern of those that are known.
How much time, sir?
It will vary. It might be a half an hour. It might be 3 hours. I don't know. It varies.
In this case, how much time did you spend on each specimen, which would be the signature clip versus the petition sheet?
The objection asks and answers. It varied, he said.
I would overrule. I'd overrule too. Overrule. You can answer. Can
Okay.
you repeat the question for the witness, please? Sir?
I don't think you did.
I don't think he heard it, but
You're breaking up.
yeah.
In this case, how much time did you spend on each specimen, which would be the signature clip versus the petition sheet?
First of all, there's a number of them in that group of 64 that didn't require much time. And there's others that required more time. So it's difficult to give it so many minutes or sections of an hour, based on the question and the agreement. Now, if we're talking specifically about the 12 names, then I probably spent in the neighborhood of 3 hours, as I said, studying the known voter registration card writing pattern compared to that of the challenge name on the petition sheets.
First of all, sir, I asked you how much time you spent on the 64 signatures, and you said 3 hours.
3 hours, approximately 3 hours. So
Okay, and then are you saying you spent an additional 3 hours on the 12 signatures?
not an additional 3 hours, but I did spend more time on the ones that that I was suspicious of, yes.
And sir, did anyone point out any signatures for you to look at?
Initially, they said, here's the group of 64, and I went through them on my own without any input from others.
It's fair to say, sir, that you spent about 3 minutes on each of the 64 signatures, and you came up with your opinions, correct?
I don't think that was what the assignment was. I don't think that was the question. The question had to do with, I had 64 signatures that I compared the writing pattern of the known and authentic registration card, voter registration card, compared to the challenge names. There were many of those 64 that I were not suspicious of.
Did anyone target you or direct you to these 12 signatures, sir?
No.
And sir, with regard to your examination, is it fair to say that you used a magnifying glass?
I used some magnifying equipment. I did not use a magnifying glass, and it wasn't necessary to do that because you can use the computer attachments, the ones that are sent over as a scanned item, and look at them accordingly.
Sir, do you know whether or not the documents you received were actually scanned originals?
I don't know that for a fact, no.
Is that a factor that you should take into account when you render your opinions?
If the image is sharp and not fuzzy, that's what I'm concerned about. You know, it might be a first generation, it might be a third generation, depending on, you know, how it was presented on the computer. It's not a factor as long as it's real sharp strokes and combination strokes.
Sir, does the type of pen, whether it's a ballpoint, fountain pen, roller ball, or felt tip, have any play in the handwriting pattern?
In this case, and in this assignment, no, I don't believe so.
Sir, do you have an opinion as to what type of writing instrument the petitioner signers, the 12 that you've opined on, used when they signed their voter registration card?
I don't know that, no.
Do you know what type they used writing instrument when they signed the petition sheet of the candidate?
I do not know that.
Did you inquire to find out?
It wasn't a factor, so no, I did not.
Now, sir, with regard to it's sheet 7, line 1. That's another one of your opinions.
You said sheet 7,
line 1.
okay?
And with regard to this voter, you did receive an affidavit, did you not?
I believe so.
And that affidavit would be, let's see here. Kansas exhibit number 12.
Okay, I have it.
And is it fair to say that even as we sit here today, you have not looked at this affidavit?
I did look at it after I received it. It's what I received was a very poor quality. I could certainly could be improved upon, you know, if I were opining regarding candidate exhibit 12, as you had mentioned.
Here's the mic. Sorry. Mr. Spencer, the reporter has a question about your last answer. She didn't hear it.
Oh, I'm sorry. I said that as I received the affidavits, the quality was very poor, and it's difficult to opine anything from what I received.
Sir, if we can go to your next one, and that is petition sheet line 8.
What sheet number?
Petition sheet 8, line 8.
Line 8, yep.
Do you have it in front of you, sir?
I do. Go ahead.
Now, sir, I want you to take a look at the J in Jose on the signature clip and the J that appears in the name voter signature at line 8 on that page.
Okay.
Would you agree that's a very, very distinctive J?
Somewhat distinctive, yes.
And they both match, correct, sir?
They don't match, no.
It's your testimony they don't match.
No, I didn't say that. I said that the writing pattern on the voter registration card is a different writing pattern than that of the challenge name on sheet number 8, line 8.
But with regard to the J, would you agree that the J on the voter registration card and the J on the petition sheet are pretty close.
Similarities, yes.
Similar.
Similarities.
It's your testimony that's just similar.
Well, we have to look at more than just the J when we're determining the findings.
Well, sir, your finding is someone else signed that name for Jose Hernandez, right? That's your testimony.
That's correct.
That's based on you looking at a document, no other items. You looked at the voter registration and you looked at the petition sheet and you provided that testimony, right?
That's correct.
And you ignored the affidavit of Jose Hernandez, who said under oath, I signed that petition sheet, correct?
Can you tell us what's
Yeah,
the affidavit of Mr. Hernandez?
It's candidate
Exhibit 16.
and it's number 20 on objectors rule 8.
Exhibit 16. Candidate exhibit 16. I'm sorry, I just.
No.
Yeah, exhibit number 16.
Correct.
Yeah, again, very poor quality, but yes, I do have it in front of me.
You have not, in fact, with regard to the affidavits, Kansas exhibits 1 through 37, it's fair to say you have nothing to refute that these affidavits were actually signed by the people that signed the petition sheets under oath, correct?
They were not provided at the time, and the best evidence available is what my findings are based on.
When was the first time you received these affidavits, Kansas exhibits 1 through 37?
Well, a short time ago, I don't know if it was a day ago, 2 days ago, but a short time ago.
And it's fair to say, I just want to make sure we're clear that I have an answer from you. You have nothing to dispute that the voters that signed these affidavits, 1 through 37, actually signed the petition sheets that they're attesting to, correct?
That I'm aware of, no.
Sir, I'm going to speed this up real quick. With regard to your testimony, you offered, other than the handwriting pattern was different, you did not provide this board with any specifics with regard to any of those 12 signatures, did you?
I don't believe I was asked that, but go ahead.
Sir, you didn't provide the specifics, correct?
Again, I was not asked that, but go ahead.
Okay, well, you understand in the field of handwriting analysis, you're required to tell this board why each signature is not genuine, correct?
If I'm asked, yes.
Well, sir, with regard to your testimony here, you made conclusions with regard to each of these 12 signatures, correct?
I opined, yes. I had findings, yes.
And with regard to your findings, you didn't prepare a report, correct?
That's true.
And sir, you testified in 2018 during an election matter that in order to examine a single signature, it would take 30 minutes having multiple exemplars, correct?
If they're available, yes.
And that would be the protocol required of a handwriting analysis person, correct?
In some cases, other cases not.
And less than 2 days later, you testified in another case where you said all it took you was 30 seconds to make your decision whether or not a signature was genuine, correct?
I don't recall that, but if you say so.
Well, sir, do you recall testifying for 17 hours regarding signatures that you were trying to claim were genuine signatures?
17 hours? No, I don't remember that.
You don't remember testifying over 3 days in the case of Vahey versus Lisa Copeland, where you were trying to testify that 1,200 signatures that were found to be invalid were valid.
When you're saying 17 hours, I do not remember that I was involved in any of the hearings for that length of time.
Well, sir, you don't recall testifying over 3 days for 17 hours?
Objection, he asked, that's asking an answer. He doesn't recall.
Sir, what's the longest you've ever testified regarding rehabilitation or challenging the genuineness of signatures?
Objection, relevance.
You can answer. Sir, do you need the question repeated?
Sir, did you hear the question?
Asking what's the longest that I have testified at a hearing, arbitration, trial,
No, I'm talking about election.
on the elections?
Yeah.
I don't remember that there were any of them that lengthy. You're correct. There were several different sessions, I believe, with Lisa Copeland, but I certainly don't remember that it was 17 hours.
Sir, with regard to your testimony here today, do you have an engagement agreement?
Oh, the fee agreement, yes.
And who is the fee agreement with?
That would be Mr. Casper.
And sir, I just have two more questions. With regard to doing these election matters, have you ever been retained by an electoral board or a local election authority as their in-house expert to review signatures?
I have not.
It's fair to say that you've been hired by people seeking to have your testimony offered for a particular purpose in an election matter.
Seems correct, yes.
I have nothing further.
Redirect.
Sir, as far as best practices go, does best practices include you making assumptions, creating scenarios, or speculating as to how a signature was made?
I'm not sure that I'm answering your question as you have asked it, but what we're doing is we're speaking for the handwriting. The handwriting cannot speak for itself, so we help those that are involved understand the writing pattern and whether there's similarities or whether there's dissimilarities. Seems like there's always a few things that have some similarities in each question signature, but overall, what is the writing pattern? Is it clockwise, counterclockwise? Which side of a particular stroke is placed first, either above or below the signature line? So what we're concerned about is what is happening with the handwriting itself, particularly the handwriting pattern. We don't know a lot of the variables in most cases, so we have to just work with what is there and not what we don't know. In some cases, we know a lot of things, and then we do take that into consideration. For instance, I know of a question document examiner that's also a medical doctor, and he can opine to how handwriting is affected by various drugs. I'm not allowed to do that because I am not a medical doctor. However, if we know that a person was very much affected by particular drugs, and we know that those drugs will affect motor response, then that's something that has to be taken into consideration. then I would ask Dr. Alexander, what are your findings and what should we do with the information that we now have? And then I would have some additional coaching, which would be helpful. But for the most part, variables, have to be set aside because we don't know them.
Did you keep track of the amount of time that you spent on each individual signature?
In this particular case,
Yes.
in general, I didn't have a log and say, I worked on this from 9/11 to 9/17, had an interruption, that kind of thing. No.
If I wrote my name on a piece of paper and photocopied it and put both of them before you, would you be able to make quick work of that comparison?
Are you talking about having your signature from some time ago compared to your signature today?
No, right now, if I signed a sheet of paper, walked into another room, made a photocopy of it and put it in front of you, would you be able to make quick work of your evaluation of an original and a photocopy of the same signature?
Well, the quick answer, I guess, is it would depend a lot on the uniqueness of your signature. Whether you have a number of items which we would call complexity or lack of that.
Okay,
The more complexity, it's quicker. Yes.
Yeah, I'm
Let
talking.
him finish his answer, please.
No, it's my question.
Board, do you want him to finish his answer or not?
Let him finish the statement.
You can finish your statement, sir. Go ahead.
Okay. So all I'm saying is I don't know until I see your signature, whether you have a lot of complexity or whether you have a lack of that. There's a number of factors that will have an influence on how long it would take to study it and for what purpose,
Okay, sir, I think you're misunderstanding my question. If I signed a piece of paper and made a photocopy of it and put the original and the photocopy of that signature in front of you, you would be able to see that they're exact same signature, correct?
In most cases, yes.
Okay. And if you encountered those in a group of something like that, a group of signatures that you were to evaluate, you would be able to move on and not have to look into whether or not it was a different signature, correct?
Yes.
Okay. Council asked you and kind of directed the question that you spent 3 minutes per signature. Now that would be an average if you took 3 hours to examine 64 signatures, correct?
You asked what I recall it required, and I'm not giving you right to the minute, but yeah, in that neighborhood, yes.
So council mentioned 3 minutes per signature, and that is just 180 divided by 64 is roughly 3 minutes, correct?
That's where you got it, yes.
Okay, but that's not how much time you spent on each signature, correct? It varied.
No, it'll vary.
Okay. Now he asked you if you had anything to dispute the affidavits that were presented to you. In your other engagements, are you required to produce evidence on behalf of the opposing counsel to dispute evidence?
No.
I'm going to object to that on foundation.
What was the question again?
Whether in his other cases he was required to produce evidence other than what he's given. I'll take that back. I didn't say that. To refute evidence produced by the opposing party.
I would overrule the objection. We let him ask about it. It's redirect.
I think it's a fair question.
Fair enough. You understand it?
Mr. Spencer, do you understand the question that was asked, or did you hear it?
In other words, you're asking do I go out and obtain more exemplars or the known authentic writing in addition to what I'm provided by counsel? And in most cases, no.
Your testimony with the signatures that Mr. Casper walked you through, that was 10 signatures, correct?
I thought it was 12, but okay.
Was it 10 or 11?
Are you referring to the direct examination?
Yes, under direct when Mr. Casper, part 11? Okay. Several of those have corresponding affidavits that were presented by Mr. Ladazinski. And since you made your initial findings on those 11, have you had a chance to review corresponding affidavits that dealt with those sheet and lines, those signatures?
Well, again, as I had mentioned before, the quality of what I received was pretty poor. So no, I have not.
Was pretty
The-
what? Or
Quality that I received them was poor. And so
Okay,
I have not.
so as poor as the quality was, you looked at them, correct?
I definitely looked at them, yes.
Okay. And did any of the affidavits that you reviewed cause you to change your opinion that you gave us on the 11 signatures that Mr. Casper walked you through?
I'm going to object to that. He's already testified that he didn't consider the affidavits.
I think it's sustained. Objection sustained. He testified that way.
He testified well.
He said he didn't review the affidavits.
wasn't asked to and didn't.
I mean, I think that
Can,
was,
can we just, I want to establish it. Did you review the affidavits at all?
Yes, I did look at them. As I say, they had very poor quality as a receipt.
When you've said poor quality several times, you mean that the pages are white background, but they're kind of dark?
Very,
Like poor
very
quality?
dark background, very dark background.
Okay, but the signatures are apparent. For example, candidate exhibit 16, Jose Hernandez. You could well see the signature on there, despite the background being, a little dark or darker than white. As you say, poor quality. So make sure we're looking at the same sort of poor quality.
If that had been the assignment, I would have asked for a better attachment, a better.
Fair enough. I just wanted to know what you meant by poor quality. The white piece of paper that should be in the background is more gray or darker, but you see the signature on each.
let me ask you.
Sure. Thank you.
Mr. Spencer, do you have a copy of candidate exhibit number 16 in front of you?
I do.
Done business
Can you hold that up to the screen?
to survive and thrive.
Got
in the next few months.
He disappeared.
You see it?
You've got your participants box up. We need to take that down so we can see you.
Can you hold that up, please, real quickly?
Okay.
See it?
We can't.
His virtual not going to work with his virtual background on.
Yeah, it's bleeding into the virtual
Can
background.
he end it?
Sorry for that.
As he put it down, I think you could see the gray with the white outline of the copy.
Seems like it's the same thing we have.
Okay.
He's gonna try to
No,
do this.
Okay. So the quality of the copies notwithstanding, did any of the affidavits that you reviewed cause you to change the opinion that you provided the board here in the 11 signatures that Mr. Casper walked you through earlier today?
I'm going to object. He testified he didn't even consider them.
That was his testimony.
Okay, and we just cleared that up. I think that what his testimony was about what his original engagement was. And then after now, we have established that he looked at them. He just said he looked at them.
He said he looked at them, didn't consider them because he wasn't asked to. Is that fair enough? You looked at them, you didn't consider them, you had already made your decision, and you weren't asked to reconsider your decision or take these into consideration in making your original decision or changing your decision. That's what I gleaned from your testimony.
That is correct.
Okay,
As you sit here today, do you have any opinion as to the signatures on the affidavit?
Well, again, based on what I have to work with, no.
can I ask one thing, just about what did you have in front of you in terms of the signature card? Would it be basically what we had, Mr. Erdman?
He was
A copy?
actually, he was provided with the summary report that had those clips.
Right, so he had
And that-
copies
and
of
that
those.
is- That's a demonstrative that took these clips and put it right next to the petition. But they come from the registrar's clips from the clerk's office.
Okay, the
That-
witness then, the signatures from the registration card were the clips that are on the clerk's summary, which is board exhibit number 9.
Yes, he worked with this, and we prepared the demonstrative that placed those signatures onto a copy of the petition sheet.
Just let the record show that Mr. Spencer, the signatures on the registration card that Mr. Spencer reviewed were the reproductions of the signatures that were on the signature clips, which is in evidence as board exhibit number 9.
That, and exhibit 9 is the petition summary.
Yes, it was admitted before you came in.
And I don't agree with that. He was given this petition summary for review, and that's what he used.
And it has the signature clip copy?
Where it says,
That was admitted, we have that.
you're saying where it says petition detail
Okay.
report?
Okay.
So I just wanted to clarify, you didn't have original cards, obviously. He had,
Petition
What you're
detail
showing us.
report.
Correct. And he wasn't,
The board copy.
and my point is that he wasn't using this to
right,
form his opinion. I just wanted to be clear on that.
Exhibit number 9, Mr. Erdman, was admitted into evidence as board exhibit 9 at the outset of the hearing today, prior to your coming. And that board exhibit 9 is the copy of the summary.
The petition summary report.
Okay. I wasn't sure if you understood that.
Mr. Erdman, are you done? I do have a question.
You go ahead. I'm
I have one question about a particular signature. If you look at sheet number 6, line 7,
6, line 7.
yeah, and then you look at candidate exhibit number 9.
Okay. Sheet
Okay.
6, and what is it?
It's sheet 6, line 7, Timothy Barnes.
Right.
And then you look at the affidavit he signed, which is candidate exhibit number 9.
Okay, I have it. Go ahead.
So what would your opinion be as to the two signatures, the one that was signed on the petition sheet, not the card, and the signature on the affidavit?
Okay, I'm looking at the affidavit, and what do you want me to compare it to?
Compared to the signature on the petition sheet.
On the
line
petition,
7.
okay? So
Column one.
this would be in the most left column, line 7,
Right,
right?
right.
And your question is?
Compare that to candidates exhibit number 9, which is the affidavit that was signed by Timothy Barnes. Is that the same signature? In your opinion?
Well, again, my quality is very, very poor, but based on what I can see, I'm suspicious of it.
Okay, thank you. He's suspicious of it.
What's the rest of the answer?
He's suspicious of it. It's suspect, yeah, well, it doesn't, yeah. See,
Mr. Spencer, regarding the same signature, Timothy C. Barnes, I had a question for you.
Okay.
With the precinct detail report, the page I have indicates his specimen signature on the permanent voters registration record was signed in 1980. So we're looking like almost 4 decades. When you have that available, do you make an allowance for the aging process or anything?
As
It's
I
on the picture clip, actually.
As I mentioned before, I didn't have any benefit of the age of the voter registration card. So I could not take that into consideration. Certainly knowing that you said 1980, was that your year?
Yeah, on my signature clip, the year 1980 is there. 19 is pre-printed and 80 is filled in pen. I'm just wondering if the age of the card, you make variations, or did you have the birth dates of the voters with your examples?
Didn't have any of that, but having that, based on that many years ago, it's 20 plus another 21, that's 41 years ago. Certainly my suspicion would be reduced because that's a long time.
Okay, thank you, sir.
So when you were asked to review these, you have 3, the ones that pertain to the affidavits. You have 3 signatures. You have the signature in column 1 on the petition. You have the signature provided by the Cook County Clerk as their exemplar, and you have a signature on the affidavit, correct?
I'm going to object. He didn't review them.
He's seen them. We've established it. He's seen them.
Are you talking about just today? Because I think he indicated earlier exactly what Judge Bertucci said, and that is he already completed his analysis and reached his opinion before he looked at the affidavits. Now, if I'm saying that incorrectly, I'm relatively certain that was his testimony in a summary. So are you, I think his objection was that the suggestion in your question is that he had this and he looked at it. And I don't think that that's correct. He looked at it after he reached his opinion.
Okay, and you're making a temporal distinction that is nowhere in my question. He looked at it, period. And I'm asking a question based on the fact that he looked at it. That's been his testimony here, is that he looked at it. If you want to ask whether that was part of his original engagement, that's a separate issue. We've already established that he looked at the information that he had and made his decision prior to seeing the affidavits. Since that time, he has seen the affidavits. So a fair question is about that process, what his thoughts are after seeing the affidavit. I don't know why that is such a problem.
Well, I think then you should ask that question, but I don't think that was your question initially. If you want to
No,
ask that
I
question,
directed him to the 3.
Just repeat the question, let's get.
Okay, sir, you have these in front of you now. Regardless of what your engagement letter was, you have the petition sheet, you have the clerk's clip of a registration signature, and you have an affidavit with a signature on it. You have all of that for sheet 6, line 7, correct?
Yeah.
Okay. looking at that now, does the affidavit change your opinion that you gave before?
I'm going to object to this. He's offered his testimony. He did not consider this as part of his opinion when he had it available to him. You know,
Okay, I asked him this, I asked him basically the same thing. I asked him to look at the affidavit signature, and I asked him to look at the signature on the petition sheet. And he said he was suspicious of the signature.
I understand that, but he's formed his opinions based on a very narrow task that he was told by objectors counsel. Okay. And now what we're going to do is we're going to say, now look at this. Let's throw this in front of you. He had it available and he chose not to review it or consider it.
I think it's a fair objection in this sense. He said he's had it, he said not a long time, but like a day or two, okay? So maybe 2 days. I mean, my last 2 days were pretty long, but in any event, but he was hired to do something. He did his job, as he says he's an expert, hired to do. And now, I appreciate this objection because are we going to recess for him to create a new expert opinion? I don't know.
That's not what we're asking.
I think the objection should be sustained because this is all this is redirect. This is not direct examination. I think the witness should be, but board, you can roll on the objection. All right, Mr. Verducci, what is your decision?
Please.
I want to ask a question. Are you going to ask this for every affidavit or just this one?
No, just as far as the process goes, is that, and I don't want to prejudice the testimony because I'm going to tell you what I'm thinking. He was giving 2 pieces of information and asked to make his opinion.
Correct.
He's made that opinion. Okay, that was his initial assignment. Since then, he's been given a 3rd piece of information. Okay, my simple question is, did the 3rd piece of information change your opinion from what you saw on the first 2?
And it's going to be with respect to Barnes.
Yes, for this one.
I'm going to, if it's just one, I'm fine with it. But the problem here is it's just like you didn't consider it. It's beyond the scope.
My opinion.
Fair enough. If it's just one, fine.
I think the board knows what he considered. So if it's okay.
Okay, and so we don't come back from the witness.
Yep.
I won't go through each one of them.
Sure.
But I will ask you, if you had seen something that would change your opinion.
No. I object to that.
We're talking about an expert who's here to testify in his expert capacity. And he has the ability to look at the 3rd signature.
The problem.
If you're just asking about Barnes, ask it, okay? So we can continue. So ask about that signature. If he changes his mind.
Okay, well, my follow-up question, then we'll argue about my policy.
Yeah, let's get this question.
So you're going to overrule the objection? Is that the decision?
Yeah. I don't know.
Based on the representation of Mr. Burton, and we're dealing with Barnes.
Mr. Kelly?
Just for Barnes, yes.
Yeah,
Okay.
for Barnes.
So, having seen the 3 exemplars, petition sheet, clerk's registration clip, and the signature on the affidavit, did you feel the need to change your testimony that you gave to Mr. Casper earlier today on the signature?
I'm going to object. It's a misleading question.
On Mr. Barnes. Well, finish the name that you're asking about.
I gave him the sheet in line.
Okay.
My objection is misleading. He didn't consider this at all.
He's considering it right now. Okay, well,
This was why I raised the objection, because this witness testified that the petitioner did not sign this. All right. Their Rule 8 says it's not genuine. 2 different issues. Okay? He's gone into an area that is not within his area of expertise. And now we're going to have him review stuff that he had, and he's already decided not to consider it.
What we're asking is if he considers it the same signature. That's it for one. I thought we agreed that one person. And then we can move on. I don't know if my fellow,
Let's finish Barnes and go on to the
yeah,
next.
let's do Barnes and then,
I have concerns.
Let me rephrase it.
And
Let me
here's
rephrase it.
one.
When, if you were given a petition sheet signature, a signature on the affidavit, and a signature from the clerk's registration, if the signature for a voter on the petition sheet and the signature on an affidavit match, but they don't match the registration card, does that still give you concern as to whether either or both of the petition sheet and the affidavit are false?
okay, that's a different question.
It's totally different.
I said I'd move on and ask a different question
Oh,
because of the problem with that one.
It's assuming a lot of things that at this point in time are not in evidence, but. it's up
Well,
to- it's
Mr.
up to-
Horvath, please, we assumed whether they were inside or outside. We assumed whether they were on a
I don't have to
clipboard.
argue with you. All I'm saying is it's making an assumption about a number of things that are not in evidence before this board. Mr. Spencer gave his opinion, stated what he based his opinion on, and what you've asked is a hypothetical question, if at best. And so all I'm saying is that it's making assumptions about things that are not before this board in evidence. It's up to
Okay,
this board
and-
if it wants to hear the answer to that question or not.
And I would ask, where was this when we were making assumptions on what the weather was and whether they were inside or outside, and we had questions to the witness based on that?
When you ask me, I'm not the one that's making the objection, sir, but I'm telling you, this board can make its decision. if it wants to
Objections
hear
were
the
made at
answer
the
to that
time.
question or not. Those were all questions that were posed by counsel to the expert concerning things that he was asking him may or may not affect the way he analyzes his signature, the protocol, if I'm not mistaken. If this board wants to hear the answer to that last question, it can overrule the objection. Did you object to that question?
I'm objecting to this line of questioning.
It's up to the board.
I think I asked it prior, if he thought that the two signatures matched, which was the one on the petition sheet and the one on the affidavit, and that's what I was going for.
And then Mr. Erdman's now asking if he found that those two matched, the petition sheet and the affidavit, but didn't match the signature card. You're asking, what would you make of that?
Yes, would you still have suspicions as to whether it's the
You
accurate?
want to hear that answer, and do you object to that?
I object to it.
So he does object.
Okay, so what does the board want to do? How do you want to move?
One moment. I'd let him answer.
I'd just like to hear about Barnes and let's go. on.
Yes.
Let him answer it so we can move this.
Sure.
Okay.
So
Your objection's overruled, sir.
you understand the question then, Spencer?
And this is in regard to Mr. Barnes.
Understand that part. Okay. So let me put together what I think you're asking.
Okay.
You want to know if we have the name that's in the voter signature column, left column, on sheet number 6, line item 7, compared to the affidavit, which I've already told you have very poor quality. If I take that into consideration with the challenge name compared to the voter registration card signature, which we now know was 40-some years ago, am I suspicious? I'm less suspicious because of the factors that you have now provided. So if push comes to shove, I would probably say that this one should not be challenged.
Okay.
Okay, so that's different than how you answered me.
Well, you've given me more information. Now I know that it was 40-some years ago when the voter registration card was filled out. I also can see that this is a gentleman that has a lot of variance in his writing pattern over time, especially now that you've presented me with a recent signature, which, you know, I didn't have all those pieces. So that's why I have answered the way I have.
Okay, so are you saying that the signature on the affidavit and the signature on the petition sheet match? The same signature, same person?
They don't match. They have a similar variance, so put it that way.
Thank you.
Thank you.
So
Thank you very much, Mr. Spencer.
as an expert, can you be given 3 exemplars of a person's signature? And with professional, with your professional eye, say, these 2 match, but I have questions about the third one.
I'm going to object because that's not the standard.
What standard? The
Whether-
standard of looking at 3 questions? 3 signatures? It's a fairly simple question.
Could you repeat that question, please?
Given 3 exemplars of the person's signature and with your professional eye say these 2 match, but I have questions about the third one.
I don't know if he knows he's supposed to answer that.
Well, I think there's an objection to
Oh,
it,
there's
so
an
we're waiting for it.
I don't mind him answering. I'd overrule.
Yeah, overall.
This doesn't,
Mr. Spencer.
did you hear the question, Mr. Spencer?
Please repeat it.
Hold on. We'll try to repeat it for you. Can you repeat it for him? Or would you repeat it for him? Here's the microphone.
As an expert, can you be given 3 exemplars of a person's signature and with your professional eyes say these 2 match, but I have questions about the third one?
Not to be too basic here, but I don't think they're all 3 exemplars. What we're saying, as I understand it, as we define an exemplar, that is the known and authentic signature. What I believe he means is if we have 2 known and authentic signatures and we compare it to the third that's in question, are we able to determine that all 3 of them were written by the same writer? And in some cases that would be true, in other cases it would not be true.
That's not my question. So I'll ask it again. If you have 3 sheets of paper with 3 signatures on them and they're placed before you, are you able to say the signature on sheet A and the signature on sheet B are the same handwriting, but the signature on sheet C is not? If they all say John Smith, can you do that?
I've done that a number of times, yes, especially if we have 2 different writers, yes.
Okay. Have you found people's handwritings, their signatures to change over 4 months' time as a natural progression?
Unless there's some extenuating circumstances, a 4-month period, the writing pattern should be very simple.
That's all I have.
I have nothing further.
Are you, no other questions?
Sure.
I didn't hear, you said.
Sure, you want to give me more time? I'm done.
You're done?
I'm done. Nothing further.
Okay. Okay. So we can dismiss this witness. Any board members have any questions for the expert
Yes,
witness?
before Mr. Spencer leaves the screen,
I have none.
Mr. Kelly,
No, thank you, sir.
No, I don't. Thank you
Thank you.
thank you very much,
for your
sir.
time.
Thank you, sir.
Appreciate the opportunity to help you. Bye now.
Can we take a 5-minute recess?
Sure.
And as we do, what do you expect to have left? We're gonna take a 5-minute recess. What's left?
The argument.
There was an argument about 10-3.
10-3, and then you're going to rest, and I'm going to put a witness on.
Are you what?
I'm going to put a witness on. Yeah.
And an argument.
Yeah.
The surgery on Tuesday. Yeah.
That was just for 2 years. And it's been bugging me at night. And so I went back to the straps exercises and I've been shoveling. That's the worst thing you can do.
Oh, yeah. You got to stay away from that. If you're not too squeamish.
I'll take a look. What did you have?
Bursitis and the
Absolutely, the other half's inside.
But that's when it was really, so it was.
Some of them are there. So
What kind of dog?
It's the black
depends on where they have
And
it.
now.
What about farms?
Well, I
Farms
do have
already?
fish oil. Boy.
Well, then shouldn't he submit to say that, I mean, not all of them do, but if that had, oh, I just noticed that.
Half of a soccer ball. Okay, that's a baseball, of course, that was your arms.
Yeah, the whole thing swelled up.
Oh, boy.
Before
All
the
right, I'm not gonna
surgery,
complain then.
it was, but it's killing me. I went in yesterday and they drained it again.
Oh,
And luckily, it was just one, and it was clear with little blood in it. He said, his explanation was that we took all that out. So those layers of dermis and the skin are, stretchy, and liquid found its, water seeks its
Right.
the lowest levels,
Sure.
build up. And they keep telling me, keep this wrap on super tight. I'm like, yeah, but when you put it on super tight, A, it's B, it hurts, and C, they had it on so tight. with
circulation, that's not good.
And, he
You
said,
ever
well,
get
you
those
gotta
steroid shots?
no, the first,
Because you don't want too many of those. You know, I
Yeah.
had 2. I prayed for a 3rd, but they said, no, we shouldn't because it does other damage potentially. But because that's such a relief, but.
but when you do your, does it feel better?
Yeah, yeah. The
Well,
worst
the
is-
fire department did this, but they didn't do.
They only do part of us. They didn't do it. No, got the machine
Yeah.
to do everything. They should be doing the whole site.
Really?
And,
Yeah.
I called them today because I was getting pains. And I said, look, I'm a 56-year-old guy. I have shooting pains.
Your children did that, like.
And I walked through it, they tell me what to do.
Yeah.
And they're like, take your pain medicine and come in on Monday like you're supposed to.
Yeah, well, it made me feel better. I'm not gonna complain, Jesus.
Now,
So
the
how
only
did it-
problem is,
That's when I had to small hit.
Yeah, the last thing you want to do is post where you live, you know? Don't do that. It's make it really easy for someone to find.
Those are the ones.
There it is. Nice. I like that one. That one's a little.
The other guy.
Are we ready? Cool.
Anybody here? Yep. Recess is over. We're reconvening. Do you have any other witnesses at this point?
No, we don't.
Rest.
Yes. Well, I mean, is it appropriate to rest without the arguing those other points, or do you want to just come back for those?
You
Which
rest
one?
on your witnesses,
On my
but you're
witnesses.
gonna argue, for
Okay.
sure.
Okay.
Yeah.
I'm ready to proceed. I have one witness to call. Bonnie Bumiller to the stand. Where would you like the witness? I could put a chair.
Wherever the court reporter can hear the rest. Are you comfortable there? I can move.
I could leave.
Just sit here. Is she gonna refer you?
Yes, I'll approach the exhibits.
Steal the microphone. I'll turn it. That's it.
Is it plugged in?
Are you muted?
Hello,
That works.
it's on?
Yeah.
So, swear the witness.
This is here.
Yes, I did.
Can you please state your full name for the record?
Bonnie Bumiller, Bonny. Bumiller is Bumiller.
Ms. Bumiller, can you tell the board your educational experience?
Yes, I'm an Illinois licensed attorney in good standing, current active status, and for the purpose of today's hearing, I'm also a notary public.
Ms. Bueller, have you ever worked in the area of election law?
Yes, I've been doing it since about 2002, 2003.
Are you familiar with the process of the objection challenges to people's signatures and to registration?
Yes, very.
And are you familiar with the process of either rehabilitating signatures or proving that signatures are genuine?
Yes.
Now, Ms. Bueller, were you asked by myself to do some work in this case?
Yes.
I am going to, why don't you tell the board what your understanding of the work that you are going to undertake?
I was presented, among other things, with a PDF document that was approximately 120 pages long, and it consisted of paired items of affidavits, which we sought to achieve from voters to prove that their signatures were genuine, followed by the matching petition page that their purported signature corresponded to. And there were about approximately 60 pairs of these items. And I was asked to print these out and staple them in pairs, which I did. So the original should have staple marks. And I made a map of Blue Island on Google Maps and dropped pins in these 60 points to most efficiently map out the locations of the voters' homes.
Did you understand that these 64 approximately affidavits came from a Rule 8 motion filed by the objectors?
Yes,
Okay, and I'm going to show you, I'm going to show you Ken's exhibit number 42. Recognize this to be the PDF file that you received.
Members of the board, two of you have the complete book, and then, Judge, you have the.
yes,
The blank ones at the back.
yes, I do.
And is that a true and accurate copy of the PDF file that you received, the print version of that file?
Yes, to the best of my knowledge, it appears to be, yes.
And did you also receive a blank affidavit that you could fill in?
Yes, I did.
I'm going to show you what's been marked as candidate exhibit number 41.
Yes, in the loose leaf. Exactly.
If you recognize that to be a fill-in affidavit that was provided to you by myself.
Yes,
Now, Mr. Bueller, did you personally yourself attempt to go to each one of the houses where there was an affidavit for a voter?
yes,
Okay, and were you successful at getting all the affidavits for all those blank affidavits that we have?
no, not, some people weren't home. Some people just didn't answer the door.
And so I have produced as Kenna's exhibit 1 through 37, which are signed affidavits, and your name appears as the notary public on those affidavits, correct?
Yes, I got 37
Okay. Now,
affidavits.
can you explain to the board the process you use with each one of these affidavits before you notarized?
Yes, I wasn't alone. We had a driver. I was with Mayor Candidate Vargas, and he and I went. We had a driver who navigated and did the GPS, and then we would approach a voter's home. Mr. Vargas did most of the talking because he personally. Mr. Vargas would knock on the door or ring the bell and introduce himself and explain that the voters asked if the person was at home. And once the right person came to the door, he would tell them that their signature was being challenged and would they mind signing an affidavit to verify that it was really them. We asked them for their driver's license, and they showed it. And after that was established, I watched them. Oh, and Mr. Vargas would show them the second copy of the petition, of the stapled set, which was the petition page number and line number, that their signature was being challenged. They examined that and said, yes, that's my genuine signature, and I intended to nominate you. And then I watched them sign the page. I did not, and I also had them sign my logbook of notarial acts.
Okay.
I did not stamp and date in front of the voter. I just did that back in the car.
Okay. Did you have a clipboard with you where the affidavit was on a clipboard?
Mr. Vargas had the clipboard for the page because that was just one sheet, and my book is a little bit rigid, so I just used that.
Okay. With regard to each one of the voters that appear in Exhibit 1 through 37, did you personally view their driver's license?
Yes.
And were you able to, when I say driver's license, was a driver's license that you recognize to be a form of government identification?
Yes.
And the person that presented the driver's license was the person that appeared in the photograph?
Yes, that's correct.
And with regard to each one of the 37, did you make an entry into your book of notarial events?
Yes, sir.
Okay, and I'm going to show you what's been marked. I believe it is exhibit. It's exhibit 40. And it starts at page 3. Goes to page 4, and then on to page 5, correct?
I'm not sure. I don't have the document you're
Okay,
referring to, but.
Let me step up. You have your original book in front of you, correct?
It's the journal.
What I have. You said exhibit 40,
It's exhibit 40.
it starts there, and then that's 40, page 1.
Yes. Yes,
Looking at exhibit 40, page 2.
yes,
Exhibit 40, page 3.
yes,
Exhibit 40, page 4.
yes,
40, page 5 has 2 signatures on it.
yes.
And then there's a 6th page, Judge, that's the first page of the exhibit 40, page 6 has 2 signatures on it.
Yes. Yes, I recognize that as a true and accurate copy of my notarial book.
Okay, so on the first page, which is actually page 3 of exhibit 40, it says page 3 in the upper left-hand corner. It shows that on February 12th, 2021, that you went to visit 9 homes based on the entries 1 through 9. Do you see that?
Yes,
And is it your handwriting in the column, date notarized, type of notarization, document, a date of document, and type of document?
yes,
Okay, and then with regard to the printed name and signature, is that the printed by you or is that by the voter?
the printed names were by me. I printed the name in, and then I wrote a little X up to the right of the slant line, and I showed it to the voter after they signed the affidavit. And I said, can you please sign next to the X?
And then you also have the address, and so these pages go together,
Yes,
right? It's a full open book.
yes,
And then it says detailed identification of individual. You have driver's license,
that's correct.
and then you put fingerprint and other information, and you listed petition for Mayor Domingo Vargas, correct?
Yes.
Okay. And did you charge a fee to notarize these?
No, I did not, and I wrote zeros in the far right column.
Okay. And did you charge a fee?
Gotcha.
Okay. And did you do the same process for each one of the 37 people?
Yes, sir.
Okay. Was there at any time that you were suspicious in any way that the people that presented you the driver's license were not, in fact, the individuals that appear in that driver's license?
No.
Now, how long did this take you?
Oh, each date probably took a minimum of 4 hours,
Okay, so we have you doing this on,
sometimes 5 or 6, you know.
so on February 12th, which is a Friday, how many hours did you spend?
I'd have to look, but it would be between 4, 5, 6 hours,
And then on Saturday, February 13th,
probably 6 hours, 5, roughly, I'm saying 5 or 6 on Sunday, and then probably 5 or 6 on Tuesday. It was a total of 4 days.
and then on page 4, we have starting on box 1, we have Saturday, then we have Sunday, and then Tuesday. And with regard to the affidavits, at any time after you staple them before they were signed, is it correct that you presented to the voters the petition sheet attached?
They were always stapled for the voter. They never came unstapled.
And I'm going to show you the originals of exhibit 1 through 37. And I have these in 2 groups. There's going to be the one group of the originals where the expert has not testified at all about, and then I've identified the ones where the expert has offered testimony with regard to those voters. And so with regard to the ones where the expert has testified, Candace exhibit number 9 is basically an affidavit of Timothy Barnes, goes to Objectors Rule 8, number 20. Can's Exhibit 12 goes to Objectors Rule 8, number 23. Can's Exhibit number 16 goes to Objectors Rule 8, number 28. Can's Exhibit 24 goes to Objectors Rule 8, number 46. Canon Exhibit 25 goes to Objector Rule 8, number 48. Canon's Exhibit 30 goes to Objectors Rule 8, number 53. Candidates Exhibit 31 goes to Objector Rule 8, number 55. Candidate 36, Exhibit 36 goes to Objector Rule 8, number 62. 62.
Can you read the first three off again? You were going pretty fast.
Sure. Candidate 9 goes to number 20. Candidate 12 goes to number 23. Candidate 16 goes to number 28.
24 to 46.
Correct.
25 to 40, candidate 25 to 48,
Yes,
candidate 30 to objector 53,
correct,
candidate 31 to objector 55,
correct.
candidate 36 to objector 62.
Now, Ms. Buemiller, did any of the voters let you into the house to sign?
Sometimes.
Okay. Was it done on a clipboard where they put it down on a table?
Mostly we stood at the door, but it was pretty cold and snowy most of these days. So sometimes the voters said, come on in. And sometimes they wrote on their own desk.
Okay.
But mostly they used the clipboard.
And with regard to these signatures that appear on the affidavits 1 through 37, at any time, did any person other than the person listed in the affidavit, and you verified their identification to be that person, sign the affidavit for that person?
No.
And is it fair to say that you witnessed each one of the 37 affiants sign their name in your presence?
Yes. And the only one that I would have had any possibility of confusion was the Gardners, because there is a Scott the father and Scott the son Gardner, and we got both of them. They were at candidate's objection, well, I guess 55, one of them's 55, candidate objector 55 on page 18, line 7. And then again, Scott at objection exhibit 56 at 18, line 8. There are two different Gardners, and the father's in his 40s and the kid's in his 20s. And I verified.
So you wanted to make sure that they signed the right petition sheet?
Yes. And I asked them, which one of you signed 7? And then I gave him the right affidavit, and which one of you signed 8? And I gave him the right affidavit, and I wrote father and son in my logbook.
I am going to show you the original affidavits that are all marked in the condition that I received them from you. These affidavits at any time was the second page exhibit A removed from the original affidavit?
No, I stapled them and they were stapled when I turned them in.
Ms. Buemiller, with regard to exhibit number 40, is that a true and accurate copy of your notarial acts or event book that you maintain in the ordinary course of serving as a notary public?
Yes, as Mr. Carey Horvath is presenting it to me, yes. Yes.
At any time, did any of the voters in those 37 affidavits, when you showed them a petition sheet, say to you that that's not my signature?
No,
Did any of the voters say that someone else signed my name?
No.
At this time, I would move Exhibit 40 into evidence and Exhibits 1 through 37 into evidence.
If I may, just for a moment, ma'am, if I could just take your book, Exhibit 40, just to show it to the members of the board. This is Exhibit 40. It's the document that is witness recovery. It's candidate Exhibit 40. Excuse me. These are candidate exhibits
1 through 37. There's
1
two.
through 37.
You asking us to admit the book in evidence, but return it to the witness, and we'll rely on copies then?
Please, of the relevant pages.
Yes, but as far as the exhibits, rather than admit the entire packet into evidence, I think we should stick with the affidavits that we're dealing with on our Rule 8 motion. The other ones have no evidentiary value here.
I believe they do. And I'll explain.
May I ask the witness a question?
Sure.
In your book, I noticed that you go from 2012 to 2013, 2014, and it goes down to 2021. You don't record everything you notarize, right?
I probably didn't notarize much in that interim.
You didn't notarize anything in 2 years or 3 years, or?
That's possible.
Ms. Coleman, I'm sorry, what? Oh, you're looking at the book, not this.
These
Okay.
are the affidavits in the form presented. Those are candidates 1 through 37.
I'm looking for a particular one that's of interest.
Which one? They're not in
Oh, I see, they're not in.
they're not in order, but which one are you looking for?
I was looking for the gardeners, but that's okay. I've got the page here.
I should say, they're not in the mirror.
They may be in objector's exhibit order.
How about it? You need a Band-Aid?
No, I've got,
I've got one in my briefcase.
no, thank you, yeah, I brought one, but I wanted to have get air and,
You need some paper towel?
no, it's not bleeding, thanks.
Did you notarize them on, did you actually notarize them on the same day that you got the signature?
Yeah,
Did you notarize them on the same day you got the signature?
yes, I did in the car, but not in the presence of the voter. I just took them back to the car where it was warm and did it in the car. So you should have 4 different dates.
Well, I see the 13, 14, 12, 16.
That's it.
Scott, did you want to, see the?
Yes, please, just for a second.
Oh, sorry.
It's not all bloody, is it?
These are the affidavits.
Just 1 through 37. 37.
Yeah.
Okay.
I am offering those.
And I am objecting.
Pardon?
And I am objecting to the affidavits.
Members of the board, uh, candidates exhibits 1 through 37 and 40 have been offered into evidence.
You didn't object to 40.
Which is the
Notaries.
the book.
Okay. There's an objection to 1 through 37.
Okay, so let the record show that candidate exhibit 40 is admitted into evidence.
I think we need to motion on that, don't
Okay,
we?
wait, or has been offered into evidence, and have a motion to accept candidate exhibit 40 into evidence.
So
At this point in time, moved by Judge Bertucci,
I'll second on the notary journal.
second by Mr. Kelly. Roll call, Judge Bertucci.
Yes.
Ms.
Yes.
Swalman,
Yes.
Mr. Kelly. Does the record show candidate exhibit 40 will be admitted into evidence? I'm going to return the original with the understanding that the copies that have been presented to the board and myself are true and correct copies of the original document. With respect to, excuse me, candidates exhibits 1 through 37, they've been offered into evidence. There is an objection pending. Do you have anything other than to say in support of the objection other than?
If he would like to introduce the affidavits for the items in our Rule 8 motion, which is what we're here for, that's fine, but the rest of them are irrelevant to what we're doing.
They all relate to your Rule 8 motion.
What? I didn't hear you.
They all relate to the Rule 8 motion.
They relate to what we've placed before the board. So the Rule 8 encompasses everything we could preserve to give testimony on. Okay, so we've given evidence on a limited number of items. So to the extent that he needs affidavits to counter those are the ones that should go into evidence.
So you don't want us to accept the other Rule 8 objections?
Yeah, only the items from our Rule 8 that we presented evidence.
Those are the only ones you want us to consider?
Yeah.
Okay.
Well, I would object to that. And the reason why is, and this goes back to the issue of genuineness of signature or signed by someone else. That is the testimony that Mr. Casper elicited from their witness, that these were signed by someone else. And, you know, while he only identified 12, and I think now down to 11 signatures, or maybe even down to 10, the issue before is that there seems to be some inkling here that this expert is testifying that some fraudulent conduct went on. And the issue is, and I raised it, is if you're going to allege fraud, they didn't. Are they going to say, listen, we proved fraud because it jumped out of you, jumped out of the papers during this matter, and that's a clear and convincing. And take account that it's raised issue. I raised this issue.
And those issues were raised for the limited number of evidentiary items that we submitted.
I suggest we allow the admission of it all and we'll give it the appropriate weight and take, into consideration. You give it limited consideration.
Okay,
I may have cut you off.
okay, I think you should have no consideration.
Right.
Mr. Lezinski, the candidate's trying to create a Rule 8 that they didn't file and then submit all of this evidence to somehow counter the expert. We presented evidence through the expert and through our affidavits on a limited number of sheet and lines that we put forth. Now, it's very common, as you know, that you create your Rule 8 motion, you capture everything that you lost. And then you winnow that down because of, time constraints and convenience to everybody. And say, okay, you know what, we preserved everything, but 9 out of 10 of them, we don't want to do anything. 1 out of 10 of them, we presented evidence, and that's what Mr. Ladazinski is now limited to.
I don't see that they alleged a pattern of fraud in their objection.
Right,
They didn't allege a pattern of fraud in their objection.
right.
So,
You're right about that.
and you're not arguing there's a pattern of
Well, but the testimony that was elicited from this expert is that the people that are the petition signers did not sign. Someone else signed these petitions. It's much different than genuine signature. And it was Mr. Casper asking those questions of the expert witness who testified that those signatures are not the signatures of the voters.
okay.
Is there a situation where someone says that's not the true signature of the signer that is somehow different than fraud, or some, that doesn't involve fraud?
So that's exactly why.
The A only means that it was not genuine.
Right.
And this is an argument that the candidate wants to drop into our Rule 8 motion, and it's not there. If a pattern of fraud, as opposed to a single indicia of fraud, presents itself, then according to the case law, the board doesn't turn a blind eye. But that's where we're at. We have not, the fact that he wants to call this fraud and that we didn't plead well, or he gets to rebut that evidence with all of these other affidavits that don't bear any relationship to the evidence that we presented in our Rule 8. They're superfluous, and the fact that they carry zero weight towards what we're talking about means that by definition, they're improper.
Board counsel have an opinion on the matter?
My opinion is that they should be admitted as a group exhibit, 1 through 37. And you as a board, as you did with respect to the affidavits submitted by the objectors, you give them the weight that you deem appropriate with respect to each and every one of them. However, if you recall Mr. Casper's initial remarks, when he was talking about whether it's genuine or whether it's, I'm not sure if he used the term fraud. I think there's enough to substantiate what counsel is offering them for. If you want to, in reviewing them, give them no weight whatsoever. It's entirely up to you.
But the evidentiary value of these extra affidavits have nothing to do with the individual signatures as to whether they're proper signatures. They're prejudicial just by the fact that he's trying to submit them. They don't go to anything that we raise.
I certainly wouldn't be prejudiced by them. The witness testified about the procedure she followed over a period of 4 days with Mr. Vargas, and she presented all the affidavits she got as a result. Some of them go specifically to what your expert testified in Rule 8. I think it was down to 11 or 12. And others are, there's more because there are 36 total. But I don't see prejudice at having them admitted, these exhibits admitted that the witness testified about. And we will know which ones go to your Rule 8. And I just don't see a problem with them.
I think the proper process is that rather than admit everything and then ignore what doesn't have to do with my Rule 8 evidentiary hearing is upside down. We've presented evidence. If he wants to submit rebuttal evidence, then he needs to submit rebuttal evidence to what we've put before the board. Not extraneous and extra evidence for the board to consider and give weight to it, because it shouldn't be before the board to give any weight to it one way or the other.
Well, I mean, it was just part of her conduct with the person she was out there with, Mr. Vargas, in getting various affidavits signed. She would have had even more, she said, except people weren't home and so on. You're limited, just as you were limited in how much your expert was gonna do. And so she presented to us what they got. I just don't see any prejudice from having.
Her testimony established that.
Pardon me?
Her testimony
Yeah,
established
no
that. We don't
question,
need
and that's
any.
why I don't think admitting them then is prejudicial in any way. It wouldn't affect the board, I'd imagine, in any prejudicial way. But that's my thought on it. Board attorney seems to agree.
I would admit the group exhibit.
Mr. Kelly
I
said
would
he-
admit the group exhibit of the affidavits.
I would admit it, but I'd also note that the ones that weren't subject to dispute ruling today really don't need, the signatures don't need to be rehabilitated.
Well, I would only make a limited exception since we've had a witness testify. I've learned by looking at the petition summary report, the county clerk's employees made an error. Scott Gardner, father, had his signature overruled at page 18, line 2, and the county clerk brought up the clip of his son. So that's a signature that should be credited to the candidate. They shouldn't suffer for the mistake made by the clerks at the election center in Cicero. They didn't bring up the right handwriting exemplar,
Also, they
so they
sustained,
ruled on the son rather than the father.
And that burden is upon them to file a Rule 8 motion and bring that signature up, not for us to go through after the fact and look for signatures that might be good. That's exactly why these affidavits don't belong in the record.
But it's here and the witness has testified, and Fortis versus Dixon tells me that if it comes before us, I'm not supposed to ignore it just because the formality wasn't absolutely correct. I mean, I'm just seeing that right now, looking at the petition detail report.
I don't think that's what Fortis v. Dixon says. I think that the candidate, just like we had, has a burden of preparing and filing a Rule 8 motion and presenting it to the board and asking for an evidentiary hearing to present evidence. Just like we did.
It was challenged and sustained as an invalid signature, but we've had testimony here from the notary public who gathered the affidavits that there is a father and son and of different ages, obviously, but they keep showing the same signature. The clerks don't show that there were two Scott Gardners.
Right.
They keep using the same signature clip for everybody.
And the candidate had their opportunity to raise that issue. The board can't ignore a pattern of fraud, but they're not permitted to just, sua sponte, amend the candidate's file.
Well, it's just a single signature, and I just think it's the equitable thing to do.
These cases come down to a single signature all the time. And the equitable thing to do is to have all the parties, follow the rules.
Well, I would make a motion that we admit, if I hadn't already, the group exhibit over Mr. Erdman's objection.
I'll second that.
And then if we could hold off on the Gardner question to give the parties a chance to think about that.
I know what I think, and I'm pretty
Well,
sure I
I'm
can guess
just
what
saying that
Steve
at
thinks.
this point, we have in front of us, admitting these or not, and we can take them separately right away if you want, but, my motion is as to that.
Okay,
And I think you seconded that.
I'll second your motion to admit the 37 affidavits.
There is a motion and a second to admit the candidates exhibits 1 through 37 inclusive, made by two members of the board. Roll call, Mr. Kelly.
Aye.
Judy?
I would caveat that I don't, I think we don't need to deal with the Gardner unless it comes down to one signature. But with the caveat that we don't need to really look at the Gardner signatures unless it comes down to one signature.
That's understandable.
Yeah.
Judge?
Yes.
Well, I mean, that means that we're using it, so. But let's ignore it unless it's important means that we're gonna deal with it. So that's not really a.
No, it doesn't. Okay.
Let the record show that the exhibits 1 through 37, candidates exhibits 1 through 37 have been admitted into evidence as part of the record in this proceeding.
I would also move,
Do you have, oh, I'm sorry, you have cross-examination.
Oh, are you done?
I'm going to move candidates exhibit number 42 and 43 into evidence. Which are the affidavits, the blank affidavits that she testified about, and the one I say blank, they're not signed. And then 43 is the fill-in affidavit if she needed to use that.
And I would absolutely object to that. There's no evidentiary value to them as far as somehow rebutting the evidence that we've produced on the limited number of sheet and lines that we've attacked here.
What's the point of this?
Mr. Ladizinski, those documents, those were the blank documents?
Correct.
And those were, if I'm not mistaken, those were testified to by
Bumiller.
by Mrs. Bumiller to establish what she was presented with from Mr. Ladizinski, and then what she did with those documents when I think she went to the door with Mr. Vargas, if I'm not mistaken. So for that purpose, you can admit them, but they have no other,
I see no relevancy. They're not signed,
they would be very limited to what you know.
and I don't see the point. It's not, you can't admit them to rehabilitate or anything. They're just blank.
Those are all blank.
They're all blank. I would motion to not accept them. I don't see the purpose at all on this one.
So the witnesses testified about having received these affidavits in blank, and many were signed and many were not for various reasons. So the testimony about it's in the record. I don't see a problem with having the paper blank affidavits in the record, but they don't assist either side. They not anything we could give any weight to or consideration to. It just, in a sense, I guess, completes the record with the paper that she testified about. So I don't see a problem with admitting it personally.
I had to use, does it matter?
What? So, I agree with Mr. Horvath in terms of admitting him. It completes the record, but I don't have any strong feelings either way either.
I'm sorry.
You're right in terms of evidentiary value. It's just the documents that were testified about, and in a sense completes the record, but
I don't believe it completes the record. Ms. Bumiller testified as to her process, as she's free to do, on direct.
Sure.
And
this
and
just
it doesn't
represents
need-
the documents she testified about, but I agree, they don't have signatures, they're not part of your Rule 8.
Blank
So I feel
document.
strongly either way.
So I don't think we need to admit blank documents prepared by the candidate that serve no purpose whatsoever into the record. There's no reason. I can see the argument on the group exhibit because they're in there, but here we have two exhibits that have nothing to do with the evidence that we put forward in our Rule 8 presentation. Nothing.
Mr. Ladizinski, do you have anything to add?
I'm not going to try to prolong this. Well, however the board rules, the board rules.
The witness testified to her procedure. She testified that she utilized blank documents as part of what she was doing. The documents as blank have no evidentiary value whatsoever. So the board does not want to admit them into evidence. It's not going to change this case one way or the other, since we're looking at the signatures themselves that are on the petitions.
And I
don't
haven't,
have strong feelings either way about it.
and I haven't questioned her process that would somehow, create the need for her to show, blank documents that she might have used given the chance.
Sure, and you haven't cross-examined her yet either.
If he cross-examines her questions.
Right, I mean, on the other hand, we could have moved to admit them subject to cross-examination or wait till after the cross, but we'll deal
Why
with it
don't we
now.
do that? We'll wait until after the cross if they're not utilized in some fashion to
That makes sense.
challenge that portion of her testimony, then as a board, you do not have to go into that because they don't have it. So, with that said, we'll just defer on that. Mr. Erdman, it's up to you now.
Oh, I'm sorry, was there another exhibit after 42?
It's 43. It's the one page. It's kind of a fill-in affidavit. Once again, it would fall in the same caveat with regard to 42. It's blank.
Is it at the end?
I thought I saw it earlier.
I see blank.
It doesn't matter. We could move on with the testimony.
I don't think I had a 43 in my.
No.
That's 38 and
Can you
39.
show us what it looks like?
Is it on the, Ms. Bumiller, is it on the table there?
Exhibit 43.
Or maybe 41, I may be
I have
off.
a blank exhibit 41.
Yeah, that's what it is. It's 41. Sorry, I apologize.
And that's. Has everybody found it?
Yeah, did you object to that one?
Yes.
Which is 41 on
It looks like this, Judy.
41 is just a blank affidavit.
Oh, it's the same thing as the other. It's the same 40,
Sorry. Yeah, this is the shoulder.
it's
Just a-
42,
It's
whatever.
just a
the-
template, yeah.
Yeah, it's a template. I don't see
Yeah.
any reason to admit it.
Now, we did admit
We admitted
1 through 37 over objection,
Right.
but certainly we won't reconsider that based on the cross-examination.
certainly.
So, my motion was subject to cross, obviously. I don't know what would come out in cross to make us reconsider, but that's exactly right. I don't know, do I? So I won't prejudge that.
But whether I live up to that.
Yeah.
Just give me 1 minute, Scott, please. Sure.
Actually, it wasn't like
Just want to make sure I have everything in order.
Mine are not.
So 40 was her book, 41 were the blanks.
Right.
42, what was 42?
It's the big stack of the affidavits. The 41's the one page, kind of a fill-in.
Okay.
The 42 is the blanks, 41 is blanker than the other ones, right?
41 is blanker.
Okay, I got it.
More blank, I
More
prefer.
blanket.
More blanks. And then 38 and 39 were,
I didn't use those.
you did not use that.
Did not use
Okay, so 1 through 37, subject to cross-examination, has been admitted, and 40 has been admitted as candidates 40 and candidates 1 to 37 have been admitted, and now it's cross-examination.
Hello, Bonnie.
Hi.
So you testified that you presented the affidavits to each of the signers from the petitions and they completed it, correct?
They signed on the signature line.
Okay. And then you signed somewhere else at a different time?
After we left their home, we went back in the car. We were driving around in a car. And I stamped them and I signed immediately after leaving the voter's home in the backseat of the vehicle.
Thank you. That's it.
Just to be clear, Ms. Bumiller, each of the affiants signed the affidavit in your presence, correct?
Yes, they did.
I have nothing further.
Mr. Urban?
Nothing. Thank you.
Lasinski, you finished?
I'm done.
No other witnesses?
No other witnesses.
You rest.
I rest.
You can get back my seat. Thank you very much, Mrs. Hugh Miller.
Thank you.
Did I have the originals of 1 through 37 and tender back to the witness number, the original number?
Mr. Horvath, I did keep the affidavits separate that were addressed by the handwriting expert.
I'm sorry, what?
For the board's convenience, I separated the signed affidavits related to the expert's testimony.
Oh,
They were in a short stack.
In 1 through 37?
Yeah, I pulled them out so they were by themselves.
was
And
that number 9?
Yes,
12?
Yep.
And they're clipped together.
they're clipped together.
And
24, 25, oh, that's what's clipped together.
Correct.
And those are the ones that I think are appropriate to be moved into into evidence, because the other ones have nothing to do with my Rule 8 motion and the evidence that I presented.
Thank you for telling me that. I was wondering why they were out of order. So,
I didn't want the board to be fishing through the stack.
so now, you're finished. You're finished. Members of the board, do you have any
Do we
questions?
want to hear arguments on the 10-3?
Do we want to deal with whether we're entering that into evidence before we move on while that's all
Oh.
fresh? Do we want to deal with what gets entered into evidence? That the final objection that hasn't been addressed is the portion versus entire.
Yeah, I mean, I ultimately did indicate it was subject to cross. Nothing came out on cross that would change my mind. I have no strong feelings about it being admitted or not. It's just, there was a motion to admit all those exhibits, the witness testified about them, and I felt it was appropriate to admit them. And as I say, nothing came out on cross to change that. I don't know about my fellow board members. The board is certainly not going to be prejudiced by any of those documents that she testified about that we've admitted.
I would admit the exhibit. I would admit the exhibit.
Mr. Kelly said he would admit the exhibits.
I would admit it with the caveat again that there's really little or no weight to the ones that weren't disputed.
So they 1 through 37 will be admitted. Candidates 1 through 37, exhibits 1 through 37 will be still admitted as part of the record into evidence.
I think we need arguments on the signing of 2 petitions.
And the what?
Signing of 2 petitions. We hope that-
Yes.
7, 10, and 10-3 if you like.
I didn't get a chance to finish reading Mr. Casper's presentation.
Okay.
Could I take a few minutes to read that?
Yeah.
I could paraphrase it for you. We're right.
Well, I know that already, but I just want to read it. Just
Or you could read it. I'm gonna.
There's one part I want to look at again too. It's
we could take a short break and 5-minute recess, 10-minute recess. Okay.
10 would be great.
Let's see. Where did it go?
I just read it on my phone if you want it.
Here, I've got it. I found
Okay.
it. Okay.
Yeah. Yeah. No, I'll stop at the office. I have to. I don't think you was to come to the lake house.
Oh, let's see. There it is.
Oh my God, that's a
Turkey,
big,
ham, and cheese, lettuce.
is that 2 or 3 slices of bread?
3. I'm trying to give up bread. So I was in the store yesterday, didn't buy any bread.
So you're using it up?
You know what, I don't want it too painful on the way home. We're not gonna drink the V8.
What do we think another hour? We're gonna think another hour, half hour?
Probably half.
You know, if you get written a check from Chase and you go in to cash it, they charge you a $6 fee if you're not accountant. And like rang the little bell back to the law school, and I said, no, this is a negotiable instrument. And if I present it for payment,
Right.
and there's funds there, you need to give me the money.
And it's a Chase account.
Yeah.
It's just that you're not a member.
Right.
Well, that's not, yeah. That's a
So
good
I'm
point.
thinking,
Are you
this is
gonna
a
do
room
a
full of brilliant attorneys. Let's
class
can you
action?
imagine how many times they charge people $6?
Everybody ready?
I guess.
Yeah.
Too easy.
Okay. Scott, you're up. This is on the argument on the
Then Steve's up.
duplicate,
Then Steve is
or
up.
excuse me,
He's
signatures on
Right.
one petition or the other, or excuse me, both petitions, excuse me.
Right. So I believe that Steve's up because that's
You
he's the one
objected
who
to it, Steve.
objected to our.
I mean, you want me to discuss the brief or the memo that Mr. Casper filed, or?
Right, he filed one and you didn't file one.
I didn't file one because I didn't have the opportunity while I'm sitting here to do that.
But what he filed matched his argument.
Yeah, and I mean, my 10.3 deals with independent candidates. That's all it deals with. You know, it doesn't deal, it says, if you look right at the top of the act, it says not candidates of any political party. So this is signing another independent candidate's petition, which is consistent with the city of Chicago does when they have their elections for, aldermen.
But you're reading the title of 10.3?
Yeah.
But then when you read the body, it mentions individual, doesn't it?
It doesn't say individual.
What's it say? I don't have it in front of me.
It says each voter signing a nomination paper shall add his signature, his place of residence, and each voter may subscribe to one nomination for such office to be filled and no more. For independence.
What?
For independence. I mean, I don't believe everyone's trying to read in other words, office of any party, that type of stuff. And my position is no.
Do you want to see the code?
I like
Yeah, I didn't bring my code.
There's a copy of the code.
Thank you.
I marked it, so there's the entire section. That's what you just read.
One moment to read it again.
And you have a copy of the code.
So, if I understand you correctly, Ms. Lozinski, you're indicating that when it's, and I'll read in part, when 5/10-3 reads, and each voter may subscribe to one nomination for each office to be filled and no more. You're saying that applies to independent candidate petitions because that's the title of 10-3.
Correct.
If that's what they wanted to
Limit it to?
to limit it to, then they would put, one independent candidate. Because the mirror with parties is the same process, is that you don't get to sign for two. I'm sorry, the mirror with the mirror. I think the mirror of it is that a Democrat can't go sign for a Republican afterward, and in those situations, and that's not what they say here.
Except this is not an established party issue, because if you take a look at new party, there's no such language.
This statute says what it means, and I think if you look, you'll see that it says office, and it dwells on office. So,
It does say office.
So that's what they're talking about.
I wondered if you have any thoughts on the subject, or my colleagues here on the board. Because I think we've heard all the arguments.
Well, I think it looks like, and of course, in his short brief, that the Chicago Board of Elections has consistently ruled that where a petition signer signs for more than one candidate, then the first signature in time is valid. And we know that candidates in Chicago don't run on party lines. They're basically all independent. But they don't really, just, it's hard. They don't make a distinction. Yeah, I'll note that he cited quite a few decisions from the Chicago Electoral Board where it said that where a petition signer signs for more than one candidate, then the first signature in time is valid and all subsequent signatures are invalid. Again, this is a unique situation where it's independent versus a party, but there's really no cases that deal with this specific situation.
And I would say, absent the extraneous case law, you look at the statute and read the statute for its clear and plain meaning, and it says what it says.
If you ask my only comment is, while it says each voter signing a nomination paper may subscribe to one nomination for such office to be filled and no more, it doesn't say anything about any type of penalty associated with it in the statute now.
Right.
And there's been no case decision, so I don't know, at least that I'm aware of.
So
that's all I'm saying.
Okay, so giving the assumption that you're only allowed to sign for one party, then you look to other case law, and other case law says, well, the first one. And that's not only enshrined in Chicago's case law, it's common sense.
Do you have access to internet here where we could look up a case site?
I'm sorry, what?
Internet? Do we have access to internet? I've got a case site, but I don't want to jump in.
I can try.
I don't want to jump in with just a head note,
In entirety that's applicable or not. I've been going through the book here trying to find something.
399 Bill 470.
Yeah, that's the state Supreme Court, but maybe it's more shade rather than
Remember how
illumination.
many signatures are in question?
That
11?
issue,
I think there are 12 by affidavit, where there's a question of whether, who signed what first.
It was 12.
That's right.
Pardon?
It's 12.
12,
He
and
struck
then,
one.
and then there are 12, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 were part of the rule. 8, is that right, Scott?
Yes.
So
yes.
total number in question, 23.
Right.
Total number.
Yeah, he struck number 9, 13, leaving 12.
I'll see if I can get this set.
While you're looking at that, back in January, but 126 signatures required after the binder check.
They had 76.
Clerk find, pardon me?
76, greater than the required minimum.
Right, 202, 76 more than needed. The Rule 8 involved 64, I believe.
Yes.
Yeah,
Of
but
which,
Not counting,
but with the clerk's number of good signatures was everything. They didn't apply the rule, the cap. We have to.
in terms of 10-3.
No, in terms of anything, any report from the clerk's office.
Yeah,
So we can't just say that the number on that report, that's how many he has over the required number of signatures, because that includes signatures that they ruled as valid beyond the cap. So they're
oh, I
piling in
understand.
extra
That's
ones.
right, that's
So-
right.
well, in the first 202 signatures,
Yes,
hold on,
there's a cap.
yeah, that's the cap. I think it's 202 is the cap and 126 is the floor.
Mr. Erdman, you think the cap was less? The valid signatures was 202.
Yes.
Required is 126. Putting the
126.
candidate 76 more over.
Yes.
But Mr. Erdman's saying
Some of those.
they didn't take into consideration the cap
Right.
by law.
The clerk's office
And if you'll
does.
wait
Right,
one
no, I
moment,
understand.
So
And that's what I don't have
if
written
you
down.
wait one moment, I have that. I just have
And
to.
that depends on how the rules of procedure are written, whether you cap
In
it
the-
or not.
At the end or beginning.
Right.
In the first 202 signatures, okay, there were 143 that were determined to be good, all right? And we can verify that count, but I did that calculation this morning. So the first 202 signatures, there were 143 that were determined to be good.
And how many does it need?
126.
And actually, my calculation has us that it should be out of the first 201.
Pardon?
My calculation has,
Well,
You round up.
the
You round up.
you round up, yes.
right, from 200.7 to.
I have my calculator.
And we're dealing with.
Some of the rules strike at the beginning.
120,
Yeah.
126 is 5% of 202. Excuse me, 2,520. Okay? 202.
And
It's 201.6, so you go to 202.
I understand that, but our number is 2509, not, I think you said
Well, the
25.
clerk said the signatures required is 126. 126 is 5% of.
We disagree.
2520. That's what, well, we can disagree all you want. That's what the county clerk has said is the minimum number. I'm not going to agree or disagree with what you have to say. I'm just saying that's what the county clerk has said in their petition summary report. And so 8% of that number is 201.6. So you go up to 202. And in the first 202 signatures, he has 143 that are good.
All right, what were the total number of ballots cast in the last election?
2,520, if I'm not mistaken.
2,509 with the official certificate of results from the clerk's website.
Well, the county clerk has indicated on the petition summary report, which is in evidence, that we have, the minimum required is 126.
Well, if it's 2509, 5% of that is 125.45. You round up on normally on 0.45 you round down, but I think since it's part of it, you probably go
Yes,
up.
anything on
So
the
you need
minimum and maximum.
126.
Right, and
So
then,
it seems like 126 is based on
126 is,
2509.
yes.
No, I want.
And we don't disagree about the 126.
right, but if that's what the minimum was, you have to use the same number to determine the maximum.
Yeah,
And
sure.
the certified results say 2509, regardless of what somebody from the clerk's office punched into
Okay,
a,
in the Rule 8 petition, in paragraph 5, it says, in addition, all signatures after the signature on nominating petition, sheet 23, line 1, should be invalidated. All signatures up to sheet 23, line 1, I think are 202 signatures, all right? So I'm not making this up. I'm just working with the numbers that we've been given.
Usually somebody tells the clerk how many signatures you need, and usually you're supposed to go by the official certificate of results, and that would be the ballots cast in the last election, and that was 2509. So we should be going by 2509 here.
Okay,
That's
so
why I've always done it.
126 required, the maximum is 8% of 2509?
Here's the max.
correct.
It would be 201. And if we were rounding up or down, 5% would be, 5% of 2509 is 125.45. So that would be 125. Right?
You round up, so 125.45 is 126.
126, excuse me. And then
8%.
And then 8%, if it's 20, what was it, 2509?
2509.
2509.08
is
200.72, so it'd be 201.
201.
Yeah, they put 202 on the petition summary report, it's 201. And under our rules, we're striking
anything over the 8%
at the back end.
Yes.
Because I had a case where it's
they went the other way.
The other way, interestingly.
That was Chicago Heights did that, I think.
Riverdale in their rules. And I guess the argument for that is, maybe you make mistakes at the beginning, and so if you're striking your earlier ones, you're probably perhaps doing a candidate a favor. Maybe more bad ones at the beginning, and I don't know what the thinking was, but in our case, it's the later ones, right? So, 201's the max. The clerk found 201 or 202 valid. But
They look at all the signatures.
Right. And Mr. Erdman has indicated it's 143 are really what the candidate here is valid. Do you agree?
Sure. I'll agree with that number.
And that means 17 over what's necessary
Correct.
before we strike or not strike any based on 10-3, which is 12 of them.
Yes.
If we, yeah.
If we could
If you
accept those-
subtracted 23 from 143, he'd only have 120. If we accepted the objectors, all of them.
Sure.
Okay.
And what you have is the 12.
We say we have, that he has 142 valid signatures.
I thought we just,
And, okay, it's just 16 over.
can we agree on numbers?
Yep.
Because he just asked me, was it 17? I said yes. And Scott said yes. Now he's saying it's 16.
Now I'm
Above.
saying 16, possibly.
Well, that's fine. Let's look, I mean, if I misspoke, then let's just look at the
17.
numbers.
All right, and so 12 are this question about when they signed.
Correct.
2 petition sheets, does it apply to independence and so on. That's 12.
That would take it down to 131.
Yeah, and that, so we'd be
That's only
fine.
if we,
Right. No, I understand.
And then the rest are based on the expert witness.
Yes.
And I guess we're ruling on one thing at a time.
and the rebuttal.
And
But it's our contention that he has 142 good signatures, not 143.
Your contention, what, 142, not what?
Not 143.
Not 143.
so that's 16, not 17.
So it would knock it down.
All right, well, let's do a count. I think that's the easiest way to do it, and take a look at the petitions. Or at the petition page report, and that's part of
Well, so,
Exhibit 9.
all right.
All right, so,
So step one would be to look to the petitions.
well, let's just look at the evidence that we have first, okay?
The petitions are in evidence.
I understand that, Scott. I'm saying let's look at the petition page report first. Then we can look at the petitions and make sure that the same amount are on those pages. We want to do this right. So let's just do it this way, okay? All right?
I want to do it
Thank
right
you.
too, Mr. Horton.
So we have on the first page of the petition page report, there are 14 pages identified. 13 of them have 10 signatures and 1 has 9. So that's 139 per the petition page report. On the second page of the petition page report, we have 4 pages with 10. That's 40. 1 with 9, that's 49. 1 with 8, that brings us to 57. And 1 with 5, that brings us to 62. 62 and 139 is 201. Okay? That's the petition page report. And what did we say was, we were using the number 201?
Yes,
Because it's 25, you said, Judy, you said it was 2509?
2509 was the total ballots cast in the last election.
Okay.
What's the number we're using for minimum signatures? Is that what you just asked?
No.
Okay.
No, we're using 2509 is the number we're keying off of. 5% of that is 126.
Correct.
8% of that is 201.
Correct.
Okay? Rounding.
Yep.
You know, 125.45.
I got it.
Okay, all right. So now we'll go to the actual petitions to verify if they match. Okay, and that's part 4 in the binder. All right, so let's see. Page 1 has 10 signatures. Page 2 has 10 signatures. Page 3 has 10 signatures. When I say page, I'm referring to the petitions.
Yes,
Page 4 has 10 signatures. Page 5 has 10 signatures. 6 has 10 signatures. 7 has 10 signatures. 8 has 10 signatures. 9 has 10 signatures. 10,
Well, no.
I'm sorry, 9 has 9 signatures, excuse me, which matches with the petition page report. 10 has 10 signatures. 11 has 10 signatures. 12 has 10 signatures. 13 has 10 signatures. And 14 has 10 signatures. So that totals 139, and it matches the petition page report, okay? With one page having 9, that's page 9. And if we go to page 15, that has 10 signatures. 16 has 10 signatures. 17 has 10 signatures. 18 has 10 signatures. 19 has 9 signatures, which matches the report. 20 has 8 signatures. Again, that matches the report. 21 has 5 signatures. That matches the report. So on pages 1 through 14, we have 139 signatures. And then on pages 15 through 21, we have 10, 20, 30, 40, 50, 62. That totals 201. We all in agreement? Is my math correct?
Okay.
Say it again, please. I'm sorry. It's late in the day.
139 on the first 14 pages, and then 62 on pages 15 through 21.
I'm sorry. The second half is for page 15 through what?
Page
21.
15 through 21, we have a total of 62 signatures. You have 4 with 10 pages, or 10 signatures, 1 with 9. That brings us to 49. 1 with 8, that brings us to 57. And 1 with 5, that brings us to 62. I think my second grade nun would be very proud of me.
She'd still hit you.
So, and the pages in the petition match up with the petition page report in terms of the number of signatures shown on each. So,
Okay, I got 142 valid signatures. If you go
Yes.
down to page.
how many do
21.
we,
What?
how many did you have?
142 if you add up all the valid signatures on the pages we're counting.
Yes, and that's,
what I did.
Oh, good.
That's what Scott says.
142.
If you don't mind.
7, 14, 37, 45, 51, 55, 63, 72, 82, 90, 100, 60, 25, 37, 42. I have 142 as well.
Does he get the first signature on sheet 22, or did you say we stop at 201?
Well, according to the, if you use 2,509, you would stop at
21.
0.08. You stop at 201.
Okay.
All right, so that would be page 21. the end
Okay.
of Page 21.
Okay, so the precinct report was off by one.
The
Detail.
summary was.
Yeah, the summary was off by one.
No, it's up.
Yes, I backed up on the summary. I didn't have what you have in front of you, the 2509. I just took what is 5% of and and then I took 8%.
And they don't necessarily look at results. They usually ask you when you go, they usually ask the attorneys, what are the signatures needed?
Lately, they've been doing we don't want to, my name's Emmett and I ain't in it, so they just do the whole thing and throw it back to the board to figure out.
Should we, since it's not in evidence, what were you reviewing there?
Oh, I'm sorry. It's the official certificate of results, Cook County Clerk's Office. We can do it, if you want to make an exhibit, April 4th, 2017
Well,
consolidated
if
election.
that's what we're using, I think we should, because it's part of.
You want to see that?
Do you have any objections?
I don't need to see it.
You don't need to see it? So why don't we do a motion to have this as board exhibit
Would be board exhibit 10.
10? 10?
Yes, 9 was the
judges?
Signature petition summary report with the
So you look at
clip
those, okay.
sheets.
Believe me, it's always, sometimes people look.
Which, is this computer working, Judge Verducci, that's in front of you?
I'm gonna try and see if I can get that.
Because you can go to the.
Well, I'd still move to admit this. It's the official, purports to be official certificate of results. 2,509 votes cast in the relevant election.
Motion by Judge Bertucci,
Second.
second by Ms. Why do I draw the blank, Judy? Judy
Just call
Coleman.
me Judy,
Second
it
by
doesn't
Judy
matter.
Coleman, please.
It's 5:30 already.
Just
Roll call.
Judy.
Judge Bertucci?
Aye.
Ms. Coleman?
Yes.
Mr. Kelly?
Yes.
Okay. I'm gonna need that, okay? So that. let the record
Mark
show.
that.
Official certificate of results for the election of April 4th, 2017, for the elected officials of Blue Island has been accepted into evidence as board exhibit number.
Is one enough? One copy enough for you, Terry?
Yeah.
Yeah, with the exhibit 10.
Based on all that, just to summarize then, 12 are in question based on having signed twice. 11 in question based on the expert's testimony.
Yes.
So that's 23.
23 total. And the 11 in question, there are affidavits by these people presented by the candidate.
Of the 11 in question, there were 1, 2, 3, 4, 5, 6, 7, 8 affidavits submitted.
Should be 9.
9, wait, 3. Okay, I had 9, 12, 16, 24. I'm sorry, 9, 12, 16, 24, 25, 30, 31, and 36. Was there another? Three. 9, 12, 16, 24, 25, 30, 31, and 36. Those are the 8 numbers that we were.
60 line 1. Carrie, is sheet 20 line 1?
Steve, these are the ones that are clipped at the top of that exhibit, right?
Yeah,
So we
but
can
I
look
may,
at that.
I may have not pulled that out, but it's.
There were 9, I count 9.
I have
Do you
9.
want the exhibits back?
Yeah, if I can go through those real quick, confirm.
Here. The ones that are clipped together are the 8 that I just went through, but you can go back through there.
And I'd like to isolate the 2 names that you don't have affidavits for, but the expert testified about. Right?
The,
You say you have affidavits,
Timothy Barnes, he testified about.
pardon me,
Timothy Barnes was one of the people he testified about.
without an affidavit.
No, he has an affidavit to.
There's three that only have expert testimony, no rebuttal affidavit.
I thought it was 2. 12 are based on signing twice. 11 are based on the expert, I believe. And I thought you had affidavits for 9 of those 11.
Well, let's
find
see
out.
what he has for affidavits.
That's what I had 8 in front of me, and so that, let's get it right.
Yeah. Then we'll argue the law with respect to the 12. Make a decision about the expert versus the affidavits, looking at this, and then the expert versus, no affidavits, but petition signatures and then signature cards.
Exactly.
There's 3 elements there.
Did you, while we're waiting, did you all want to look at the set of affidavits, objectors 1 through 12 again?
Sure.
Well, I have it in here. I have them in the booklet.
These are the originals.
Yeah, okay, yeah.
Anderson versus Mullenix. No, I'm just.
Now they have one here.
Oh, these are the ones that have double.
Right.
Oh, okay, I don't need
That's
to
the
look,
only-
I don't need to look at that. That's that they signed twice.
Pardon? Okay, and then what was the last one?
Sheet 60 line 1.
And
It's
so,
right at the end.
so how many are there?
There's 9.
Wait.
Do you have the
Sheet 60 line 1.
No, for all.
No, I don't have it.
Okay, all right.
Oh, 34, okay. That was, Barry Ward, okay, I didn't have that one written down.
Can I?
Yeah, I'll give it to, I'm gonna show you, okay?
Sir, are you leaving? Did he leave? Did he leave something under his chair?
On the floor, on the ground, not floor.
This is the one, 34,960. 30, exhibit 34, it's your.
all part of it.
Right.
So now, the affidavits are. Signed ones, yeah.
Okay. You're in it's
8.
number 8.
Right,
And they're
they're there. Okay.
they're in numerical order. Second ones are in numerical order, 1 to 47.
No, I've got written down. Thank you.
Okay.
1, 2, 3, 4, 5, 6, 7, 8.
You want to look at my list? So this is it's page
Yeah,
9.
perfect.
Okay.
Do you have those others up there? Oh, they're
Yes.
there.
Thank you.
Carrie, that lot doesn't close at a certain time, does it? The one
Oh,
across the
lot,
street?
across the street?
Yeah, does that close at any certain
We all
time?
get tickets. No, they don't close.
Yeah, I did.
Well, you know the mayor, right? So you're okay.
This morning, if we get tickets, I'll have to straighten it up. Yours, I won't.
Yeah, I was gonna say. I'll have 4 booths
You know, I
on there.
parked across the street there too. That's the only place you can't park.
Yeah.
That's just me.
So.
And the 2 that you don't have affidavits for, do you know their names?
Yeah, actually, I can give that to you.
One is Donald, maybe?
Yeah, he's on page sheet 2, line 9.
What is it?
Okay, no affidavit. And what's the other one?
What page?
Sheet 2, line 9. They didn't have an affidavit for that person. And the other one is,
It was Marshbanks.
yes. Donald,
Sheet 18, line 4. Jadira, Jadira.
18-4.
Yes.
Jadira Verduzo,
Yeah. Or do so.
something like that.
Yeah.
Verduzco.
Oh, okay. Yadira Verduzco. Okay, 18.
Line 4, okay.
What line is 10?
Which I knew which one. Is there a way for you to tell us of the 9, what the candidates' exhibit numbers are for the 9 that you have affidavits for? It's easier than going through this.
You want me to, the candidates exhibits for the lines they have affidavits for?
Yeah.
Sure. Candidates exhibits for the lines they have affidavits for, candidate exhibit 9 Candidate Exhibit 12,
Okay.
Candidate Exhibit 16,
Mm-hmm.
Candidate Exhibit 24, Candidate Exhibit 25, Candidate Exhibit 30, Candidate Exhibit 31, Candidate Exhibit 34, and Candidate Exhibit 36.
Thank you.
There should be 9 of them.
That makes it easier.
Look.
Exhibit 30 is one of the ones you mentioned, Harry,
Yeah.
Gary.
Pardon?
Exhibit 30 is one of the ones you mentioned, Rosalia Sierra.
That's, yeah, it is.
Yes.
And
Exhibit number 30 is Rosalia Sierra, yes.
Question?
That's sheet 17.
Line 6.
Getting close, getting close. Just a little bit more.
Read that case, it's here.
Okay.
It really doesn't,
It's just bromide, it doesn't really,
it doesn't really talk about
it's, see that,
we're considering at this point in time. It talks about provisions in the code for independent candidates and provisions in the code for political parties. But doesn't address what we're talking about here.
all right, see, that's the trouble
You
with
gotta
that.
take my word for it, but if you want to read any of it, I would say starting, it was an interesting case, I'll tell you that.
How old is it?
Oh, it's from 1940. But what it involved was that Rock Island County had an election, and just before the election, the candidate from the Republican Party withdrew. And they locked certain voting machines, locked the Republican out of certain voting machines, but
Not others?
not others. But if you really, apparently in the end, the guy that withdrew would have won. He didn't want to be. The court had to determine if there was some kind of a conspiracy in causing him to withdraw. There was something to be said about money exchanging hands.
Oh, okay.
But in the discussion, they talked about sections of the code relating to independent or not smaller parties, and then sections dealing with the
Rock Island.
Rock Island County. If you want to read it just for fun.
Isn't that what we all do in our spare time? Read cases from the 40s?
Sure.
Friday night at 6:00.
But not in the comfort of our own home. We're reading cases from 1940 or better.
Let's see.
Tap your ruby slippers and say there's no place like home.
My Google map.
Yeah, no, I. How much more time does everybody need?
I need 3 minutes. I'm
All
going to
right,
the
I'm going
bathroom.
to the bathroom.
No help whatsoever.
Thanks for reminding me. list. I was just marking them too. Ready to go? Okay. Sheet 2, line 9. Sheet 6, line 7. Sheet 7, line 1. Sheet 7, line 9. Sheet 13, 16, 2, 18, 4, 18, 7.
Here, just so you know.
Yeah, just a minute. I'm counting my notes on the ones I wanted to hit and keep.
And, what we got here? Oops.
We haven't gone any, yeah, it is cold. I think they turned the heat off on us.
They're trying to get us out of here. Okay.
You know, Bert once had me years and years ago. It was a Worth Township.
Mm.
We were here until I think 2 o'clock in the morning on a Friday night or something. Oh my God. I don't know how, Worth Township, I think. Or Worth. I can't, it was somewhere in this area. Oh my God. I said, how did I ever get picked to be a public member for this? I mean, literally, I wanted to put toothpicks in my eyes, leaving at 2 o'clock in the morning. Oh,
Was that the Husky case or?
I don't think so, but we weren't done. We had to come back. I know that. It was witnesses and witnesses. It was for signatures. And they brought the witnesses in. Oh my God. Huh? Was there something in Moraine Valley? No.
He used to be on the board at Marine Valley. I don't know. Bert was the trustee.
Oh, yeah, I know. Actually, 2 years ago was the first time in a long time that Moraine had something, yeah. Got anything good back there?
Pardon me?
Got anything good back there?
This sandwich, it's delicious. My wife said, we should order from Lois's sushi place or whatever. We had sushi and so on. Yeah, I'm gonna tell her when I call them when we're finished. You want sushi? Take some shrimp out of the fridge and help yourself. This is my dinner right here. I'll have a drink with her.
I'm gonna have one drink and then I'll be checked out.
Yeah.
My eyes hurt. That's what.
17-6.
Rosalia.
Got a lot of my affidavit.
That's the part about I realize.
17-6. Hold on 1 second. No, go ahead.
What would you like? Mm-hmm. Page 17? No, he did page 16, line 2, and then he went down to page 18, line 4.
Yeah, you went 16 to 18-4. That's what I had.
I think, yeah.
But hold on 1 second. Sorry. What was it? 17?
17-6. Sheet 17, line 6.
Rosalia?
Mm-hmm.
What about her?
He didn't
Yeah.
testify to that.
Okay.
That, you had Rosalia. That was one of the affidavits.
We're not.
No, not yet. Rosalia Sierra was one of the 12 affidavits for duplicate or for signatures on two petitions.
Okay. And this is the second one.
So it was sheet, well, 17-6, yeah.
She signed twice?
Well, That's what's, yes, that was one of those. That was that first group of affidavits that
12.
Mike Casper submitted, yes.
Well, I bet you he's glad he's home.
Okay. What's that?
Can't
Bet
you
you he's
keep
glad he's
straight?
home.
Friday evening with his daughter.
Yeah, he didn't want to come back.
Can't get
huh?
better, yeah.
She could
Text him and
this
tell
would
him he
have
has to
great
come
after
back.
school
How old is
program.
she?
What's that?
She's in 7th grade.
Yeah,
My daughter would be a lock-key at that point.
my kids were. in the
My
after
daughter was
school,
a
too.
lock-key at that point because we both worked.
I was. Latchkey kid. Is that what it is?
Latchkey or lock-key?
They're
or-
latch.
Latchkey.
Then they have the free range kids.
Was it?
That's like the new term. The kids were playing in the park. And
Yeah,
Oh,
that's
really?
what I was. Free
Just the
range,
mom-
non-GMO.
You could see them from the window or something, and some neighbors complained, and they referred to it as free range kids. Well, I certainly was, and beyond. Growing up
Oh,
on
my
the west
parents
side.
were never home when I got home.
In the summertime, you get up, get on your bike, and just be gone. You come home to like, tree light came up, be home by then.
Right?
Okay, are we ready? for-
Yeah, I'm ready.
Are you ready?
Yeah.
Are you ready? All right. Let's go back on the record.
Okay, back on the record, it's approximately 6:15 in the evening, and we are now back on the record in the proceeding. The 2020 BIMOEB-02, Esparza and Carvajal versus Vargas.
Okay, so the first thing we have to do is just do a motion on the double signage petitions. Correct?
Right. We considered the statute and some case law.
Right.
If there's any more argument.
I think we were done.
Done.
All right, so
Roseanne, Mr. Kelly read a case that was provided.
I don't think it was relevant. It wasn't
It
relevant.
wasn't helpful. It was just full
Yeah.
of generalities. It didn't really have any definition as to the term I was looking
The
for.
case that Mr. Kelly had referred was a case
It was did.
Ferguson versus Mullenix. And it was at 399 Illinois 470. It did not address the specific issue that you are being asked to address this evening. It discussed in generalities as part of the decision, major parties and minor political parties and the differences, but did not come close to talking about what you're looking at now.
What are your feelings as board attorney on this subject?
On this subject, there's no direct case law. The statute itself, as I mentioned, it says shall not, that the name of the candidate whose name may appear in any other place, or it says each voter signing a nomination paper may subscribe to one nomination for such office to be filled and no more. It doesn't say anything about what happens if more than one is signed. It makes no reference whatsoever to signing an independent candidate signature or signing and then signing a party signature or vice versa.
Right. Now, Mr. Erdman indicates that cases have, when you had parties involved, found a consequence, and that is first signature counts, second one doesn't. Here, we don't have that stated in the statute you're indicating.
Yes. And you had 12 objections. And as you pointed out at one point, Judge Bertucci, there were, in 5 of the instances, the signatures or the notarization was on the Vargas nomination paper was earlier than the notarization of the circulator on the other the other nomination paper. On 6, the notarization of the circulator on the Vargas nomination papers came subsequent on a date subsequent to the notarization on the other petition that it was compared to. And in one instance, the notarization was on the very same date.
Okay, I would say that Mr. Casper, though, did cite cases from the Chicago Board of Elections that it really doesn't indicate when the voters signed it, but when the circulator went to
Get it notarized.
get it notarized. So
Yeah,
it
I'm
doesn't,
just saying that that was just a point that Judge Bertucci made.
right. I'm just,
It doesn't take us too far. It just indicates,
Yeah.
you know,
It's
that the notary happened, you know, weeks later. On some of the other candidates' papers, and weeks later on some of Vargas's.
Yes.
Is that an indication of when they were signed? You know, of course, not necessarily. So I don't know how much we glean from that, but I pointed it out.
Yes.
I would also note that in election law, a lot of the provisions in the election code don't give us the answers we want, and it's not uncommon for us to look at other provisions of the code to determine what we need to do. I mean, just because it's not in 10.3, it doesn't mean we, you know.
I know, I'm just saying
No,
what's
I'm just giving you my opinion
Sure.
right now. So it's my opinion that, well, it's my opinion that we would let in the 10. It's my opinion that we should rule in favor of the 12 objections, that there is 2 signatures, and we have to dismiss the one that was signed last.
So is it, I didn't hear the last part of what you said.
Well, that we have to reject the sign.
You said reject
Reject
the one that was signed
signed
last.
last, right, according
So-
to the
If you
affidavits that were
accept the
submitted.
affidavits,
Right, that's
as
what I'm
being
saying,
true.
right. I'm accepting the affidavits as being true. There's no evidence that it's not true. And for some case law, and I sometimes you wonder, do you treat political parties different than independent candidates? Why should you be able to sign the petition of a political party and also sign an independent petition when you can't sign 2 independent petitions, or you can't sign for 2 political parties? Doesn't make sense to me. So I would allow the affidavits in.
You allow the affidavits.
I would, that's my opinion, yes.
Judge Bertucci, do you have any comment? Or Mr. Kelly, either one of you?
I've been wrestling with this and I'm just not comfortable with extending the provision to 10.3 where they don't give you the fatal, failure to comply with this penalty. I know the Watkins versus Burke case only too well because my cousin's appellate court case is on the next page. People of the library book, but unrelated to elections. But it's just really a harsh penalty, and usually like Bardwell versus Valentine versus Bardwell, etc. If there's a fatal defect, the statute says shoot it down, and I'm wrestling with it. It kind of sort of, but no court has ruled on it, and the Chicago Board of Elections isn't binding on us.
How did the like Watkins get to their conclusion?
These were candidates running for ward committeemen in the Democratic primary in the 14th ward. And they made a bare-faced assertion that identical signatures appeared on both. And then when it got on appellate level review, they said, yes, but the additional step is you've got to give us a time frame. First in time wins the signature. And failing in the objector there failed to set out a sequencing. He just said he made the mere assertion that signatures appeared on both sets of petitions. They said, but if you don't come the additional information,
Right.
whose page was circulated first, the objection failed. And we have some affidavits here about the time of signing or which one was signed first, but I kept going back to the code on 10.3 and I wish they would rewrite the election code, but I've been saying that for 30 years. It's just such a quilt.
You don't feel on our facts they would reach that conclusion necessarily. Even if, like Ms. Coleman determined in her mind, based on the affidavits, that she's accepting them, that these people did recall that they signed someone else's candidacy papers first.
Yeah.
So you have the sequence in our case.
And there was no rebuttal evidence.
Yeah, right. If you accept that, we have that sequence, but you don't feel necessarily, Mr. Kelly, that the appellate court would reach that conclusion in our case when you consider the sort of vague aspect of the statute.
Well, it's just because like there's other places, like in 10.5, it tells you straight up that no petition will be valid unless you do this. And they get to the penalties right there, you
Right.
know. And this one is kind of vague, you know, and I don't know.
Well, what does 10.5 deal with?
10.5 deals with the form of the circulator's affidavit and
Okay, so that's a different issue altogether. I mean, you find in the election law that some have a penalty that you have to.
well,
do.
and also the statement of economic interest. If you fail to file that, that will invalidate your papers. But it's there in unambiguous, definitive language. And 10.3 is just like, it gets, you know, is it directory or mandatory? I don't know.
Take one last look at 10.3.
Sure. Yeah, we're
That one section one more time. It's, you know, this is a case of first impression for me on this issue. I've not had that.
each voter signing a nomination paper shall add his signature, his place of residence, and each voter may subscribe to one nomination for such office to be filled and no more. But then it doesn't say, and if he signs two, or, you know, it stops. It goes to a colon at that
And
point.
you know how sometimes in the election code shall, and I don't want to say amazingly, but doesn't mean shall because there's no
Right.
consequence.
Right.
Here, the word shall isn't even used, it's may. I mean, we know what the intent seems to be. Each voter may subscribe to one nomination for such office we filled and no more, but they don't even use shall, they use may. And then no consequence, as you point out, that exists in other parts
Well, there's
of
no.
the statute, no
Well,
penalty.
I mean, there's no penalty in a lot of those provisions.
No
You have
question.
to interpret it.
No question.
Yeah, I know,
I
but
just wanted to point out that it says may.
I mean,
May I-
usually you find the penalties in the sections that deal with form and what papers you have to sign and, you know,
Yeah.
exact, you know, not, it doesn't, there's no penalties when it comes to necessarily, you know, the person signing.
Right.
So you have to interpret it.
If I may, the statute says and no more. So that's where they draw the line. You get one. And to read, you know, it's, you know, construct. You read the statute in a way, you can't read it in a way that makes it irrelevant and meaningless. And that's what we have here. And while there are places where they say, you know, you shall do this, or here's the penalty. My view of those cases is they're drawing a line to prohibit substantial compliance. You know, if you do not sign your statement of candidacy, your name shall not be on the ballot, period. you know, where there is no substantial compliance for that issue. So here, we know what they're talking about, and no more means no more. You can't do it, and they create the impossibility of you signing another candidate for that office, and that's what we have here. We have affidavits that say we signed this one, and then the statute says, okay, you can sign no more. And the only logical and non-ridiculous way to read that is no more. So anything that comes after that is no more. And we shouldn't read it as a draconian penalty that's throwing somebody off a ballot. We read it as to whether that signature counts or not. And then, you know, the fact that might end up costing somebody access to the ballot doesn't make that law any less, you know, that statute any less enforceable. So we've got a clear instruction of what is allowed, and no more, I think, is clear. We have the clear intent of the statute. I don't think anybody will question that. You're limited to one. And then we have proof through the affidavits of which one was signed first, which would indicate that anything else falls under the and no more portion of the statute.
And then Watkins.
Was Watkins the appellate case that, yeah, well, Watkins said there's no proof.
Right.
So, and here we
As
say,
if to say
okay.
if there was.
Yeah, here we say,
This
yes.
is the order.
Right,
That's
and
what this moment's
they
for.
wouldn't have addressed that issue if it didn't matter. And I think that's the nod to, well, you had no proof. Well, if you did, then we have a different situation. And here we have the proof, and it's a different situation.
Well, like Mr. Kelly, I'm struggling with it, but you're right. The statute, whether it says shall or not, even though it says may, as you say, it says may do this, but no more. And that part's clear. Don't sign more than two.
Don't sign more than one.
Yeah, don't sign more than one, don't sign more than two, more than three, but you're dealing with one, you're right.
No, but
it feels like we've been here 2 days, though.
Yeah.
I'll tell you that. That's where I got that from. So I think I agree with Madam Chair that if we accept the affidavits, and I don't see a reason, not to. They're sworn affidavits. How the people necessarily remembered which one they signed first, I don't know, but it's not hard to believe. So I would vote to not consider those signatures, which I believe comes to 12.
12.
yes.
So is there is a motion
To
to accept the
David
affidavits?
and not include the
With-
12 duplicate signatures within the count.
So the motion is to accept the affidavits in objectors exhibits 1 through 12 inclusive,
Right.
and not consider the signatures that were challenged in those 12 affidavits.
Correct.
I would second that.
Okay, motion by Judy, second by Judge Bertucci. Roll call, please.
Nay.
Judge Bertucci?
Aye.
Ms. Coleman?
Aye.
Mr. Kelly?
My vote is nay, and what I'm standing on is People ex relatione, Meyer versus Kerner, Valentine versus Bardwell, and McNamara versus Municipal Officers Electoral Board of Oak Lawn, which stood for the proposition
if there's a fatal defect, the statute's got to expressly state that it's invalidates your papers. And I'm just not willing to read that into 10.3 based on that statute being phrased as it was.
The vote is 2-1.
That
So-
brings us down to 130 ballot
I'm
signatures.
sorry, you're not in here.
That brings us down to 130 ballot signatures.
Yes,
We started with 143,
142.
excuse me, 142. Yeah, that's right. So we're down to 130. Eleven at play. Right.
Yeah, and 9 have affidavits.
9 have affidavits, 2 don't.
Good.
Uh,
Are we going to be allowed to address,
Yeah, I was
this-
just about to ask,
okay,
you know.
argument on this
your
issue?
arguments on those 11. Those 11 signatures.
you've accepted them into evidence at this point in time.
Right.
Right. So yeah, we're gonna take argument. There may be different argument for 2 of the 11 than the other 9, you know, perhaps, but yes.
So
We're talking about his rebuttal affidavits to the
Yes.
expert's testimony, correct?
Yeah, we're talking about the
Okay.
expert's testimony, whether we accept it,
So then,
versus affidavits and so on, right?
okay, so I would ask that we first look to the 3 sheet and lines where the expert testified and there are no affidavits.
There's 2.
2.
2-9, 7-9, and 18-4.
There's no 18-4.
Let's see which one. No affidavits would be for sheet 2, line 9.
And
That be Donald,
Marsham?
last name starts with an M,
Yes.
Marshbank.
Marchbank?
Yeah.
And then I believe 18, sheet 18, line 4, there was no affidavit for. And that is Jadira Verduzco,
Yeah.
or Verduzco, Jadiraverduzo, I believe. So, yeah, we probably should take one at a time.
There's no affidavit for. Do you have 7-9 on your list?
yes,
Okay.
page 7, line 9.
Yeah,
Gaston Ramos.
and there's no affidavit for
wait, what is that?
7-9 is Gaston Ramos.
Ramos.
Yeah.
Yeah, that's not one of the 11. And
Yeah.
why is that?
It is. Page 7, line 9 was one of the 11.
Page 7, line 9 was one of the 11. Mr. Spencer testified to, yes.
Well, with that one, I have 12.
I have
1, 2. These were the ones that he testified to.
I have 11.
Sheet 2, line 9.
Right.
Sheet 6, line 7. Sheet 7, line 1. Sheet 7, line 9. Sheet 8, line 8. Sheet 13, line 6. Sheet 16, line 2. Sheet 18, line 4. Sheet 18, line 7. Sheet 20, line 1. And sheet 20, line 4. So that's 1, 2, 3, 4, 5, 6, 7,
That's 11.
8, 9, 10, 11.
I'm showing, I may have written this down wrong. I'm showing 17.6 as part of that. but that's Rosalia Sierra.
That was Rosalia Sierra.
That's right. So you're exactly right. There was a 7-9. I apologize.
And then there were 9 affidavits submitted. And those affidavits were with respect to sheet 6, line 7, Timothy Barnes. Sheet 7, line 1, Michelle Gonzalez. Sheet 8, line 8, Jose Hernandez. Sheet 13, line 6, Kenneth Marsalis or Marsalis. Sheet 16, line 2, Andrew Robinson. Sheet 17, line 6,
No.
Rosario Sierra. But he didn't testify to Rosalia Sierra. Rosalia Sierra
Signed twice.
is
Signed
one of
twice.
the affidavits that, if I'm not mistaken,
Yeah, so he didn't, yeah.
that was in the packet of 12, if I'm not mistaken. Okay,
Right, so she's not, or he's not doing that.
let me just check that. I think that's where that may have come from. Yes, that was the affidavit for Rosalia Sierra was objector's affidavit number 9 in the group of 12. We call it. And she said that she signed the independent nomination petition of Domingo Vargas subsequent to when she signed the petition for the United Blue Island UBI party. What she said, United Blue Island, yes, UBI party. Then the next one is 18, line 4,
No, it's 17.
or excuse me, 18, line 7, Scott Gardner. And then the next one is 20, line 1, and that's Barry Ward. And then the last one is 20, line 4, and that's Anna Ward or Anna Ward.
Yeah, I think you forgot,
20, line 4, did I?
yeah, you forgot sheet 7, line 9. Isn't that-
He said that.
Gaston
And then
Ramos.
Gaston Ramos,
Yeah.
there's no affidavit on that. I was just reading off the affidavits.
Right.
Well, then that's only, then there's 3 that have no affidavits.
There are 3, yes. One is sheet 2, line 9. That's a Mr. Marshbanks, if I'm not mistaken.
Donald.
Yes, sheet 2, line 9. Yes, that's Marshbanks. And then sheet 7, line 9,
Gaston Ramos.
Gaston Ramos.
What's the third?
Pardon?
When the third would be?
The third one would be Hadira Verduzco,
Oh.
sheet 18, line 4.
Okay, but that doesn't make sense because I have, you read me not 1, 2, 3, 4, 5, 6, 7, 8, 9 exhibits, affidavits submitted, and there's 11, so that leaves 2.
Well, no, one of the affidavits that was admitted, Judy, was
Okay,
for
so,
Rosalia Sierra.
all right, what exhibit number is that then?
The affidavit, that's
30.
candidate exhibit 30.
All right, thank you.
Now, that said, we voted 2-1 to strike
Rosalia.
Rosalia Sierra. We could be wrong, right?
That is correct.
We could be wrong. So we probably want to decide her signature question.
Yes.
And there is an affidavit for her. which is Exhibit 30.
That
And
would
whether
throw-
there is or not, we need to consider it.
Right, but that would
everyone
throw
that-
our numbers.
So it's really 12.
If you want to, of the 12, if you want to hold on that, that affidavit was a part of the group of 12. The affidavit saying she had signed
Right,
the UBI prior
right.
to the largest.
Right.
Right.
All right.
But she also signed an affidavit saying,
Yes,
I signed for Vargas, and that's my legitimate signature.
yes,
And that's candidate's number 30.
that's number 30.
So I'm just saying we should rule on the validity of her signature versus what the expert said or didn't say.
But then not counted at our number. As far as our decision is concerned.
Well, right, right. But that's right. It's still not going to go into our number. Unless there's a reversal of our decision, striking her for the other basis.
Yes.
Okay? So I think we should rule on that anyway, the validity of her signature. We don't have to.
Okay, so
One vote won't matter.
wasn't she the one who crossed out her signature
Yes.
on the sheet?
Well,
She
sure, but
printed and then she kind of scratched out another signature in the margin.
in the margin, if you take a look at that signature, it's similar to the candidate sheet. It's how she signs her name. So apparently she printed it and crossed it out. Perhaps.
Her signature is in the margin
Right.
above, or excuse me, yeah, right, where apparently the name of Porfirio was printed in there. It was stricken out, and then she signed it, and then there's also the signature from the clip on there.
Right.
That's on sheet 17, line 6.
Right. And then her affidavit with the signature,
Yes.
what I would say is similar to what she signed in the margin.
So the original affidavit was on the question who signed first.
Correct.
So if this one doesn't count because we accepted the affidavit, then we're not looking at it, regardless of what the signature matches or doesn't match or kind of is close, right?
Sure. All I'm saying is we could be reversed on this legal point, putting
So take care of both of them.
Sierra back in play.
Okay.
And so take care of both is all I'm saying. We're here anyway.
This is what happens
down to
when you
one
come a
signature,
half
I
day
don't know,
late.
but
Okay.
you never know.
Okay.
Because I don't know how we're all gonna vote on these,
Gotcha.
affidavit or not, or expert testimony or not. I would say make a decision about Sierra on this point too.
Before we begin going through these affidavits, I would like to make at least a brief argument on the issue.
Makes sense?
Is because I believe that there's a mistake on who's got the burden here. And it is the objector's burden because the nomination papers were deemed valid upon filing. The signatures were found to be valid after a record exam.
Right.
They're presumed valid. It's Mr. Erdman's responsibility to rebut these by this expert testimony if you choose to believe that expert testimony. And what's important here is if you want to take the weight here, you know, he's making calls like balls and strikes. He got 9 of them wrong. Okay? His testimony, quite frankly, do you believe this man? Oh, Mr. Casper's got a credit card. Send me a check later. No problem. I'm going to look at this. The notary spent more time getting affidavits than that man spent looking at any of these signatures. This man who took a correspondence course, who portrays himself as an expert, who has no real certification.
His CV on whether he's an expert or not. Been accepted as an expert.
No, he has not been accepted yet. He's not been accepted. He's been allowed to testify.
Testify as an expert, right? But I think the argument's fair.
The argument is a fair argument.
Yeah.
But no, well, so if you want to talk about burden, then why I asked to separate these three is because we presented our evidence.
And what I'm saying is,
Evidence presented, so that's where we're at.
yeah, but I did present evidence.
An expert with nothing countering it.
Okay,
Not
That's
quite
for
the
three.
case. You have the presumption of validity based upon the record exam that was done by the clerk's office. So you can't say nothing to counter it.
Right.
And
That's
you
what
heard-
we're countering.
And it's up to this board to determine the weight to give to the experts. And I use that term very generically. The weight to give to the expert's testimony. We all sat here and we paid attention to what he said, but this board doesn't just have to rubber stamp something that he says either. So that's why we're here.
I haven't asked the board to do that. What I've said is that's where we're at. Let's take those three first. So we've presented our evidence.
We can
If
take those
Steve
three
wants
first.
to give us something else, otherwise
Sure.
then
And
those
what
are
we
the
have
first
with those
three we
three
can
is
decide.
3 people that purportedly signed an affidavit, and their signatures were sworn to by someone. And we had them reviewed and accepted by the elections office clerk. And then on the other side, we have this expert. And so I think it's a fair argument, but we can.
But I'm saying that our burden was to provide some evidence as to why the clerk's employee, a non-expert, was wrong. We did that. And the candidate has had the opportunity to provide rebuttal evidence.
I did.
And
by cross-examination.
For those three, we have.
No, the cross-examination, this man didn't follow protocols.
Okay, that goes to his, whether the way you give his testimony.
Right, but that's what his argument's about.
So tell me for these three to start off with, as a stepping off spot, tell us what you think of his testimony.
Well, I think that as board members, we can look at the signatures and determine whether we think it's a match, okay?
Absolutely.
And taking the
I
weight
plan to.
of the expert too, and that's what I plan to do.
And my only point is that's a stepping off.
So let's get started.
Let's use that as a stepping off spot.
Fair enough.
Not that, I'm not saying I had an expert testimony, therefore I win, it's done, you have to give them to me. I'm just saying in the logical order of things, we've got three that we don't need to battle back and forth between an expert and an affidavit.
Fair enough. We can deal with those three first. I don't care, but we should allow them to argue.
Absolutely.
So you have a brief argument?
Yeah, the brief argument, this man's been found unqualified in cases where it involved mortgage fraud. I mean, it's just like, yeah, I had this experience and I took a correspondence course and now I'm testifying because this is a good gig. I came in here to testify. I spent 3 minutes per signature. Okay, approximately. Maybe spends a little bit more. But the problem we have here is we have someone that is going to determine the rights of the voters who signed these petitions. And remember what his testimony is. His testimony is that it's not that these aren't genuine, they don't match. Someone else signed these.
That's what he said.
Okay? That's his testimony. Someone else signed these. You have to take that quantum leap. And suspicion, that is not a term used in any recognized field. I question that signature. I have a suspicion. What this man testified about is that someone signed these petitions and they lied. Okay? You must take the number of times he shot that gun, and he shot that gun 12 times. Guess what? I'm an expert, but to a reasonable degree of certainty, I got it wrong 9 times. This man's testimony.
I wasn't impressed with his testimony.
Okay,
I
so
was
how
not
do you
impressed.
prove that it's not a genuine, if it's not a genuine, okay, abstract? If you're saying it's not a genuine signature, then somebody else did sign it. I mean.
No,
otherwise it
no.
would be-
No, it could be, guess what? His testimony on written pattern. Are you telling me that signatures are the same? You could look at someone's signature and yeah, when I pointed to that J, that is a distinctive J signed by Jose. He didn't look at that. He said, oh, what we
I
have.
understand that, but I think we're capable of, looking at it also and determining whether he's right or you're right.
I understand that, but when this is the testimony that they've offered. They didn't ask you to look at it. You have the right to look at it, but their testimony is a hired gun that came in here who ignored affidavits with signatures on it. I mean, he ignored. He took a blind eye.
That's fine, but I have never determined, when I'm asked to look at signatures and I've sat on the board, I've always looked at it myself, okay? So that's what I'm saying now.
We're
Let
gonna
the
do
board
that.
look at the
And I think
signatures
that's,
and make the
from the board's
determination.
point of view, at this juncture, given how we've gone through everything today, that is the advisable course to follow. You are the final arbiters of the validity of these signatures at this point in this hearing. And so that's the way we should do it.
So I think we
But if
got
he-
your point and your argument that you were not impressed with that expert. We understand that. Why don't we go through these three without affidavits in order, and we'll go through every signature.
I think that's
Is that a
fine.
fair suggestion?
I
was not impressed with the expert. I'll just tell you right now.
It's a
There's nothing more that could be much said. I heard
yeah.
testimony and I heard both arguments.
And that's where we were 5 minutes when I suggested that we start off here.
Yeah.
Rather than,
And I'm not just
we spent
discussing
3
his
minutes
testimony.
disparaging the expert, as opposed to doing what I suggested as a logical, if you want to start somewhere else, that's fine. It was a suggestion as a logical place to start.
Mr. Horwath, I trust your judgment on where we should start and proceed now.
Sheet and line, give us a name.
Right.
I would start
At the beginning, page
sheet 2,
2.
line 9,
Right.
and go right down the line. And then that's, I think, the fairest and least
expeditious,
least way of having anything that you've done turned around.
And to note that for that particular one, there's no affidavit, correct?
Correct.
Correct.
2, line 9, Donald Marchbank or
Marchbanks.
something along those lines.
Marchbanks.
Marchbank?
Marchbanks.
Thank you. We have a notarized signature on a petition.
No.
Yeah, on a petition. We have a notarized signature.
Oh, it just says that, yeah, that the person, yeah, was signed.
On the petition, the notarization is on for the circulator, not for.
I'm sorry, the
Person
circulator.
signing.
You're absolutely right. But we have his purported signature on a petition, and then it was reviewed at Board of Elections.
Clerk's employee, yes.
And then we're going to look at it and see what we think, but there is no affidavit presented by the candidate. And you're right, it's the circulators that was notarized. The circulator swore these people signed in front of that circulator.
That's
Right, but the circulator isn't making any kind of testimony as to that those are the persons who are signed. He didn't check ID, he didn't do anything like that.
They don't
Right.
have to-
He's just saying that the person
Yes.
who put pen to sheet A, line
Purported to
C, wrote their name down there in
Right.
front of it.
So.
So of all the ones that I saw today, for me, that looks the least alike. Of all the signatures I've seen today, this one was,
Yeah, I can see what you're saying.
it doesn't look like it.
Now, so this is sheet 2, line 9, Donald Marchbanks. We have no idea when he signed the registration.
No.
We know somebody did about 41 years ago. And Marchbanks could have signed it more than 41 years ago, less than 41 years ago. We have no idea.
Well, he was born in 1970, so I don't think he's.
Okay.
41 years.
Right, and we don't,
Sorry, we have that.
and we don't have any evidence as to when he signed
Right.
his registration card. So that's,
So he signed his name or the signature on sheet 2, line 9, slants to the left. And it slants to the left on the signature card. But there are also differences.
Right.
You know, I would say most signatures I've ever seen, including the rest on that entire page, slant to the right. Donald Marchbanks slants to the left in the signature line on line 9 and on the registration card. And someone found that your Rule 8 challenged the finding of the records check, which I think we're entitled to give some weight to, right, along with everything else.
Absolutely.
So,
less than an expert is what I would say.
well, I understand, but starting signature by
I'm not saying
signature,
no,
let me
and I'm
get to
just
the expert now.
saying.
That's a good point. As I said, I'm not going to entirely dismiss the expert, but I was rather unimpressed. I listened to him very carefully. I've listened to many experts in my life, very unimpressed. And not because, he's paid. Yeah, of course he's paid, that can slide his testimony, but that doesn't make it wrong. But it's a factor. But you listen to him, I didn't have that stuff. Now he's had it a day or two, he says. Could have been up to 2 days, and isn't going to say, wait, maybe I made a mistake here. I better look at this stuff. He says, I wasn't asked to. I'm only going to do what I was asked to. And that's fair enough. But you are an expert. You have to, honor your expertise. And to just disregard those additional factors, I mean, he didn't say, I called the people that hired me and told them my concerns. He just said, I wasn't asked to do that, so I'm not going to look at a third potential signature of the person that claims they signed this, and they did so under oath on an affidavit. I was just not impressed. So I'm not going to give a lot of weight as to this signature on sheet 2, line 9, to the expert. Do the signatures look different on the petition versus the card? They somewhat do. And people do change their signatures. It's the only one slanted left, as I say, which is more of a rarity. Most people slant to the right, and everyone else on that page, and you can go sheet by sheet and find that to be the case pretty much, straight up or to the right. So on balance, I am not prepared to strike that signature based on your objection.
Okay, if I could just a couple of points that you made. One, there is no affidavit for this
That's right.
signature. So the fact that he did or didn't look at the non-existent affidavit doesn't matter. When I
Right, I didn't mean it on this person or the other two.
just
I
this
only meant
person
it
right
generally, in
And
terms
when
of
I-
his credibility.
And when I asked him if he looked at them, he said yes. And when I asked him did any of that change your opinion, he said no. So we got to that over strenuous objections based on an engagement.
That's not really the testimony I heard. He got them late, and he said early on in his testimony, it didn't really affect his decisions, which he had made before those affidavits were available. So if he did give them a look-see, it was sort of a short shrift, if I'm taking him as a man of his word under oath.
Okay, and we can ridicule them for 3 minutes all we want. But what the man did was take 64 and distill them down to this number. If he was a hired gun slinging, left and right and shooting anything that popped up, do you think we'd have 12? Do you think we'd be this close? Okay, he did his job. and he didn't go beyond it. He wasn't swayed by anything other than what he saw. And he did see he testified that he made his decision prior to seeing the affidavits. Then he saw the affidavits, and I asked him, did seeing the affidavits change your opinion? And he said no,
It wasn't
except
quite
for,
like that.
Okay.
No, it wasn't quite like that.
Okay, time out. I don't think we need to further argue the testimony of the expert. I think right now we're at the point where each public member should determine whether they feel it's the same signature or not.
You may want to make a motion to accept the record examination, overrule the objection. The alternative is to grant the objector's appeal and sustain the objection. So each one of you needs to decide. On this particular one, do you want to, in essence, overrule the objection and accept the signature, or
Sustain.
That is my motion.
pardon?
That is my motion
To
with
overrule?
respect to this signature on sheet 2, line 9, that the objection be overruled
You're gonna,
for
your
the
motion,
reasons I stated.
okay. You've made the motion. Is there a second on that?
I'll second.
Motion by Judge Bertucci, second by Member Kelly. Roll call. Member Kelly.
I am going to vote to overrule the objection and accept Donald Marchbank's signature as valid.
This is a really hard call for me, just looking at the signatures and not taking anything else into consideration. Just looks so different. I'm gonna sustain.
Okay. Member Kelly votes to overrule the objection. Member Coleman votes to sustain the objection. Member Bertucci.
Vote to overrule the objection.
Let the record show, with respect to the objection to the signature of Donald Marchbanks on sheet 2, line 9, that objection is overruled and the signature is accepted. Next is sheet 6, line 7, and that is the signature of Timothy Barnes. The affidavit in support of that by the candidates is candidate exhibit number 9.
This is a case where I'm in favor of overruling the objector's complaint regarding this signature. We had the expert testify, and I raised the question about the signature clip indicating that Mr. Barnes registered to vote in 1980, which is 4 decades ago. And we have an affidavit, and there's certainly some points of commonality in the signature. So I believe that this is a legitimate signature.
And I would note, when you raised the fact that it was about 41 years ago, the expert admitted that would be a factor for him, and that was something he didn't know.
Yeah.
I would second that motion.
So that there is a motion by Member Kelly, seconded by Member Bertucci, to accept the record examination determination and overrule the objection to this signature. Roll call. Member Coleman.
Well, this signature of law cracks me up because I think all 3 signatures look different, but there was an affidavit submitted by the signer, and there's nothing to dispute his affidavit, so I would vote to overrule it.
Member Bertucci.
I vote aye to overrule the objection.
Member Kelly.
Aye to overrule.
Let the record show that the objection to the signature of Timothy Barnes sheet 6, line 9, has been overruled, and the result of the record examination by the clerk, county clerk, has been accepted. The next one is sheet 7, line 1, and that is Michelle Gonzalez. There is an affidavit signed by Ms. Gonzalez, candidate exhibit number 12.
Okay, I would make a motion to overrule the objection. I'll note for the record, although the signature on the affidavit is not that clear, but I look at the signature on the petition, I looked on the registration signatures, and the Z's are the same, and the G, the last name is the same. So it's, I would say it's the same signature.
Okay, there is a motion by member Coleman. Is there a second to overrule the objection and accept the determination of the county clerk?
Yes, I will second.
Motion by member Coleman, second by member Kelly. Roll call. Member Bertucci.
Aye.
Voting to overrule.
Voting to overrule.
Member Kelly
Aye.
and member Coleman.
Aye.
Let the record show that the objection to the signature on on sheet 7, line 1, the signature of Michelle Gonzalez, has been overruled, and the report or the determination of the county clerk has been accepted by this board. The next,
Before we move on, just real quick, I just want to stress that the evaluation here is 3 points. The signature on the petition, the signature on the affidavit, and the signature on the clerk's clip from the registration. And a board can find that the affidavit and the petition signature match, but it's not the person from the registration. So it's 3 points of evaluation. And for the record, anywhere where he testified, the record shouldn't show that there's no evidence against what the case being made is, because that is evidence, and you guys can give him the weight that you think.
You're talking about the expert.
Yes.
Yeah, sure.
But that I just want to make sure that the record doesn't show that there was no evidence.
Fair enough.
Slip of a tongue or.
Sure, fair enough. But I just make
they're
clear
making
again,
their decision based upon the evidence presented to them.
Right.
I get that, Terry. What the statement was made that there being no evidence against it, blank. This is how we're ruling. And my point is that the record shouldn't say that there's no evidence. It's just that you given the evidence the weight that you deemed it necessary, and weren't moved by it. Not that it didn't exist.
Understand.
Okay. Fair enough. Excuse me. Okay.
You are a trooper, I must say. I've always appreciated.
We'll give you 30 seconds.
Don't step on your phone.
Yeah, be careful there. Oh, no. All right.
I would note, I used to have coworkers say they were on the paper because, they wanted to get going. Yeah, that tricks. See,
My niece
But
used
that's who I always asked, can you go on, work through lunch, listen, the lawyers are ready to do things. We're court reporters.
Does that floor thing pop open right by you? Are you right foot? Does that pop open? Oh, okay.
Do you need his mic with him sitting there by you? Because that you can plug it in there. Gotcha.
The other two are? Okay.
She has to recharge?
Mike?
There is an outlet here. Okay, get the extension.
my nieces used to love when I would bring them stacks of photographic paper, so they could just write.
Yeah.
And then it would be strung up all the way around the roof.
What would happen if he was in our film discussion class?
I
We'd
still
be there to
remember them
wait
sitting
for
in the jury box at 26.
break it down frame by
Bench
frame.
trial.
Got amazed though, this only likes to watch a lot of trash movies too, like that Ed Wood.
Elder abuse and neglect of his father.
One semester
He was
was
slow.
Ed Wood movies.
He was an adult, he was
Those were
slow, the kid.
painful.
And he let these gangbangers kind of run the house, and was taking lead from everything. But anyway, police officers testifying.
And I forgot my watch at home and I feel like lost without it.
Nice car across the bed on this guy.
I stopped wearing a watch when I broke the last one, and
Well, it's also my steps, but I haven't done many steps today, so it
I
doesn't
just
matter.
stopped looking.
And then you're gonna get bored, you know.
What?
You ready to go?
I'm not getting it. All right, you ready? Let's go.
Terry's gone. So, he'd be swinging around in the chairs and not really paying attention, you know. I remember one time I brought him, we always had
I never
like a jail
pictures
cell
that I'd be
next to
quartered.
his courtroom. It was glass, though. It wasn't bars like in the westerns. And I said, I brought them back there. They were young kids, my sons, and we put the fear of God in them. I said, gentlemen, anybody in there, you know, ever do drugs? And they all raised their hands, you know, all bust outs, charged with all kinds of crimes. Anybody glad they ever?
All right, let's go.
Okay. You all set?
Ready?
And action.
All right, the next is sheet 7, line 9. And this is the objection concerning the signature of Gaston Ramos. There is no affidavit for this one.
Was a signature. I kept looking back and forth between the petition page and the clip. And although there are some differences in the presentation of the signature on the candidate's petition, I'm also seeing points of commonality. Obviously, it appears that he's formed his capital letter G differently, but the ASTON in his first name and Ramos, I'm satisfied with 4 of the 5 letters there. So this could be just a person trying to sign within the cramped space allowed on the petition. I think this is a genuine signature is my guess. Or best.
You're making a motion to overrule.
Yeah, I would overrule on this one. I think there's sufficient similarity where I'm of the mind that it is a genuine, proper signature from a voter.
There's a motion by member Kelly to overrule the objection and accept the determination of the county clerk. Is there a second?
Yeah, I'll second it. I'll note for the record that the R's are very similar in the last name. So,
On a roll call, member Bertucci,
I vote aye to overrule the objection.
member Coleman,
aye.
member Kelly.
Aye.
Let the record show that the objection to the signature of Gaston Ramos on sheet 7, line 9 has been overruled, and the determination of the county clerk as to its validity has been accepted. The next objection is to signature on sheet 8, line 8, and that is to Jose Hernandez. And I believe there is an affidavit on that. It's candidate exhibit 16.
I would make a motion to overrule the objection. The J is very distinctive. And it actually looks the same on all 3. It looks the same on the distinctive. And the thing, and it's the same J on the petition sheet, the registration of signatures, and on the affidavit.
Judy, you have to talk a little bit closer to the microphone.
Did you get it?
Okay. There is a motion by member Coleman to overrule the objection to the signature of Jose Hernandez on sheet 8, line 8, and accept the determination of the its validity by the county clerk. Is there a second?
Second.
Second by Judge Bertucci. Roll call. Member Kelly.
I'm voting aye to overrule. I'm seeing the capital letters J and H as being very similar to the signature clip, so I'm voting to overrule.
And Member Bertucci.
Likewise, I vote aye to overrule based on all the evidence.
And Member Coleman.
Aye, as previously stated.
Let the record show that the board has voted to overrule the objection to the signature of Jose Hernandez on sheet 8, line 8, and accept the determination of the county clerk. The next objection is to sheet 13, line 6. That is Kenneth, signature of Kenneth Marsalis. There is an affidavit with respect to this.
What exhibit is that affidavit?
The affidavit is candidate 16. Kenneth, oh, I'm sorry, Kenneth
24.
Marsalis, candidate 24.
If I could speak. I would ask that the board look at the last name on the petition and the affidavit, and then look at how the M is formed on the last name. From that's a completely different way of forming the M's.
I would object to any interjection from the attorneys at this time.
I don't think we need any more arguments, but we can just decide on our own.
The board is going through its decision process, and so with respect to the signature of Mr. Marsalis.
I would overrule. I'll make a motion to overrule and uphold the decision of the county clerk's employee.
Candidate Kelly has made a motion to overrule the objection to the signature of Mr. Marsalis and accept the determination of the county clerk. Is there a second to that motion?
Second.
Judge Bertucci has seconded the motion. Roll call, please. Candidate Coleman, or Member Coleman.
Aye for overruling. I'll note that the case on the petition sheet and the registration sheet are the same. The case is a little different on the affidavit, but looking at both petition sheet and the registration signature, I see the same case.
Candidate Bertucci, or excuse me, Member Bertucci. I'm elevating you all.
I don't think that's an elevation.
20 elections. I'm done running. Count Grammar School, high school, college, law school, and the big one. I vote aye to overrule the objection.
And Member Kelly.
Aye.
Let the record show that the objection to the signature of Kenneth Marsalis, sheet 13, line 6, has been overruled and the determination of the county clerk has been accepted. The next.
May I just say one thing? And I know we all want to move on.
Sure.
We've been here a long time, but if there's something, I would say that in fairness, if there's something either attorney thinks we're missing and they want to quickly tell us something, I personally wouldn't object. That's all. But I think we've given a fair hearing to everyone, witness and lawyers and so on. But if there's something you think, I personally wouldn't be opposed.
Okay. It's like throwing the good bait to the fish, right? You
I
can't ask an
know,
attorney
I
to
know.
talk and they're gonna talk.
You saw it at your own risk.
I took 30 seconds.
So, okay. The next objection is sheet 16, line 2. That is Andrew Robinson. There's an affidavit signed by Mr. Robinson. That's candidate exhibit 25.
You see?
Sheet 16.
16-2.
Oh.
What? 19?
No, he was born in 1993.
38?
20.
So you don't know when to register for this.
28 years old. You know, I would note as a person that appears to have signed the registration card with his name quite legible. It's in, it's not in print, it's you know, it's in the form of a signature, but is clearer than what's on, is signed, purportedly signed on the petition sheet and the affidavit. But in that regard, I would just note, we all have different signatures, and sometimes we may sign a credit card receipt real quickly. Maybe sometimes we'll initial things. And other times, if we want to make it clear how our name is spelled, we may sign our name, maybe similar to you may print it. And so I'm not too concerned about the fact that the registration signature is quite legible, even though it's in writing, you know, it's not printed. But the signature card does appear to be different than the signature on the petition and the signature in the affidavit. But the signature on the affidavit and the signature on the petition appear to be quite similar. So while noting that difference on the signature card, I don't find that to be to cause me to sustain the objection. So I would move to accept that signature of this person that purportedly signed a petition and then signed an affidavit saying he did.
See, Judge Bertucci has made a motion to overrule the objection and accept the determination of the county clerk as to its validity. Is there a second?
I will second based on the affidavit.
Roll call. Member Coleman.
Well, yeah, this one's a little difficult because, you know, the signature on the petition and the signature on the affidavit are the same. The signature on the registrations is not. I don't think it's even close. That's what's troubling me. I mean, there is a, you know, I'm looking for, you know, rights and
Could be a false affidavit.
yeah, I know. I just, that's the thing that's troubling me. I mean, two of them are the same, but the one on the registration card is a lot different.
He might have been 18 years old and wanted his name legible.
Yeah, I'm not sure how much a signature, I'm not an expert, but I don't know how much a signature changes, you know.
All I was saying is it may not be a change as much as it is someone sometimes may want it, you know, legible, and they make that their signature for that occasion. That's all I'm saying.
No,
And sometimes people
I know, I
just use
understand.
initials.
I understand. It's just that one's like,
But yeah, I appreciate your concern.
I appreciate your concern and, you know, without the affidavit, I would have to say it's two different signatures. I'm gonna sustain this one
I'm sorry,
You
what?
said
gonna
without the affidavit,
without the affidavit.
but there is one.
I know there is,
Oh,
but,
gotcha. Okay. I just want to make sure we're on the same page.
no, I'm
sorry.
saying, yes, this one, I'm gonna sustain. So I vote sustain it.
Sustain. All right, so
He votes to.
I vote
Bertucci.
to overrule the objection along with Kelly.
Member Kelly?
I'm going to vote to overrule based upon his submitting the affidavit to the notary public.
Let the record show that the board by a vote of 2-1, Member Coleman determining she would sustain the objection. The board by a vote of 2-1 has voted to overrule the objection to the signature of Andrew Robinson on sheet 16, line 2, and accept the determination of the county clerk with respect to this. The next objection is to Yadira Verduzco, the signature of Yadira Verduzco. That's on sheet 18, line 4. There is no affidavit with respect to that signature.
Well, I have to say, I probably shouldn't comment, but the signatures on 3 and 4 look very familiar. The signatures on line 3 and 4 look very similar.
In this instance, I would sustain the objection. I'm not buying that as a match with the signature clip taken from the permanent voters registration record. The letters J and V, there's just the letter A and D, there's just too much dissimilarity. I don't think that's a genuine signature signed by a voter in their own proper person.
So there is a motion by Member Kelly to sustain the objection to the signature of Yadira Verduzco on sheet 18, line 4. Is there a second?
I'll second that.
Second to the motion by,
And I'll
Member-
note that I don't think the signatures match, and I'll also note that one of my reasons is that 3 and 4, if you look at the signatures and you look at the printed,
Could be the same
they
person.
could be the same person.
Yeah.
That's what it appears to be.
Yeah, it's
Okay,
too
so-
similar for me to say that it's a genuine.
there is a motion by Member Kelly, a second by Member Coleman to sustain the objection to the signature of Yadira Verduzco on sheet 18, line 4. Roll call. Member Bertucci.
I vote aye to sustain the objection.
Member Kelly
I vote aye to sustain the objection.
and Member Coleman.
I vote aye to sustain the objection.
Let the record show that the board has voted to sustain the objection to the signature of Yadira Verduzco at sheet 18, line 4. The next signature is on sheet 18, line 7, Scott Gardner. There is an affidavit by Scott Gardner. And that is candidate exhibit 31.
I would note that the signature from the affidavit to either the clips used or the signature on the sheet bear no resemblance to me.
Um, I've got two Scott Gardner affidavits, and I'm trying to see which one is the fit here. We've got Exhibit 31 candidate and Exhibit 32 candidate. And
It looks like candidate's exhibit 32
yeah,
matches the signature for line 8 closer. You know, he signed it wrong. He printed first and then he signed it, which is opposite.
and then why? So was this one sustained as a
This was
duplicate
father and son.
signature?
Yeah.
Well, there's a third Scott Gardner up the page, isn't there? Or no, is that George above?
There's a Scott Gardner on 7 and a Scott Gardner on 8.
There's a Kathy Gardner
I
above
think there
that.
was.
Yeah, and there's somebody on line 2, another member of the family, but I think
This
that's
is
a
on-
George.
This is candidate 30, exhibit 31, and this is sheet 18, line 7. So
Yeah.
that's what you're looking at.
I'm just mixed up if they transposed or,
Well, if you look at here,
yeah.
exhibit 32, that looks like the one that's on 8.
Okay, but that's not the one that's in play here, so
No, I can't second.
can't make much of any of that. I think I have to sustain this objection. I can't make line 7 out to match either of these really. On line 7 of sheet 18, the purported signature of Scott Gardner. The affidavit signature doesn't help me either.
Who's the Gardner on line 2?
Is that a Gardner or somebody else?
Is it George or something, or what is that?
Maybe that's not a Gardner. It does seem to be Gardner to me, but
The last name,
in
yeah.
the print. But take a look at the signature on line 2 and take a look at the signature on the affidavit, exhibit 31.
Yeah, that one I could buy.
Isn't that something?
Yeah.
It's Scott, well, it says 18 line 2 is Scott Gardner.
Well,
And then down below, it's Scott Gardner and Scott Gardner.
well, no, the affidavit, exhibit 31 says 18-7.
No, but I'm looking at the sheets. If you look at these sheets,
Oh, right.
there's Scott Gardner, Scott Gardner, Scott Gardner.
The clip for those, I know what you're pointing to now. The clip on 18.2, 18.7, and 18.8
Are all Scott Gardners.
are all the same. The address for the individual is the same in all three, 18.2, 18.7, and 18.
In
Is this the
testimony,
one
there's
where
a father and
father
son. Yeah.
Yes.
Yes.
There's a father and son and a son.
Yeah.
So
But in any event, we have an affidavit for line
And they're all the same
18-7.
signature. I think I have to agree. It really, I'm not getting it, but it's the same. I would,
Anything we're missing?
No,
I could ask the attorneys on this one. I mean, it's all over the place.
I have what I have.
I'd second the motion to sustain it, to sustain the objection
okay, so there is a
for line 7.
motion by member Kelly
Yes.
Oh, I'm sorry, your second name, Judy?
Yeah.
Okay.
Second by member Coleman to sustain the objection to the signature of Scott Gardner on sheet 8, line 7.
Sheet 18.
I'm sorry,
Sheet 18.
excuse me, sheet 18, line 7. I apologize. And I can't read my own writing.
That's what I'm here for.
Member Bertucci,
I vote aye to sustain the objection to the signature.
member Kelly,
I vote aye to sustain the objection to the signature.
and member Coleman.
I vote aye to sustain.
Let the record show that the objection to the signature on line 18, on sheet 18, line 7, the signature of Scott Gardner has been sustained, or yes, has been sustained in the determination of the county clerk. Has been overruled. Next one is sheet 20, line 1. And that is to the signature of Barry Ward. And there is an affidavit, it's candidate exhibit 34. And yes, candidate exhibit 34.
I would make the motion to overrule the objection. The Bs look the same to me. And just it's funny signature. I mean, they're a little different in each one, but it's sort of the same. I don't know how to explain it.
Motion by member Coleman to overrule the objection to the signature on line 20, or sheet 20, line 1, signature of Barry Ward. Is there a second to that motion?
I'll second.
Second by member Bertucci. Roll call, member Kelly.
I vote aye.
Member Coleman
Aye.
and member Bertucci.
I vote aye.
Let the record show that the board has voted to overrule the objection to the signature of Barry Ward on sheet 20, line 1, and accept the determination of the county clerk as to its validity. The last one is sheet 20, line 4, and that is to the signature of Arna Ward.
I would point out that the printing for Aaron Ward and Anna Ward are almost identical, and the distinctive right-leaning A in both the clip and the affidavit don't match the upright large A, and the W on the petition stands straight up, unlike the affidavit or the clip from the clerk's office.
For the record, there is an affidavit. It is candidate exhibit 36.
Right.
Yeah, I would note that at least the line 3 and 4, the printed name it looks like it was done by the same person. It looks like it was printed by the same person. The registration, the signature on the registration seems to match the affidavit, but I don't know if the signature on the petition matches the affidavit and the registration on line 4.
And you have the information on when the card was signed and so on.
Oh, let's see.
Person was born in 72, but
What is it, sheet 20?
Sheet 20, what line is it?
4.
She was born in 1972. It doesn't give me the date for this one. So she's 49? 49.
So the affidavit signature appears to be very similar in my mind to the signature card. Signature on the petition seems a bit different. But, I don't know the circumstances under which it's signed, quickly, in the cold, or, we don't know. But that's the evidence before us.
Oh, if you look at 3, look at the big loop on, that seems to be these two.
Is you're not talking about the loop on 3.
Yeah, I'm talking about the loop on 3 and the loop on 4 are
They both have loops.
pretty much similar. And the printed signatures are pretty much similar
The
too.
printed are, there's no requirement that the person signing has to print the name themselves.
No, but
That could be done, perhaps a circulator will say, I'm gonna print your name, what is it? I could do that for you, that's okay. But, there's a clear W in line 4 ward and not a clear W on line 3 ward. So I wouldn't say the last names were the same person, but, we're necessarily signed by the same person just because of the loops, because there's no W in the one above. I would vote to overrule the objection.
I would point out that when things get mom and popped, the first signature is the one that adheres closest to the actual signature of the registered voter, and then the second one is an affected attempt to sign as the other person, and that's what would cause the difference in the A and the difference in the W that we see. And again, it's the 3-point test. You look at the affidavit and you look at the clip, and those two can match all day long. But if they don't resemble the signature on the petition, then it's a bad signature.
I didn't hear any testimony about mom and pop. I mean, that could be your argument, Mr. Erdman, and I'm welcome to give you the instructions to join the correspondence course. But there's been no testimony about mom and pop.
I was responding to the question of the chair about the similarities between the two lines. That's where it was brought up.
The board is capable of making its own determination. Was there a motion by?
I do a motion to sustain the objection.
I made a motion.
I'm sorry, you made the motion. Okay, I'm sorry.
To overrule the objection.
Okay, I'm sorry.
Is there a second on the motion to overrule the objection?
I have second to overrule. It's not perfect, but I think the fit is close enough.
And there's a sworn affidavit.
Yeah.
On the motion to overrule the objection, Member Kelly,
Aye.
Member Coleman,
No, I mean, we talked about slants before, and the slants and the W's are just no.
and Member Bertucci.
I vote aye to overrule the objection.
Let the record show that the board has voted 2-1 to overrule the objection to the signature of Arnold Ward on sheet 20, line 4, and accept the determination of the county clerk. That is the last objection.
How many did we sustain?
Okay, you sustained,
I think 3.
you sustained the objection to sheet 18, line 4, Yadira Verduzco, and you sustained the objection to sheet 18, line 7. So you sustained.
We only sustained 2?
Pardon?
We only sustained 2?
I'm sorry, what?
We only sustained 2?
You sustained 2, yes, and you overruled the balance.
Okay, so
Let's
that
see.
would give him 128.
128, that's what I counted, yeah.
Gives him
128.
128, which
There-
is 2 over.
There's one signature that was left over, which is 17-6, which
Yes, I
was,
gonna get to
okay,
that.
I apologize.
No, I just wanted to make, there was one signature. That was the, excuse me, the signature on candidate Exhibit 30, Rosalia Sierra, on sheet 17, line 6, which Judge Bertucci brought to our attention earlier, and which was also a signature that was the subject of objector exhibit number 9.
Okay, I would make a motion to overrule the objection, but with an asterisk that it's not going to go into our count for signatures because of our prior ruling.
So there is a
We overrule the objection, our motion is to overrule the objection, but noting that we also voted to take her signature off because of a legal question concerning signing another person's petition.
So it doesn't go into our count for valid
Correct.
signatures.
So it's a motion to overrule the objection to the validity of that signature, but it will not go into the count because it was taken off as part of your prior decision on the 12 affidavits submitted by the objector concerning signing 2 petitions.
Correct.
So there is a motion to overrule the objection to the validity of the signature of Rosalia Rosera on sheet 17, line 6. Is there a second to that motion?
Yes.
There's a motion by Member Kelly, or excuse me, Member Coleman, second by Member Kelly. Roll call, Member Bertucci?
Aye.
Member Coleman?
Aye.
And Member Kelly.
Aye.
Let the record show that the board has voted to overrule the objection to the validity of the signature of Rosalia Sierra on sheet 17, line 6. The board has noted that that will not go into the count at this point in time because that signature was removed pursuant to its determination with respect to objector exhibits 1 through 12. Okay, so 142 minus 30 minus 2. The final count at this point in time is that 128 of the signatures on the nominating petitions of Domingo Vargas have been determined by this board based upon the evidence to be valid, minimum number of signatures required, 126. So the determination of the validity, a determination at this point in time is that there are sufficient signatures remaining on the nomination papers of Mr. Domingo Vargas. Proceed with respect to the election. Members of the board, I will prepare a decision today. I know, Member Coleman, you're not available on Tuesday or Wednesday. Would you be available by Zoom on either of those days?
I would be available on Tuesday. Wednesday I could be available. I'm getting my second shot and I understand that you might have symptoms on the next day. So Wednesday I'll be home. I could do Zoom.
The reason I ask is because I have a commitment Monday, which I've moved from today to Monday. I could probably prepare the petition over the weekend, but for us to get everything together, or excuse me, prepare the decision over the weekend, for us to get everything together by then may be difficult. Are you available, Mr. Erdman, are you available on Tuesday or Wednesday?
If we do by Zoom, I'm available on Wednesday.
Yeah,
Anytime
Zoom
on
should be
Wednesday.
fine, right?
Yeah.
Zoom should be fine.
Zoom could be fine on that.
Okay.
If we could Zoom at 9 o'clock, we could do it Monday if I can get everything together. As we did the last time.
That should be fine.
I'm back to my doctor to remove staples from my elbow at 10.
Oh,
So
okay.
if it's gonna move quickly, I could commit to 9.
Well, if you've got a doctor's appointment, I don't want to.
I mean, it's not that far away. If we're done by 9:30,
Oh, God, last time it took, 10
5 minutes, yeah.
Yeah.
I mean,
That's what I'm assuming.
Monday I'm available anytime also.
Dan?
All right, Monday you're available?
Yes.
Monday, if we go at 9 o'clock sharp, because I have a 9:30 appointment on Monday, but if we go at 9.
9
zip,
sharp,
zip.
it will just be to do what we did the last time,
Yeah.
very quickly. Same call-in information.
Fine with me.
Forward it to us.
Yep.
It works.
Please.
Again.
Is the board gonna make a motion tonight with regard? Is the board gonna make a motion tonight with regard to the objection being overruled?
Why can't we get a retired pharmacist to be the handwriting?
The objection being overruled.
The pharmacist has
Okay.
to read the doctor's
Thank you.
signatures. They know more about
No, I've
handwriting.
been doing this for so long, I feel like it's.
With respect to, before we conclude this proceeding, can there be a motion made by the board tonight that the objection to the nomination nomination papers of Domingo Vargas in case number 2020 PIMOEB-02 be overruled?
Yeah, I'll make a motion that the objector's petition is overruled as testified to in open court, as will be prepared in a written decision. In open court, and it will, and as set forth in the written decision to be prepared by the board's attorney.
Is there a second to that motion?
Yes.
Motion by member Coleman, second by member Kelly. Roll call, member Bertucci. Aye. Member Kelly.
Aye.
Member Coleman.
Aye.
The board has voted by a roll call of 3-0 to overrule the decision of, or the objection of the petitioner Solomon Esparza and Octavio Carvajal to the nomination papers of Domingo F. Vargas based upon the testimony and evidence presented throughout the course of this hearing today. The written decision will be prepared for the board's consideration Monday morning at 9 o'clock. It will be by Zoom, with the call-in information being the same as it was on the agenda for today's hearing. Can we make a motion to recess until Monday morning at 9 o'clock for purposes of the decision?
So moved.
Motion by member Bertucci, second by member
Second,
Kelly.
yes.
That's February 22nd.
February 22nd. Roll call. Member Bertucci.
Aye.
Member Kelly.
Aye.
Member Coleman.
Aye.
Thank
all
you.
very
Good night,
much.
everyone. Have a good
Council,
weekend.
Thank you very much.
Did you get it?